Good morning. I'm convening today's hearing of the Labor and Public Employees Committee. The time is now 11:13. Before we begin, I'd like to advise everyone the fire exits in the room, especially with so many firefighters here. We have two in the back and then one here. In case of fire, please calmly walk the exit, follow Capitol Police instructions and exit the building in an orderly manner. In case of a lockdown event, the doors to the hearing room will lock automatically. Please stay seated until such a time as the Capitol Police clear the lockdown event. At this time, I'd like to move on to item 2 of the agenda. So this would be the time when I'd ask if my co-chair or ranking members have anything to say.
Just looking forward to a great day with public testimony and anxious to hear from all you, and good to see you all in the room. Thank you.
Senator. So at this time, we will call on participants in the public testimony. We have Senator May Flexer.
Thank you, Representative. Good morning, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Weir, and other distinguished members of the Labor and Public Employees Committee. Thank you for the opportunity to testify this morning in support of Senate Bill 1035, an act concerning limitations on the use of non-disclosure agreements. With the chair's indulgence, I'm joined this morning by my colleague, Representative Blumenthal, who has also introduced this bill with me for a number of years. And I want to thank the committee for raising this bill and having a public hearing today, having this important discussion to limit the use of NDAs. Several other states in our country have taken the bold step of limiting the access to silence victims of workplace discrimination and harassment. In states like New Jersey, California, and Washington, they've passed strong laws to limit the use of NDAs so that we can ensure that our state policies remove bad actors from our workplaces so that we can empower people who suffer from harassment, from various forms of workplace discrimination, to step forward and not be silenced, but instead be empowered to tell the truth about what they're experiencing and make sure the person who's engaging in that kind of behavior is held accountable, and those people can be removed from our workplaces so we can create a healthier culture in workplaces all across our state. I don't want to take up too much of the committee's time this morning, so with that, I will share my time with the chair's permission with Representative Blumenthal.
May proceed. Thank you.
Thank you, Mr. Chair, and thank you, Senator Flexer, for that great introduction to the bill. We appreciate the chair's rankings and vice chair's indulgence today, and it's great to see you all in the committee room. I'm sorry not to be there in person. But I wanted to echo Senator Flexer's statements about this bill. Toxic workplaces and abusers in those workplaces rely on silence to persist. And we've seen through many of the biggest scandals related to toxic workplaces and abuse in the workplaces that the strategic use of NDAs is a weapon for abusers. Even when it is not a purposeful vehicle to silence accusers and maintain a toxic workplace, often it prevents survivors and victims of those toxic workplaces from having the number one defense mechanism and weapon that they have to fight back, which is their voices. And we as public officials, people across the spectrum, potential employees of that company or in that environment, deserve to know the truth about those environments when toxic workplaces and abusive workplaces and abusers exist in those workplaces. The public is with us on this principle. A recent poll noted that 76% of Connecticut voters support banning NDAs for workplace abuse, harassment, and discrimination. 68% oppose companies using NDAs to silence workers who witness or experience toxicity. This is a bipartisan majority. There are a number of states that have passed broad legislation, like the state of Washington. This bill is based on Washington's bill. These bills have been in existence for several years now, and businesses have learned to work with them, employees have learned to work with them, and they've improved transparency in the workplace. And I thank the chairs, the rankings, and the vice chairs, and all the members of this illustrious committee for permitting me to testify.
Thank you, Senator and Representative. Any questions of the committee? Senator Sampson.
Thank you very much, Mr. Chairman. Good morning. And nice to see my GAE colleagues on the screen today. We've had this bill kicking around for the last several years, of course, and I know that you guys are, big advocates for it. I just want to respond to the kind of the rhetoric that's been used by both of you, in fact, suggesting that we don't want people to be silenced. Obviously, I'm sympathetic to the argument. I don't want to see anyone have to work in a toxic workplace or, abusers getting away with their crimes. But isn't an NDA something that is signed by the employee voluntarily and often in exchange for a settlement figure? Through you, Mr. Chairman.
Thank you, Mr. Chair. Through you, thank you, Senator, for the question. And I actually think your question gives us an opportunity to make a really important point. So I think a lot of people think that NDAs just come into place when there is a situation of discrimination or abuse or harassment. But in fact, as many as 1/3 of all workers in our country sign non-disclosure agreements upon being hired or on their first day on the job. So when they're offered, it's often part of an offer package or part of the paperwork that you fill out on the first day. So oftentimes, people are not aware the extent to which the non-disclosure agreement that they're subject to extends to other things. Now, one might think it's normal, and this bill does not limit in any way, shape, or form the right of an employer to limit disclosure of proprietary information, things that are particular to that place of business, that particular industry, that particular position. But people don't realize that when they're signing an NDA, it also covers these other types of behavior like discrimination, like harassment, like workplace abuse. So there's actually a broad use of NDAs, and they're often signed well before any particular incident happens.
And with the chair's indulgence, I would first of all just second everything that Senator Flexer has said and thank the distinguished ranking member for the question. I would also say that even when there is a potential for litigation, often NDAs that are signed post arising of dispute happen before any litigation has happened, before the employee is represented by counsel. And in that situation, there can be a vast differential in power between the employer and the employee, a vast difference in sophistication and knowledge. On behalf of the employee, they may be in a very weak bargaining position and may not understand what rights they're signing away. Even when the individual is represented, there have been situations that have been documented in some of the toxic workplace situations that came out in the past 5 or 10 years, where first of all, there was the strategic use of kind of insider lawyers who would be provided to the employee and would not be giving perhaps the best advice to the employee. Even if the employee has a lawyer who is independent, that lawyer may not be prioritizing the person's voice over their financial settlement. And I think it's very difficult for the employee to understand the true value of giving up their voice. Putting even all that aside, we're not even, that transaction between the employee and the employer, even if it happens in a fair, knowing, informed manner, does not consider all the other potential employees who could be affected by future misconduct if the past misconduct is kept under wraps. Thank you, Mr. Chair.
Thank you, Representative. Senator Sampson.
Thank you, Mr. Chairman. I appreciate those answers. And I guess what I learned from the conversation so far is that we have two separate situations which we should talk about separately. One of them is the notion of having someone sign an NDA agreement upon the beginning of their employment. And that's certainly a separate concept from the idea of someone signing an NDA as a result of some agreement based on, a conduct during their employment. And I appreciate the arguments that you guys made on both of those issues. Although, I mean, it sounds to me like you're suggesting that the reason why the employee should not be allowed the opportunity to choose to sign an NDA is because they don't have the same power as the employer. And I forget what the other reason was. But let's take these one at a time. Let's start with the idea of, lost my sound for a second, but it's back. Let's take the idea of someone that has been involved in some terrible situation, abuse or, harassment on the job, and they negotiate terms with the employer for a certain dollar amount in exchange for signing an NDA. Aside from all of the other concerns that were mentioned about the potential danger to other employees and so forth, let's take that out of the equation, because I don't know if that's going to happen in every case. But doesn't this employee deserve the right to be able to enter into a private contract of their own free will to exchange for money their silence, if that is what they choose? Through you, Mr. Chairman.
Senator Representative.
Thank you, Mr. Chair. I think that question gets to much of the crux of this proposal. The reason, so a person could still enter into a settlement agreement if they were subject to workplace discrimination, but they don't have to be silenced in the process. In many of both the high profile cases that we've seen in recent years and some of the less high profile cases we've seen in recent years, the core behavior is often perpetuated over and over and over again by the same actor. And so I would argue that one of the main reasons to disallow NDAs for silencing victims of discrimination is to root out these perpetrators. Because what happens is these settlements are entered into, there is sometimes money exchanged, and that perpetrator continues the abuse to other people, either in that same workplace or goes on to other workplaces and commits that same kind of behavior. And so what we're not doing here is limiting the settlement, the ability of someone to negotiate something because of the behavior they've had to endure. But what we are saying is that silence cannot be a component of that. You cannot take away someone's voice literally for the rest of their life in exchange for acknowledging and settling about the behavior that's occurred.
And if I could just add on to what Senator Flexer said, I think we're not averse to a situation where an employee doesn't want to talk about it and may agree themselves in a non-legally binding manner not to talk about it, and the employer is bound not to talk about it. A one-way NDA where that binds the employer and the employee wants to go on with their life. That was part of a previous version of this bill in the past. We don't want to force people to talk about these things. That being said, what we're against is the employer compelling the silence of the employee or the former employee. And, I think we're only now discovering the true extent to which these agreements can silence individuals, both in the sense of, their future employment prospects, for instance. So, if they are silenced about this misconduct, they may not be able to talk about why they left their last job. And that may be a black mark on their employment going forward. And, often the situations that we hear about with NDAs and toxic workplaces involve powerful employees relatively. People like Gretchen Carlson or Hollywood actors and actresses or other people who have, relative to the average employee, significant sophistication, resources, and power. The vast majority of NDAs in the workplace are signed by people who are fast food workers or hotel workers. They have no idea how to understand all the legal, all the legal implications, especially if they're unrepresented. And they may not be significantly advised. They may not be getting a settlement that would justify, such a black mark on their record or a problem for them in the future. And so as a general matter, we think these NDAs silence people. They deprive other employees of the ability to know what they're getting into, or to know who to avoid, or to know how to protect themselves against toxic people in the workplace. They also just silence people forever. They can't talk to their spouse or their psychiatrist or their future employers about these problems, and it could have a devastating impact on their career or their life going forward.
Senator Sampson.
Thank you, Mr. Chairman. Yeah, with respect to you guys, you keep using language that I don't think is accurate. I mean, you've said over and over again that this is the employer silencing the employee, that they're taking away their right to speak, that they are being forced into silence. And this is the part that I object to, which is that, you're using this language as if somehow the employee is being deprived of their freedom, when in fact the bill that's before us deprives the employee of their freedom. The employee is currently free to engage in a negotiation to be compensated for their silence if they choose. If I go ahead and I put duct tape over my mouth, am I being forced to be silent? No, I'm choosing that. And that's the situation here. You mentioned Gretchen Carlson. I think that's an interesting example because, the other thing that you've said is that people don't know, they're in a weaker position, they're unrepresented. I would imagine somebody like Gretchen Carlson had an agent and somebody reviewing her contract when she signed it. So I just, the thing for me is I don't really understand why the language is all about this force issue when we're talking about a free choice. And that free choice applies to that person if it's after an incident. I would also point out, and maybe you can clarify this for me, does this bill just deal with someone that sexual abuse or something like that? Or or harassment? Could it be something completely different? Could it be just somebody, stole funds from the company and they didn't want that person to, share that information? There's so many assumptions in the rhetoric that is accompanying your testimony. And I mean, no disrespect, you're advocating for the bill, but I think it's not fair to suggest that someone's freedom is being taken away because they have free choice currently to engage in one of these contracts. Let me just ask another question, which is about the retroactive nature of this. I'm just looking at the staff attorney's breakdown of the bill. I didn't actually read the language myself, but maybe you can clarify for me whether this bill actually would, in Connecticut, if this law is passed, eliminate any pre-existing NDA agreements that have been signed willingly by both parties through you.
Senator Flexer, Representative Blumenthal.
Thank you. I will get to the retroactivity portion of it in a minute, and Representative Blumenthal will add to it. But I do just want to be very clear about why we're using this language. So the current practice does in fact silence people. The current practice, again, as I mentioned earlier, as many as 1/3 of all workers in this country sign NDAs at the start of their employment. So they are in fact silenced before they even experience any workplace discrimination or abuse. And this bill is limited to only experiences of workplace discrimination. So it does cover if you are someone who suffers from sexual harassment in the workplace, if you are discriminated against because of your race, because of your age, because of your sexual orientation, your gender identity, your status in terms of disability. There are many ways that people are discriminated in the workplace. And again, most workers don't realize that up to 1/3 of them sign away their right to talk about any discrimination that they experience when they commence employment. And so the leverage in these agreements is silence, versus a settlement with our current laws. In the state of Washington, where they have the strong law that we're advocating that we replicate here in Connecticut, that power dynamic is shifted. And so that the commitment of silence is removed from the equation. And so we use that rhetoric not because it is some sort of dramatic tactic, but because that is in fact what is happening. You cannot get a settlement if you do not pledge silence in most of these situations. And so that's the dynamic that we're trying to eliminate. People can negotiate a settlement with different terms, but not demand that someone has to lose their ability to speak about their own personal experience and what they've had to endure in terms of racial discrimination, discrimination because they have a disability, or their experience with sexual harassment for the rest of their life, just to end that abuse and settle in these particular situations. Representative Blumenthal, if you want to speak to the retroactivity portion.
Sure. Thanks, Senator. So the bill is retroactive to non-disclosure agreements that are entered into before a dispute arises only. So if there was some sort of allegation of wrongdoing or litigation, and then an NDA is part of a settlement agreement, this bill would not affect those retroactively. It's only the pre-dispute NDAs, most typically the ones that are entered into at the outset of employment, that would be affected retroactively.
Senator Sampson.
Thank you, Mr. Chairman. I appreciate that answer, and I appreciate the clarification, Representative. I'll just ask a final question, since we keep going back and forth on this force issue and so forth. If an employee was in fact forced to sign an NDA through some sort of threat of violence or you name it, would that be against the law through you, Mr. Chairman?
Senator. Representative.
Sure. So I guess I'll take this one.
All right, go ahead.
Such an agreement would generally be void for unconscionability or being against public policy. If there were a threat of physical violence, certainly. That being said, even in that situation, the employee would have to go to court and pay a lawyer to avoid it. They may, first of all, be not in a position to do that, or not be of sophistication to realize they can do that. Even the process itself could be a punishment. But I guess the distinction between our different perspectives on this issue kind of comes down, I think, to I guess a distinction I'll try to articulate now, which is that I think this bill would not prevent an employee from bargaining for the issue to be over and for them not to talk anymore. We're not saying they can't sign an agreement. We're not saying that they can't be silent. What this bill would say is the employer can't have the employee sign the agreement, or most importantly, and I think this is the key distinction, sue or move to compel it. And that's, I think, the issue of silencing that is most relevant here. It's not necessarily, you may be free to sign an agreement, but then if you ever talk about this issue again, you may face a lawsuit for millions of dollars of damages, and that could just totally devastate your life. And so, that's the distinction I think we're getting at here. Of course, people are free to sign a document and potentially enter into an agreement, but those agreements have implications that involve state power being brought to bear to impose potentially ruinous damages on people for just talking about their experience of being discriminated against or abused or harassed.
Senator Sampson.
Thank you very much, Mr. Chairman. Again, I appreciate the response. I'm a little confused by a couple things. You said if they're sued or moved to compel the signing a document, and then you finished your remarks by saying, of course, people are free to sign, and that's kind of my argument with you, is that right now people are free to sign. They can make a intellectual choice on their own. Do I want this job? It comes with signing this non-disclosure agreement. Am I being compensated fairly? If I don't think so, then I'm not taking the job. Or I'm going to tell the employer that I'll take the job if I don't have to sign the agreement. But it's up to the person. I mean, there's no gun to their head. There's no force there. They're having to make a decision on their own, a free choice. And, in the secondary case where something actually does occur, again, it's the employee either has the choice to go to the authorities or to pursue whatever avenue they want, or they can sign an NDA in exchange for a payment. And again, I mean, some folks might think that that's bad because it's going to, not necessarily solve the problem at that business. And I don't disagree with that. I think that's a potential that could happen. But I also believe that it's the right of that employee to make the decision for themselves. It's like, well, what do I want to do because I was harassed at work? Do I want to go to the police? Do I want to file a lawsuit? How do I want to go through this? Or do I want to just take a check in exchange for my silence? And a lot of people choose to do that. And the fact that people choose to do that, I think, is an indication that that's a decision people would freely make. And it's been a frustrating conversation. I respect the two of you immensely. I just think it's very hard to suggest that when you're proposing a bill that is denying someone a activity that they can freely engage in today, that you're on the side of freedom. That is the side of force. That is the denying of a right that an employee would have. I don't have any more questions, Mr. Chairman. Thank you.
Thank you, Senator. Any other questions to the committee? Representative Weir.
Thank you, Mr. Chair, and thank you to the proponents for the information on this. I have both of you referenced, and I'm going to try to remember. I believe Representative Blumenthal referenced data coming from a poll or a survey in terms of percentages of, it was a bipartisan survey, percentages of people who felt that this type of an NDA was worthwhile. And also some statistics on fast food workers having to sign NDAs. Can you, Representative, are you able to provide the committee with the sources of those and maybe some backup data? It'd be very helpful for me to read that and kind of understand it in context through you, Mr. Chair.
Senator or Representative?
Through you, Mr. Chair, with regard to the data on the polling, that was in a Hartford Courant article that was published, I believe, today. And it's a Morning Consult poll, which I believe means that the underlying data should be publicly available. I'd be happy to send the article and the poll to the committee. And Senator Flexer may have the reference for the data that 1/3 of employees sign an NDA as a condition of employment.
Yeah, and we can get that to you.
Thank you for
We'll
that.
certainly send that along.
Yes, thank you for both of those would be helpful. I thought I heard Representative Blumenthal talk about fast food workers and the number of a certain percentage of fast food workers, and maybe I misheard. And through you, Mr. Chair, a couple more questions.
Yep.
Senator Flexer, I also I took notes here, just trying to keep up, but that you talked about some data, and maybe you didn't reference data, but you talked about repeat offenders, and I'm curious if there is any data or any reference that is there evidence that we have to the numbers where you talked about repeat offenders. Is there backup to that or something we can reference through you, Mr. Chair?
Senator, Representative?
Yeah, thank you. Thank you, Representative, for the question. So in my work in the legislature, I have had the opportunity to look at a number of different issues like domestic violence, like sexual assault, like sexual harassment, and this work on workplace discrimination. And a common thread through working on all of those issues and understanding what happens with perpetrators of those kinds of abuse is silence allows them to continue to find new victims. And so when people are not held to account at their first incident, whether it's an incident of domestic violence or the kinds of workplace discrimination we're talking about today, they are allowed to continue to perpetuate that behavior over and over and over again. And so I can get you a number of different studies that detail that these kinds of behaviors, particularly workplace discrimination that you're dealing with in this bill here today, they are the kind of behaviors that grow in the dark. And so when people don't know who these perpetrators are because they're allowed to move along with their lives, with their previous victims never coming to light, never talking about the behavior and the discrimination and the abuse they've had to endure, they are allowed to move from workplace to workplace to workplace. This legislature a number of years ago did some really great work to stand up for victims of this kind of workplace discrimination. And the young women who came to me talking about the managers who would just get shifted from one site to the next after inflicting their abuse on someone in their particular location, they would just get moved around from job to job to job, with never actually losing their job. And so that's the kind of thing we're trying to root out here, right? Is that these perpetrators know what they're doing. They know how to command their power, and they know how to use the structures of the system to perpetuate their behaviors and frankly get away with it. And so I would be happy to send the committee a lot of studies about how this kind of behavior endures, how these perpetrators are able to engage in this type of behavior over and over again, and why silence is one of their best weapons.
And if I could just add on to that, with the chair's indulgence, I appreciate the question. I don't believe I cited a figure on fast food workers in particular. I think the figure we talked about was generally about employees across the board, roughly 1/3 sign a non-disclosure agreement upon employment as a condition of employment. I guess my point was merely to say that a lot of these people are not sophisticated counterparties. A lot of them are in a severe power imbalance, whether it comes to economic power or sophistication. It's one thing to have a theoretical freedom to agree to something in a knowing manner. If you're a high-paid office worker or a lawyer or something like that who knows how to negotiate an agreement, who can afford to give up the job that's being offered. It's another if you have to support your family and you're trying to work at I don't want to name a specific restaurant, but a fast food restaurant or a coffee restaurant, working for minimum wage or just above minimum wage. In those cases, that choice is often illusory. And I will say that, lots of more sophisticated workers sign NDAs routinely as a condition of employment, simply because they don't really have a choice. I have myself signed an NDA as a condition of employment at the outset of employment in the past. Even though I knew it technically wasn't the best idea, that just gives you an idea of the power imbalance and how routinely these agreements are signed by employees just as a matter of course.
Representative Weir.
Thank you for both of that. I appreciate the opportunity to review data. What I want to make sure is that, Representative Blumenthal, in terms of talking about the fast food workers and some of the less sophisticated workers, I agree that there are various levels of, if I look at myself at age, earlier in my career, would I have recognized, because I have signed NDAs and also as an employer have requested employees to sign NDAs. It was never at the outset of employment, it was never to talk about a situation like this. As Senator Flexer pointed out, it was more to talk about trade secrets or important information that was to be protected in exchange for, coming aboard. So, but I want to make sure that we're looking at data. That's why I appreciate that. And then we're not making an assumption that because someone's a fast food worker, that they're not sophisticated and incapable of navigating through an agreement and negotiation like this. But I'll close my remarks with just a concern, and I look forward to future discussion on this topic, is that, you know, it was referenced more than once that, you know, some of the people who get involved in these situations may only have, may look at an NDA as the maybe a less expensive way to resolve this issue, where they may not have access to an attorney, may not have the funds to fund a legal battle. And so in turn, they look at the NDA as an opportunity to settle this with some compensation or exchange in return for not disclosing certain facts of the, you know, not disclosing certain facts or details. And I want to make sure that in considering a bill like this, by taking away that ability for the person to get be compensated in exchange for non-disclosure, if we take that away, we could be forcing them into litigation. That may be the only way that they're going to be compensated, you know. And I just want to make sure that we're not swinging this the other way, where the employer says the NDAs are off the table. Go ahead and sue me, you know, and knowing full well that the employee doesn't have the means to do so. So I just want to make that point, looking at this from another perspective. But that's just how I operate, is we should be looking at both sides. And if we take a position, I think we should be looking at the other position just as carefully, to make sure that we don't go 100 miles an hour in one direction and realize down the road that, you know, we may have left some people out or taken away the ability for somebody to defend themselves. And in this case, the NDA may be the path of least resistance for somebody who doesn't have the means to go down the road of a long legal battle. So thank you for your comments, and thank you for testifying, and I appreciate you listening to me.
Thank you, Representative Canino.
Thank you, Mr. Chair, and thank you both for coming to testify today. My colleagues litigated this pretty thoroughly, so I only have one question for you. Would anything in this legislation bar an employer from imposing confidentiality requirements on their human resources employees? You know, for example, if there's one of these disputes happen in a workplace and the HR professionals either worked on it or heard about it, and then you have an individual who maybe is the subject of that case and doesn't want that to get out among their colleagues or among other people. Yeah, would this bar any requirements for confidentiality from human resources professionals?
Senator, Representative.
That's a great question. I appreciate it, Representative, and thank you, Mr. Chair. No, it would not. This is about the people who are the victims, the recipient of workplace discrimination, not people who work in a professional setting to manage those situations like HR.
Thank you.
Anyone else? Senator Kushner.
I just want to thank both of you, not just for being here today, but for your attention to this issue and your advocacy on this issue. One of the things that maybe we can look at positively in this discussion is that we all seem to agree on one thing, that workplace abuse and harassment, sexual harassment and abuse is wrong, and that no one here condones that. I think how we go about making sure that it's not perpetuated is the key issue that you're bringing to us. And I think it happens way, way more often than people are aware of. I think it happens to many, many women, particularly in the workplace. And I think that, you know, I know it's happened to me at times in my lifetime. Certainly, I'm sure it's happened to most women. And we need to stop it. And so I think if we can look at this as a way to make sure that people are in a position to expose sexual harassment, and I don't mean to say it only happens to women, so don't distort my views on this, because I know that is not the case. And I know it's not just sexual harassment. I know there are other forms of discrimination. But it is so clear to me that we need to take steps as a government to do everything we can to stop this from happening in workplaces. So I truly appreciate you bringing the bill to us, and I know it will get due consideration from the committee. So thank you so much.
Thank you, Senator. Any further questions or comments? Seeing none, thank you both for your testimony today.
Thank you,
Good,
Mr.
Madam
Chair.
Chair.
Have a good day. Thank you very much.
Take care. Up next, we have Aaron Chiquette.
It's still good morning, so I can say good morning, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Weir, and distinguished members of the committee. I am Erin Choquette, the CEO of the Connecticut Paid Leave Authority. Thank you for giving me the opportunity to testify in Senate Bill 1427, an act expanding paid family and medical leave insurance program benefits to certain school employees. The Connecticut Paid Leave Authority administers the Connecticut Paid Leave Program, an employee-funded program that provides income replacement benefits to eligible workers who need to take a short time away from work to receive treatment for and recover from a serious illness, to care for a seriously ill family member, to bond with a newborn or newly placed child in their family, to address situations related to domestic violence, sexual assault, or situations related to a family member's service in the armed forces. Since 2022, Connecticut Paid Leave has provided over $1 billion in wage replacement benefits to more than 145,000 Connecticut workers. Connecticut Paid Leave applies to most employers with one or more employees in Connecticut, but not all. In particular for today, it is not available to employees of non-public elementary and secondary schools under any circumstances. Employees of local or regional boards of education are not covered under our program unless the unionized employees of that board collectively bargain to participate, in which case the non-union employees would be covered as well. We frequently hear from school employees that they wish they could participate in our program. Not an event goes by where we don't get that comment from someone walking by or someone on our social media. Senate Bill 1427 would enable non-certified employees of public and private schools to participate in Connecticut Paid Leave, thus ensuring that these workers have a financial safety net when they need to take time away to care for themselves or their families. While we support Senate Bill 1427's goal to expand Connecticut Paid Leave to cover these workers, we recommend that it be amended to ensure these workers also have access to job protection under the Connecticut Family and Medical Leave Act. The ability to receive income replacement benefits when you need to take a leave of absence can be critically important, but we don't want people to risk losing their jobs. Connecticut Paid Leave and Connecticut FMLA work together to provide that financial stability to workers when they need to take time away and to make sure that they have a job to return to when their need for leave is over. Thank you for your time this morning. I'd be happy to answer any questions you may have.
Thank you. Any questions or comments from the committee? Representative Weir.
Thank you, Aaron, for your testimony, and thank you for being here today. I heard some of the stats on the, how much you've paid out, and I think I'll reserve those for another time. But is this proposal, would this allow them to individually participate, or is this going to be, as an opt-in, or is this an opt-out forced type of arrangement where anyone fitting that description is automatically entered in through you, Mr. Chair?
Under this legislation, anyone who is a non-certified employee of a public or private school would be covered. So they come in like the 1.5 million Connecticut workers who are already covered under existing legislation. I will add that we do have language in the existing statute that allows for employers to work with their staff to opt for a private plan, which is an alternative compliance mechanism, but there is no opt-out.
Representative Weir.
Thank you. So that one, so they don't have the ability. It's forced in, and they don't have an opt-out. So they're automatically enrolled in this plan without an option other than, and I know how the language works with the existing plan, they're forced into the plan. That's unless they have a private plan that meets the criteria as designated by the Paid Leave Authority.
Correct.
Thank you.
Thank you, Representative. Senator Kushner.
Thank you. And I I always really enjoy the opportunity to publicly thank you for not just your advocacy here today and your testimony here today, but really amazing job, well done in establishing this program. I don't, the public should know that you were one of two of the leaders that stood up this program during COVID when no one thought we would be able to do it. You not only got the program going, but did an excellent job in administering it. And I would say of anything we've done since I've been here in the last 6 years, that I hear more positive feedback from constituents, it's always the paid family medical leave program. And I really want to say something that, really addresses this question about opting in or opting out. I haven't heard anybody say, I wish I could opt out. I've heard people say, I wish I could be in. And that is why we have expanded coverage last year. And again, this year, we're seeking to do that. I think opting out or opting in presents huge problems because of adverse selection. And it might be important for you to address that. I know the only time we allow somebody to opt in is the independent contractor who can opt in under our statute, but they have to stay in for at least 3 years. So they're not just getting in, taking advantage of the fund and then getting out again. So if you could just, briefly address the adverse selection issues that you would face if there was an opt-out or an opt-in.
Thank you so much for that question. And thank you for your comments and thank you for your leadership in this area. You are correct. This is an insurance program, right? So with an insurance program, you need to make sure that the risk pool is broad enough to ensure that the program has the funds to pay for the claims that are necessary. So we never lose sight of the fact that this is an insurance program. Having individuals be able to move in and out of the program, claim benefits, and then, walk away without paying their fair share into the trust fund is not the way insurance works, and it's not the way this program works. I would also add, it's not, not sure how to phrase this. People who do not have access to this program, people who did not have access to this program prior to 2022, utilized other state benefits. They utilized other state resources. They were receiving benefits from DSS. They were still needed assistance. They still needed to put food on the table. They still needed to pay the rent. They still need to pay for electricity bills. So the existence of the Connecticut Paid Leave Program essentially helps prevent people from getting to that crisis point, helps make sure that that the funds that are in those other programs can be utilized for people who have no other resources, and allows Connecticut workers to pool together to assist other Connecticut workers and themselves when time occurs. So it's important to protect the solvency of the fund by preventing that adverse selection, but it's also important to recognize we're saving the state fisc by the existence of this program. This is a worker-funded program. This comes directly as a 0.5% payroll deduction straight from workers' paychecks. Employers have not been required to participate, unlike in many other states. We do not get appropriations from the legislature. So this is a very economical and efficient way to make sure that that safety net exists. And so we do need to make sure it works by having a robust pool.
Through you, Mr. Chair. One other, thank you for that explanation, but also one other point I'd like to bring up, and I appreciate your bringing to our attention the need in this area to amend or to have substitute language in this case. And I think it's really important that people have job protection that goes with the benefit. We ensure that in the way we set up the original statute to include both payment of benefits, but also job protection to return to work. And it's critically important. So that's a good catch on your part. And we have already discussed it briefly with the Department of Labor, and we'll be working on substitute language on that, and we'll certainly want your input to make sure that we get it right. The other point I do want to make, though, is to draw your attention to the language of the exclusion. And you talked about including non-certified employees. I do want to point out the way the bill is structured is we are excluding certain school employees, which would be those that hold a professional license. I think we want to make sure there's a very bright line as to who's included or who isn't included, and non-certified employee may not capture that. So we figured the best way to describe it is that we're excluding those with professional licenses and certified employees. So just wanted to make sure that everyone's aware of that, because we're being careful, and we tried to be careful in making a bright line so that the authority would have an easy way of identifying who's in or who's out.
Thank you. I appreciate that.
Thank you.
Thank you, Senator. Any further? Representative Wilson.
Thank you. I just want to again, thank you, Aaron, for the work that you continue to do to educate individuals on what this program does. I think when we continue to work on, one of the big points you just mentioned around the most vulnerable individuals, and allowing those that don't need to be in that most vulnerable category, the opportunity to continue moving forward through an opportunity like this is amazing. And so I look forward to seeing what the authority does and what you continue to educate people. So thank you.
Thank you so much.
Seeing no other questions or comments, thank you
Thank
for
you
your
for your
testimony
time.
and time. Today, up next, we will have Peter Brown.
Good afternoon,
Good afternoon.
good chairs, ranking members, and all the distinguished members of the Labor Committee. My name is Peter Brown. I'm the President, Uniformed Professional Firefighters Association. We represent nearly 4,000 career firefighters across the state. I'm here in support of two bills today. The first is House Bill 5609. That bill provides critical protections to employees who may see their pension benefits, their lifetime pension benefits, significantly reduced just because they were injured at work. And I know others are going to speak on that later, but I did want to mention our support of that. Our main focus is Senate Bill 1426, which provides technical changes to the Cancer Relief Program. I want to mention that you see our firefighters are here today. To be clear, they're not here in support of me. They're here in support of Greg, Nelson, and their fellow Hartford firefighters who could not be here today because they're suffering through occupational cancer. So I just wanted to mention how critical this issue is. And this committee knows all too well how important this is. This committee helped drive lead the way to pass this bill 2 years ago. And I'm fortunate enough to meet firefighters from all over the country. And I could tell you that in speaking to them, our law provides one of the most comprehensive set of protections for firefighters with cancers anywhere else in the country. So thank you for that. We greatly appreciate it. I'm here today because over the last year and a half, as great as this law is, we've seen that, unfortunately, the vast majority of our cancer claims, over 30 at our latest count, have met significant roadblocks, and they're stuck kind of in procedural hurdles that we're not able to get through. So what this bill does, as we see it, it fixes a number of those issues. And my written testimony actually goes point by point on each one of these changes and how those changes will help the process. So I don't want to spend too much time on those. I want to focus specifically on one issue, which I personally think is the most important. And that's the one that provides workers' comp administrative law judges the affirmative authority to adjudicate disputed claims. As you know, in trying to get that level of benefit correct, we attempted to mirror and parallel workers' compensation because we believe that provided the highest level of benefits for our firefighters with cancers. And especially that this is a workplace illness, we felt that was a critical thing to do. So when a dispute arises in workers' compensation, it goes through an administrative law judge who is able to make a ruling on those cases. When we have had our cases have disputes and actually receive denials, the vast majority of them receive denials, We've attempted to utilize that same system to solve the problem. What's happened in a number of those hearings is we've gone in front of an administrative law judge. They've heard the case. They've reviewed the facts. They've actually said on the record, we understand the issue. We agree with you that the firefighters should be eligible to receive these benefits, but we don't believe we have the statutory authority to make that decision and force a municipal employer or state employer to provide the benefits to those firefighters. So in section 1F, we adding the language that gives them the authority and actually mentioning in 31-278 where they do receive their statutory authority, referencing R7313P cancer cases. We think that will solve that problem. And although I think we probably all agree that none of these cases should be disputed if they meet the simple criteria of being eligible, if there is a dispute, now a firefighter can go in front of the workers' comp judge. They can receive a fair and expedited hearing process and hopefully solve the problem. So, as I said, we strongly support these efforts. All of these changes, I think, will help smooth along the claims and get our firefighters access to these benefits as quickly as possible, which was the intent. And I appreciate your time today. I'd be happy to answer any questions.
Thank you. Any questions? I don't see any questions. I do appreciate that you have brought it back to our committee because I think everything that you've spoken about today aligns with what our original intent was. We wanted to be certain that firefighters had access to workers' comp-like benefits, benefits that totally mirrored what you would receive under workers' comp if you could prove that the cancer was a result of a workplace exposure. We know that that wasn't possible. I do also want to say that this was an agreement that was worked out with all the parties at the table. And so for municipalities, I think there was agreement that this would be a separate fund, but would provide those benefits. So I'm disappointed that you're struggling a bit with it. But hopefully through this legislation, we can close those loopholes and make sure that the intent of the legislature and the governor were really that we were providing this kind of benefit to our firefighters. So well-deserved, it's the least we can do. And so I appreciate you bringing forward and always bringing the expertise that we need to get it right. So thank you.
Thank you. Thank you.
Next up, we have Jeff Tomczyk. What are you going to say after that, Jeff? I think he covered everything. No, I'm just kidding. Good to see you.
I think there's a firefighter behind me that will dispute that because I think I'm long-winded. Well, good afternoon, distinguished chairs, ranking members, and all the members of Labor Committee. My name is Jeff Tomczyk. I am the political director for the Uniformed Professional Firefighters of Connecticut. You know what? You between your comments and President Brown's comments, I believe that you know, and my written testimony, it's very clear on what we're trying to accomplish here. And we can discuss items like spirit of law and intent and true intent. And I think, you know, through a significant amount of gratitude on every firefighter across the state of Connecticut, career or volunteer, in 2022 and 2023, we formed a significant amount of education to the legislature to help them understand and learn the crisis point that we were at with cancer among firefighters. And we had a very well-developed collaborative effort with CCM, Workers' Compensation, the Treasurer's Office, and private attorneys to accomplish what was eventually put into law as 7-313B. And what came out of that was just a natural, I guess, for lack of better terms, progression on how law and attorneys can work with particular ways that or interpretations of law specifically. And when we look at the comparison of the way the development of workers' compensation has been created, and as well as how this was supposed to carry on that mirror image. There were some complexities and some challenges that were already discussed. So what we attempted to do, and what I think what this bill proposal explains clearly, is this is not an expansion of a benefit that was provided. This is clearly just some technical changes that are helping us to accomplish that legislative intent. And that intent is to allow our members that are eligible to go through a process of receiving benefits in an efficient time manner. We can discuss, as we did in 2022 and 2023, the challenges that an individual faces when they develop and are diagnosed with cancer. It's a very stressful time on them, personally, their family, and as well as the organizations that try and help them through the process. Our goal through the legislature, through workers' compensation, through the treasurer's office, and our organizations was to smooth that process out and make it our benefits as efficiently attainable as possible. So these technical changes, one by one, are listed in my written testimony, but just to hit on a few, as you'll hear from some of our members that are testifying, a state employee needed to be reiterated a couple times throughout the legislation because they work under a DAS separate chapter of the statutes, and oftentimes those two aren't referenced together. So it was clear that we needed to identify that in stronger language. Furthermore, we carried over skin cancer that was originally in our wage replacement bill, and the full intention was to carry it over into this language. So we wanted to make sure that that was reflected as well. Just as a little bit of data.
Mr. Tomczyk, your time is almost up. Please conclude your remarks.
Thank you, Cameron. Skin cancer is 27% more. Firefighters are affected 27% more than the general population. So it is imperative that particular cancer is carried over as it was reflected in the first bill that we did for wage replacement. And most importantly, as President Brown spoke to, identifying the authority for workers' compensation judges. They do want to help us out, but that authority was limited, and this does reflect how that can be, how this change can impact that. I do want to close with just saying again my personal gratitude on how this legislature, this committee specifically, as well as the legislature as a whole, embrace the education that we're providing on the crisis that we face. And the further testimony today with some of our members that had to face these challenges can expand on that. But it has been helpful, and I really want to push these technical changes through to carry on the true intent of what you are trying to accomplish and make sure that our members are covered the way they are deserved to be. Thank you, and I'll take any questions you may have.
Thank you. Representative Khan.
Thank you, Madam Chair, and thank you, Jeff, for coming before us today. I appreciate the work you do on this important issue and just making sure that our guys are covered when they get these types of illnesses. I just wanted to address one thing. Reading through the testimony, there seems to be a couple municipal CEOs who have concerns of the statutory change from the definition of personal injury to occupational disease. They claim that this will cause increased liability and moves this more towards a workers' compensation presumption. So I was wondering if you could just assuage those concerns.
Absolutely, Representative, and I appreciate the question. I did want to speak to that a little bit because I did recognize their opposition to that, and I think it's a misunderstanding on their part. Certainly, you can review their written testimony and trying to interpret it, but specifically in 7-313P, there are two inferences to one, the personal injury as well as the occupational illness. But I think through pathology, we can all recognize that cancer is not a personal injury. It is an occupational illness. And the suggested change of reinforcing the occupational illness aspect is just to absolve any confusion on that aspect and have the clarity of it just being identified specifically as occupational illness. When we talk about the reflective way we're mirroring the workers' compensation statutes, it's to my knowledge, of course, I'm not an attorney, but my work through the development of this, as well as representing members with injuries, there is no discernible liability reference for those two particular classifications. To my knowledge, again, the only differences is a statute of limitations comes into play. And with personal injury through workers' comp, you have 1 year to identify and claim, submit a 30C form to workers' comp identifying that you received that injury during work. For occupational illnesses, you have a 3-year window. Personally, I don't really see that becoming an issue. I mean, cancer is a pretty specific thing. Once you start developing symptoms and go to a doctor and get diagnosed with cancer, there really is no significant waiting period that you need to do or take. So I don't really see how a 3-year window would be called into question on that. But I do think that through the pathology aspect of it, it is a disease. It's an occupational disease or illness. It is not an injury. So that's why we suggested the change or the consistency of that.
I appreciate that distinction. Thank you.
Thank you. Any other questions? Thank you for those clarifying remarks. And we will look closely at the changes that you've suggested. And clearly, as I said before, our intent is to make sure that firefighters have access to this fund. So thank you again.
Thank you very much.
Next up, we have Ed Hawthorne.
Good morning, Senator
Good morning.
Kushner, Representative Weir, and of course, my state senator and fellow Wolcott resident, Senator Rob Sampson. My name is Ed Hawthorne. I'm proud to represent the working men, women of the state as the president of Connecticut AFL-CIO, Federation of hundreds of unions representing approximately 250,000 members in the public sector, private sector, and Connecticut state building trades. I'm here on several bills today, and I'll try to get through all of them before Cam buzzes me over there. First off is HB 5609, Act concerning retirement benefits for workers' compensation. We're looking at people failing to report injuries out of fear that their pension will be reduced. It's a double penalty. We'd ask that the committee support this bill to ensure a worker protection and health and safety in the workplace, which was previously discussed. Next is HB 6517, an act concerning disclosures of salary ranges for public and internal job postings. In 2024, women earned 83 cents for every dollar earned by men worldwide. In 2023, the Bureau of Labor Statistics stated that women earn approximately 83.6% of men's wages. The provisions of this bill would require salary ranges to be posted on public and internal job postings. This would empower applicants to negotiate compensation, promotes open dialogue, and help close that wage gap. And it decreases conscious and unconscious bias related to identity, gender, race, and previous pay scales. We're not alone. Other states do have this on the books. Colorado, California, and Washington do have similar laws. SB 1254, an act establishing protections for warehouse workers. It is the governor's version of the bill, which we are in support of. It'll establish protections to enhance their health and safety. We've discussed it before, the high injury rates of warehouse workers. It's twice that of the private sector. Thousands of warehouse workers sustain injuries requiring medical treatment. And Amazon, the largest warehouse employer in the state, has among the highest injury rates above its peers. And I do have injury data in there. So Representative Weir, I'm sure you'll be delving into that, being a data guy like me. Just like the other bill, disclosure of production quotas, prohibitive unfair quotas, protections against retaliation. Once again, similar states have it on the books. California, Minnesota, New York, Oregon, and Illinois is awaiting the governor's signature. SB 831, the advanced scheduling. We all know the challenges of work-life balance. Without a predictable schedule, families do suffer. And this is limited to employers with over 500 workers globally. We ask the committee support that bill as well. Discussed earlier by Senator Flexer and Representative Blumenthal, SB 1035, an act concerning limitations on the use of non-disclosure agreements. The provisions of the bill do stifle speech, conceal misconduct, monopolize markets. There's a public interest to this because it perpetuates the harm that's being caused in the workplace. by silencing the people from being able to speak up when they may not even know they're subject to an NDA. SB 1226, an act making changes to Firefighters Cancer Relief Fund. Brothers Tomczyk and Brown reiterated that, but it makes technical changes to streamline the process to ensure they get the benefits that they are due. And lastly, SB 1427, the paid family and medical leave for non-certified employees. It provides job protections, partial wage replacement, as was previously stated. It's cost neutral to municipalities and boards of education because they are not putting a dime into it, which I think was failed to be stated before. But it ensures that non-certified employees can take the necessary leave without fear, and it recognizes the integral role of non-certified staff in our students' day-to-day lives at school while they're away from parents like me. So thank you, and I'll be happy to answer any questions.
Any questions? I don't see any questions. Thank you for your testimony.
Just one more thing that I forgot. Representative Ware, you were talking about data. Keating in the Hartford Current today had some data on that you were asking for from Senator Flexer as well as Representative Blumenthal. So check out the Keating article. It actually gives the polling disclosure and what that was like in the margin of error and stuff like that. Sorry, I forgot to mention that, but now I'm actually done.
You're fine. Thank you. Next up, we have Nellie Yara. Okay. You know, if you would like to give it to Cameron, he can then hand it to each of us. We'll handle it. Thank you. Can you leave one for Rep Camino? Thank you. We want to leave one here. Good to see you this morning. Go right ahead. You need to, there you go. No, it was on, I guess it's a little fragile. Okay, there you go.
Good afternoon, members of the co-chairs of the Labor Committee, Representative Weir, Senator Kushner. Thank you for the time today and to offer me to speak and for your continued support to allow us to become leaders in the movement for inclusion of domestic workers under state and federal labor laws. My name is Nellie Yara, and I am the Executive Director of Connecticut Worker Center and part of the Connecticut Domestic Worker Justice Coalition, which is made up of domestic workers and employer organizations, affiliates of the National Domestic Worker Alliance. Together, we represent thousands of domestic workers and employers across our state, mostly immigrant women of color who provide care and support in people's homes, caring for children, cleaning houses, and supporting people with disabilities and older adults. Those years of continued work on support and assisting with the education program help us to engage more domestic workers in the movement. They learn to defend their rights, but we still have much work ahead. I believe in order to achieve social change, it must affect transformation at the personal, cultural, and institutional level. And that's why I'm here today to request your support for SB 1428, an act appropriating funds for $500,000 in the FY26 budget and $500,000 in the FY27 budget for the Domestic Workers Education and Training Grant Program. By passing this act, our elected official will ensure that domestic workers' rights in Connecticut are fully realized and that employers have the information they need to comply with their obligations under the law. Today, there are over 5,000 domestic workers who have access to the information about the Know Your Rights program in Connecticut. And there are over 35,000 domestic workers that need to be educated. We have celebrated many transformative wins over the past decade, including the Connecticut Domestic Workers Bill of Rights, and recently the expansion of the Pay Safe and Sick Leave law. Many workers still do know their rights and how to enforce them. We have engaged in organizing domestic workers since 2012, and together we passed state and federal laws. The Connecticut legislature passed an act concerning wage education and enforcement relating to domestic workers in 2021, establishing a fund program with the Connecticut Department of Labor to collaborate with community-based organizations to educate domestic workers and employers about their rights and responsibilities under the law. Through this partnership, organizations have provided on-the-ground outreach, assisting domestic workers in understanding their new rights and employers in understanding their new responsibilities, as well as with supporting workers whose rights have been violated to access remedies. This successful program is now in this fourth year, with the existing fund expiring in June 2025. We urge you to pass SB 1428 to continue and expand this existing program and strengthen our collaboration with the Connecticut Department of Labor in outreach and education, support investigation of rights abuse, create referrals to legal service, and broaden enforcement of paid sick leave.
Ms. Jara, your time is almost up. Please conclude your remarks.
Thank you. We need our state to support, as we support our families, homes, and loved ones across Connecticut. We need to educate workers' expertise to give them the tools to self-advocacy, to teach and support other workers who have victimized, and they need the opportunity to learn and be respected in the workplace. Thank you, Senator Kushner, to be our champion, and hopefully you continue working together with and supporting domestic workers. Thank you.
Thank you. I don't see any hands, but I do want to say that I appreciate the work that you have done in this area, and you and the other organizations have been doing this work for years, for many more years than we ever as a legislature recognized through the appropriation. And I do understand that in order to continue this work, there needs to be additional funds. So we appreciate you bringing it to our attention. And we have heard from the Department of Labor how well the program has worked through that collaboration. So we appreciate it. I don't see any other hands. I do want to ask you a question, though,
Yes.
regarding some of the other people that have signed up to testify. A number of people are online, and there are some also folks that signed up that I believe are in the room. We had arranged for a translator to be here, and that translator has been delayed, as far as I understand. And I don't know if you have someone that can translate.
The two participants that we have here, they can read it in English, and I can help one doing the translation in Spanish.
Okay, thank you so much for helping us out with that. It's on us that we didn't have that translator available, and we'll try and make sure that doesn't happen again, but thank you for helping out. So we will go ahead and proceed. And we have next on the list. I think what I might do is first call on the folks that are in the room, and then maybe Cameron, you can help Nellie get set up on Zoom to help with the translation for those who are online. We'll figure out how to do that, but let's start with who's in the room, if that makes sense.
Yeah.
And is that Oneida
Oneida.
Cayetano?
Sí.
Buenas tardes, copresidentes del Comité Laboral y senadora Kushner y representantes, por darme la oportunidad de hablar hoy en nombre de SB 1428. Mi nombre es Oneida Cayetano. Soy una trabajadora doméstica y miembro del Centro de Trabajadores de Connecticut. Este proyecto de ley es muy importante para garantizar que los derechos de los trabajadores del hogar en Connecticut se realicen plenamente y que los empleadores tengan la información que necesitan para cumplir con sus obligaciones bajo la ley. Sufrí robo de mi salario. Mi empleadora se burlaba de mí y se aprovechaba de mi tiempo. Yo trabajaba y no me pagaba. Durante 6 días consecutivos me dijo que me reuniera con ella en diferentes lugares. Me prometió el pago, pero nunca cumplió. Yo trabajaba cuidando a una persona de día y de noche. Lo único que quería era que ella me pagara mis 90 horas de trabajo. Ella me decía que nos viéramos en algunos lugares y a las 8 de la mañana y a las 9 me citaba. Y recuerdo esperarla por horas, a veces hasta las 7 y 8 de la noche. Ella me aseguraba que estaba en camino y yo la esperaba hasta que me cansé de esperarla. Me sentía muy triste, a veces lloraba. Me sentía muy confundida y dolida por la arrogancia de mi empleadora. Estaba desesperada porque necesitaba mi dinero para pagar mi renta, mi alquiler y mi comida. Un día no tenía comida y así que fui al Thomas Merton Centro, que está cerca de donde vivo. En este lugar dan comida. Y ese día había alguien de Connecticut Worker Center dando información sobre los derechos de los trabajadores. Perdón. Me puse en contacto con ellos y recibí todo el apoyo que necesitaba. Me ayudaron presentando una queja ante el Departamento Federal de Trabajo e incluso me ayudaron a conseguir un alivio migratorio a través de la acción diferida para la aplicación de la ley laboral. Aprecio el apoyo de Connecticut Worker Center y creo que más personas necesitan saberse acerca de sus derechos y el apoyo que es clave para continuar con esta misión. Nos urge su apoyo con el SB 1428 para continuar y ampliar estos programas existentes y fortalecer nuestra colaboración con el Departamento de Trabajo de Connecticut en la divulgación y la educación, apoyar la investigación de los abusos de derechos, crear referencias de servicios legales y ampliar la aplicación de la licencia por enfermedad pagada. Necesitamos que nuestros estados nos apoyen mientras apoyamos a las familias, a los hogares y los seres queridos de todo Connecticut. Muchas gracias.
Thank you for your testimony. And now, Nellie, if you will translate.
Good afternoon, co-chairs of the Labor Committee, Senator Kushner and Representative Sanchez, for giving the opportunity to speak today on behalf of SB 1428. My name is Oneida Cayetano, and I am a domestic worker and a member of Connecticut Worker Center. This bill is very important to ensure that the rights of domestic workers in Connecticut are fully realized and that employers have the information they need to meet their obligations under the law. I suffer wage theft. My employer mocked me and took advantage of my time. I worked and didn't get paid. For 6 consecutive days, she told me to meet her in different places. She promised me payment, but she never complied. I work caring for someone day and night, and all I want was to get paid for my 90 hours. She wouldn't tell me to meet her at 8 a.m. or 9 a.m., and I remember being there for hours, sometimes until 7 p.m., 8 p.m. She wouldn't assure me that she was on her way, but I would wait for her until I got tired of waiting for her. I felt sad, sometimes I cried. I felt very confused and hurt by the arrogant attitude of my employer. I was desperate because I need my money to pay the rent and to eat. One day I had no food, so I went to the Thomas Merton Center, which is close to where I live. In this place, they give out food. And that day, there was someone from Connecticut Worker Center giving information about their worker rights. I contacted them and I received all the support and I needed. They assisted me by filing a complaint with the Federal Labor Department, and they even helped me get immigration relief through the Deferred Action for Labor Enforcement. I appreciate Connecticut Worker Center and all the support for the domestic workers they do. And I believe more people need to know about the rights and support is key to continue with the mission. I urge to support HB 1428 to continue and expand these exciting existing programs and strengthen our collaboration with the Department of Labor on outreach and education, support investigation of rights abuse, create legal service referrals, and expand paid sick leave enforcement. We need our state to support us, and we support families, households, and love and across Connecticut. Thank you for your time.
Thank you for your testimony and for telling your story. I know it wasn't easy, but it is important for us to hear from people that we might otherwise not know about their struggles. So please translate that for me.
Dice que muchas gracias porque tú estás aquí por contar tu historia y que sabemos que muchas personas necesitan de esa ayuda y estamos ahí para.
Thank you, you too.
Thank you.
God bless you.
Thank you. Next up, I am going to go online because I understand that Tatiana Behar is here. And that, again, I apologize, but I understand you don't need the translation today. So appreciate being with us. So please go ahead, Tatiana.
Thank you, Committee Chair, Senator Julie Kushner and Representative Manny Sanchez, and as well as other committee members for the opportunity to speak today. My name is Tatiana Behar, Director of Local Organizing Programs at the National Domestic Workers Alliance, and also Coordinator of the Connecticut Domestic Workers Justice Coalition. I'm here to request your support for SB 1428, which will provide $500,000 in each fiscal year, 26 and 27, and much needed funding for outreach, education, and enforcement of domestic workers' rights. For far too long, domestic workers have been denied access to basic rights, leaving them vulnerable to exploitation, unsafe working conditions, and retaliation. Now that the over 30,000 domestic workers in Connecticut have new rights and protections since 2015, with the passage of the Connecticut Domestic Workers Bill of Rights and recently the Basic Leave Law, it is critical that they are fully informed about how to properly navigate their rights. To improve the working conditions of domestic workers, it is essential that robust outreach efforts are made statewide, especially given the disaggregated nature of domestic work. With the national political climate in the coming years, it will be even harder to reach immigrant workers and vulnerable populations like domestic workers who are more likely to fear coming forward and reporting labor rights abuses to government agencies. After witnessing the positive impact of domestic workers' rights education and enforcement programs, most states and cities have begun funding these initiatives. In 2013, California Domestic Workers Bill of Rights became law, and in 2016, this program was reauthorized. California has now committed $35 million over the next 5 years to support domestic worker and employer education. In addition to California, New Jersey, Washington, D.C., Seattle, Boston, and New York City have all launched similar partnerships and funding programs. In 2021, the Connecticut legislature passed an act concerning wage education and enforcement relating to domestic workers, establishing a funding program within the Connecticut Department of Labor. Through this partnership, organizations has provided on-the-ground outreach and education, assisting domestic workers in accessing their rights, employers complying with their responsibilities, and supporting workers whose rights have been violated to access remedies. This successful program is now on its 4th year and existing funding expiring in June 2025. Passing SB number 1428 will ensure and expand this program so domestic workers can access their rights and connect with the Connecticut Department of Labor and other state government agencies who are key partners of our movement. Thank you, committee members and chairs, for hearing my testimony, for supporting domestic workers, and really we are hoping Connecticut also takes the lead as other states in the country and support domestic workers' rights as they also support families, people with disabilities, elder adults, and also clean and organize our homes. Thank you so much.
Well, thank you. And thank you for your work on a national level and advocacy, and also bringing the information to this committee about what other states are doing. We do want to make sure our committee's jurisdiction, our charge is to make sure that not only are we passing bills that support working families in Connecticut, but also that people have access to both the education they need to know what rights they do have, but also to have the advocacy they need. And your affiliate organizations here in Connecticut do a great job with that. And so we appreciate you being here to testify. I don't see any questions, but thank you for your work and thank you for your words today. Next up, we have Patricia Zavaleta. Patricia, are you with us? She would be online.
Patricia, if you could please unmute yourself, and Nellie.
And Nellie, we might need you to come up and say that into the microphone, or someone who can translate. We need to make sure that Patricia understands that she needs to unmute herself in order to be able to testify. And then after she testify, if you'll let her know that you'll be doing the translation, I'd appreciate it.
The translation for her.
What's that?
I'm going to be doing the translation for Patricia.
Yes, can you let her know right now that she needs to unmute herself?
Patricia, tienes que prender tu micrófono, por favor.
And you might need to speak right into that microphone.
¿Me escucha ahora?
Sí.
Ok. Estimado copresidente del Comité de Trabajo, senador Kushner y representante Sánchez. Mi nombre es Patricia Zavaleta. Soy una trabajadora del hogar y miembro del Centro Connecticut Worker Center. Gracias por la oportunidad de testificar en nombre de SB 1428, una ley que asigna fondos por 500,000 en el presupuesto del año fiscal 26 y 500,000 en el presupuesto del año fiscal 27 para la educación de los trabajadores del hogar y el programa de becas de formación. Al aprobar esta ley, nuestros funcionarios electos se aseguran de que los derechos de los trabajadores del hogar de Connecticut se realicen plenamente y que los empleadores tengan la información que necesitan para cumplir con sus obligaciones bajo la ley. El Connecticut Worker Center es parte de la coalición por la justicia de los trabajadores del hogar de Connecticut, formada por trabajadores del hogar y organizaciones de empleadores afiliados a la Alianza Nacional de Trabajadores del Hogar. Creo que es muy importante que conozcamos nuestros derechos. Cuando no los conocemos, estamos expuestos al abuso laboral y al robo de salario. Si nos pasa algo en el trabajo y no sabemos cómo encontrar ayuda, no podemos defendernos. En mi experiencia personal, he tenido múltiples problemas en el trabajo. Una vez me caí de una escalera y me tuvieron que operar de la rodilla. Nunca me recuperé bien. Mi jefe de aquella época nunca pagó mis medicinas ni las facturas del hospital. También trabajé por alguien que me prometió un sueldo determinado y nunca me pagó esa cantidad. También tuve problemas en los hombros debido a los movimientos repetitivos que tenía que realizar en el trabajo. Tuve que ponerme un implante en el hombro y hasta ahora me sigue molestando. Antes se aprovecharon de mí porque no conocía mis derechos. Si los hubiera conocido, podría haber buscado ayuda. Por favor, apoye SB 1428 para continuar y ampliar esos programas existentes y fortalecer nuestra colaboración con el Departamento de Trabajo de Connecticut en divulgación y educación, apoyar la investigación de casos laborales, crear referencias a servicios legales y ampliar la aplicación de la licencia por enfermedad pagada. Gracias por su apoyo, por su tiempo.
Thank you. Go ahead with the translation.
They are co-chairs of the Labor Committee, Senator Kushner and Representative Sanchez. My name is Patricia Zavaleta. I am a domestic worker and a member of Connecticut Worker Center. Thank you for the opportunity to testify on behalf of SB 1428, an act appropriating funds for 5,000 500,000 in the FY26 budget and 500,000 in the FY27 budget for the Domestic Workers Education and Training Grant Program. By passing this act, our elected officials will ensure that domestic workers' rights in Connecticut are fully realized and that employers have the information they need to comply with their obligations under the law. Connecticut Workers Center is part of the Connecticut Domestic Workers Justice Coalition, which is made up of domestic workers and employers organizations, affiliates of the National Domestic Workers Alliance. I believe it is very important for us to know about our rights. When we don't know our rights, we are exposed to labor abuse and wage theft. If something happens at work and we don't know how to find help, we can defend ourselves. In my personal experience, I have had multiple problems at work. Once I fell off a ladder and I had to have knee surgery. I never recovered well from it. My boss from that time never paid for my medicines or the hospital bills. I also worked for someone who promised me a certain pay and never paid me that amount. I also had problems in my shoulders due to the repetitive motions I had to perform at work. I had to have a shoulder implant, and until today, it still bothers me. I was taking advantage before because I didn't know my rights. If I have known them, I could have sought help or advice. Please support SB 1428 to continue and expand these existing programs and strengthen our collaboration with the Connecticut Department of Labor in outreach and education, support the investigation of labor cases, create referrals to legal services, and broaden enforcement of basic leave. Thank you for your time.
Thank you, Patricia, for your testimony today.
Gracias.
Next up, we have Carmen Lanche. Carmen, do you need translation? You need to, there you go.
Sí. Buenas tardes. Ahora voy a leer mi testimonio.
¿Tú necesitas traducir?
Sí.
Okay, can you translate for Carmen? Can someone translate for Carmen? Momentito.
Gracias.
Okay. Continuar.
Buenas tardes, senador Kushner, representante Sánchez y miembros del Comité de Labor. Mi nombre es Carmen Lanche, vivo en Norwalk y soy la directora de la organización Comunidades Sin Fronteras. Somos parte de la coalición de Justicia para Trabajadoras del Hogar en Connecticut y también somos parte de la Alianza Nacional de Trabajadoras del Hogar. La ampliación de las actividades educativas y de divulgación que son enfoques más productivos para prevenir las infracciones salariales y horarias antes de que se conviertan en un problema y disminuirían el número total de infracciones. El robo de salario a los trabajadores del hogar, quienes no se les paga por las horas trabajadas. Esto va desde un pago por debajo del salario mínimo para los trabajadores del hogar, falta de pago de tiempo y medio por horas trabajadas, más de 40 horas en determinadas semanas y falta de pago en absoluto. Ejemplos de educación incluyen la realización de seminarios para empleadores y empleados que eduquen a los empleadores sobre sus responsabilidades. Existe una mayor demanda por parte de los empleadores que quieran saber cuáles son sus obligaciones con respecto a la compensación de los empleados. Yo estoy aquí en apoyo a esta ley porque yo sé que la divulgación puede incluye más que todo informar y educar a los trabajadores del hogar sobre sus derechos y a los empleadores sobre sus responsabilidades. Nivelar las condiciones para los trabajadores del hogar mediante la educación es muy importante porque ayuda a recibir un sueldo justo y digno por su trabajo realizado. Se asigna el presupuesto Este presupuesto podría ser establecido cada año por un monto de 500,000 anualmente. Esto ayudaría a seguir trabajando con la implementación y educación tanto de trabajadoras del hogar como empleadores. Por eso apoyo la SB. Por eso apoyo este proyecto de ley, porque yo sé que ustedes han visto el trabajo que se ha realizado, han visto usted, senadora Kushner, más que todo que ha sido nuestra campeona, de que las trabajadoras del hogar ahora están más empoderadas y saben defender sus derechos, pero falta mucho más trabajo por hacer porque en el estado de Conérico hay más de 35,000 trabajadoras del hogar. Espero de que hoy puedan tomar la decisión de seguir apoyando el trabajo y de seguir apoyando a todos los trabajadores, incluidos los trabajadores del hogar. Gracias.
Thank you for your testimony. Nellie, please translate.
I don't have my
Summarize.
testimony. I'm gonna summarize, but good afternoon again. Thank you for your support. My name is Carmen Lanche, and she's Executive Director of Comunidades Sin Fronteras in NOAC, and she is speaking on behalf of SB 1428 for allocating funds of 500,000 for the year 26 and 500,000 for the budget 2027 for the Domestic Workers Education and Training Grant Program. She believed that the education is important for the domestic workers, and those years of fund that we have the opportunity to do the outreach, to do the presentation of Know Your Right, of the Know Your Rights program, and to work with different agencies and support domestic workers, make the difference on domestic workers' lives. And also she wants to ask for the continued support. We depend on the financial with the financial assistance to continue the education program. We have more domestic workers to educate, and we assist them on filing claims to the Department of Labor, assisting domestic workers internally doing mediations. So basically, what this education program is supporting more workers, and the main thing is to reduce wage theft and exploitation. If we educate, we empower workers, and we change those workers' lives and also the family.
Thank you, Carmen. And as I said before to Nellie, we appreciate the work not only of the Connecticut Worker Center, but your organization as well, Comunidades Sin Fronteras, Connecticut. Muchas gracias.
Thank you.
Gracias, senadora.
And I see there is Representative Hughes.
Thank you, Madam Chair, and thank you so much, Carmen, for your testimony. I just wanted to clarify that this program was funded through ARPA dollars that is running out, correct?
Yeah.
Yes. Thank you. And I know that, Carmen, you have seen firsthand how the education program has intervened, especially in cases of wage theft and exploitation, which of course the state of Connecticut wants to interrupt. So I just wondered, maybe Nellie talked about this, but how many workers the current program that's about to run out of funds has helped? Do you know?
Well, we have thousands of domestic workers, more than 5,000 on those basically almost 4 years. And a lot of materials were distributed in different places, libraries, schools, parks. But still more to do, more work to do. And you can hear the testimony of already from our Oneida, You know, this is true. We're not creating stories. We're not making up stories. We're working directly with our community, and we can see the necessities and the need to educate those workers. This is the only way that we can, again, reduce wage theft, exploitation, and work in coordination with the agencies, especially with the Department of Labor. So those years we gain a lot of opportunity to interact with some people who are working with the Department of Labor. We have assigned investigators who they were supporting some workers with some cases. So there is a lot of work to do, but also we wish we can, you know, the Department of Labor, they invest and they have more investigators to move on in cases, because people are waiting to be paid, and at the end of the day, they want to bring food to the table by every week, and not to wait 6 months, 1 year, more than 1 year to fix a problem that employer is taking advantage. So I think it's important to continue the work, and we are very grateful that Senator Kushner, Representative Hughes, and everybody knows that the need. So we hoping that to continue doing that work.
I do want to say
Thank
that
you.
I see that Carmen has raised her hand. I think she'd like to respond to the question as well. So go ahead, Carmen, and Nelly, if you would translate for us.
Sí, yo quería solamente decir que durante el año 2021-2023 tenemos ya un reporte hecho que 140 entrenamientos han sido por educadores, 2.500 trabajadoras del hogar han tenido información sobre sus derechos. Hemos repartido más de 5.000 materiales educativos mediante redes sociales y también por email, mensajes. Han sido 4.000 trabajadoras del hogar donde han reaccionado a estas publicaciones, y también tenemos 1.000 empleadores que también han reaccionado a las publicaciones de las responsabilidades de empleadores en el estado de Connecticut. Con esto quiero decir que estos fondos han sido de gran ayuda para todas las organizaciones que estamos trabajando para las trabajadoras del hogar, y el apoyo de ustedes es grande y ha sido magnífico, y queremos seguir trabajando con ustedes, que sigan apoyando a nuestra comunidad trabajadora del hogar, porque necesitan seguir conociendo sus derechos, necesitan seguir defendiendo sus derechos, y cada trabajadora del hogar empoderada es una trabajadora feliz, y el trabajo que ellas hacen merecen toda la dignidad y respeto, y por ese trabajo otras profesiones, otros trabajadores, otros personas pueden seguir trabajando, dejando a sus hijos seguros y en confianza. Gracias.
I know that was a lot. And
Yeah.
in the future, I think we need to advise folks to break into shorter.
She was referring about the key accomplishment of the Connecticut Domestic Worker Education and Training Program. I did share a document with the members. So basically, we have 2,500 domestic workers trained in Know Your Rights workshops, 4,000 domestic workers reached with Know Your Rights materials and community outreach, 140 domestic workers peer educators trained, 1,000 domestic employers access resources about their legal obligations, more than 40 domestic workers supporting their wage theft and discrimination complaints, collected $10,000 for domestic workers owed wage through direct negotiations with employers, legal support, and Connecticut DOL claims. At the end, Carmen is referring that domestic worker is an important work. They make possible other workers. Employers can leave their kids, their parents, their grandparents, the house to be clean, and come back and see the house clean, beautiful, and they have to be recognized. They have to be respected, and they have to be paid, and we gain laws, and we will continue gaining more space for our domestic workers who are no more invisible. Thank you.
Thank you. And just Representative Hughes, we did at the outset get a document, and I know Cameron has it as well for all the members of the committee, but thank you for that additional testimony. And I saw Tatiana come back up. And I saw your hand go up. It's not typical that we do it this way, but I will say in recent hearings that we've had panels where you can ask the question of a number of different people. So I'm going to allow you if you want to add some information.
Yeah, I just wanted to add that this data that we are sharing with you is just in 2 years of this program. There are much more domestic workers who were training Know Your Rights workshops in the last 2 years. It's really been very successful. It's not only about just domestic workers knowing their rights and employers, how getting the guidance on how to implement these rights in their homes, but it's also creating leadership opportunities for women of color in also being more outspoken, connecting with other domestic workers. And I think also it's very important to understand that it's not very easy to do domestic worker and employer outreach. These we're talking about people's private homes. It becomes very hard to find domestic workers or to talk to employers because not all the employers identified as employers, right? If you ask someone who hires a nanny or a house cleaner, they may not think themselves as an employer, or they don't have a human resources person in the home. So this program really has historically and successfully changed and raise standards, not only in Connecticut, but many other cities and states, as we shared also in our testimony. So I think that considering also how the economic issues that impact domestic workers in the last years with inflation and also the need to expand this program, we believe that this is really critical for if we want to ensure that domestic workers' rights are actually real and feels like the victory is not only in the paper, but also in the workplaces. Thank you so much for.
Thank you for that commentary. And I do want to, I think it's important to underscore what you and others have said today about the fact that domestic workers most frequently work in isolation. And I would guess that many of the wage claims that we see in the Department of Labor, workers understand their rights not so much from a piece of paper or a law that we pass up here, but because a coworker tells them, oh, they didn't pay you right. And so that information, that's transfer of information about our laws doesn't happen as easily for domestic workers because they're working in isolation. And it's because of these organic groups that we have in the state of Connecticut that have been working for years to establish relationships, to make their presence skills is really, really important to making sure that people are fully aware of what their rights are. So we think there's many ways in which the domestic workers organizations, these community organizations have been sort of essential to enforcing the laws we have. I do also want to note, Nellie, I heard what you said when you talked about the inspectors. It was just like one brief sentence, but one of the other bills we have before us in this legislative session here in the Labor Committee is to increase the number of wage and hour inspectors. And I do know from over the last year in particular, from hearing from your organizations, that there have been real issues in getting action by the Department of Labor because, in any timely basis because of the backlog of cases and the lack of inspectors. So it does, those two issues really come together. If we are going to pass laws, we need people to be able to know what the laws are that protect them on the job, as well as inspectors at the Department of Labor to investigate and then ultimately enforce those laws. So I'm glad you mentioned that as well. I don't have that bill number right in front of me, but I'm sure we all are well aware of it. Okay, so next up, and we do have an interpreter with us, Yearly. Thank you for joining us. So next up, we have Beatriz Moncada, and you are online, Beatriz. And if you could, Yearly, is Yearly your first name?
Yes, it is.
Okay.
Nice to meet you, everyone. I will be your interpreter today, okay? Everything will be confident here. And just if I need a pause, I will raise my hand. I know I'm not sure if everybody is looking at me, but I will just jump in and would start interpreting, okay?
That sounds
Solo acabo de decir que seré el intérprete de ustedes. Si levanto mi mano y ustedes me ven, pues por favor hagan una pausa. Si no, pues yo voy a interrumpir y voy a proceder a interpretar.
And could you
Okay.
please advise Beatrice that she needs to unmute her microphone?
Puedes, Patricia, por favor, puedes desmutear tu micrófono, por favor, para hablar.
Sometimes we have difficulty with folks not knowing how to unmute themselves on Zoom. So you may need to explain that to Beatrice.
A veces tenemos dificultades para desmutear el micrófono. Por favor, Beatriz, puedes... dije Patricia. I said Patricia. It was my mistake. Beatriz, ¿puedes desmutear tu micrófono, por favor, para hablarnos?
Okay, I have another suggestion. I know, Carmen, you're in the same
Oh,
organization.
sí.
Could you please, Yurli, could you translate for me? Could Carmen call Beatrice separately and advise her on how to unmute, and that we will go on to the next person while we're waiting for Beatrice?
Ok, Carmen, ¿puedes por favor decirle a Beatriz que llamarla en privado y explicarle cómo hacer para que pueda hablar en público? Desmutear su celular, por favor. Muchas gracias.
In the meantime, I'm going to go on and see, I don't see Xenia Castillo. She has not joined us yet. So then, and neither has Judith Paz.
No veo a Cinia Castillo y no veo a Judith. Están por ahí, ¿saben si se va a conectar?
So I think what I would like to do, oh, there's Beatrice, but in the meantime, while Beatrice is looking to unmute, let's go to Sylvia Salinas, who is with us now. Sylvia, can you hear us, and do you need translation?
No, I will do it in English. Thank you, Senator.
Thank you. Please proceed.
Good afternoon, co-chairs of the Labor Committee, Senator Kushner, Representative Sanchez, and members of the committee. Thank you for the opportunity to testify on behalf of SB 1428, an act appropriating funds for the Domestic Workers Education and Training Grants Program. My name is Sylvia Salinas. I am the Workers and Community Advocate at Connecticut Workers Center. We are part of the Connecticut Domestic Workers Justice Coalition, which is made up of domestic workers and employer organizations, all affiliates of the National Domestic Workers Alliance. We have been working on behalf of domestic workers for years, and thanks to this fund, we have been able to inform and educate workers and employers in Connecticut about their rights and responsibilities. Together, we represent thousands of domestic workers and employers across our state, mostly immigrant women of color who provide care and support in people's homes, caring for children, cleaning houses, and supporting people with disabilities. All underserved workers. By passing SB 1428, our elected officials will ensure that domestic workers' rights in Connecticut are enforced and that employers have the information they need to comply with their obligations under the law. Since the legislature passed in Connecticut in 2021, an act concerning wage education and enforcement relating to domestic workers, here we in Connecticut Workers Center, we have reached out to over 800 workers and employers. We need your support to continue to do it. And also, please remember that domestic workers play an essential role in our society. They make all other work possible, as it was just mentioned before. Thank you for your time and your commitment to domestic workers.
And thank you, Sylvia, for your testimony and also for the work you do through the Connecticut Workers Center to really make sure that these workers' rights that are in our statutes are upheld. So thank you so much.
Thank you.
I do see that now Beatrice is with us, and it looks like you, Beatrice, can now unmute. And if Yurli could help her with, oh, there you go. Go right ahead, Beatriz.
Ok, ahora vemos que Beatriz está con nosotros. Beatriz, si puedes continuar. I'm going to do a pause because I cannot hear what she said. I don't know if you guys are listening something. Beatriz, no te puedo escuchar. No sé si las otras personas te pueden escuchar. Beatriz.
Beatrice and Carmen, are we having a problem? Perhaps she needs to, under the audio settings, she may need to increase the volume on her mic.
Carmen, vemos que Beatriz está teniendo problemas para su micrófono. ¿Le puedes decir que en la configuración tiene que ponerle más volumen a su micrófono, por favor?
Sí, ahora le digo. Gracias.
Yes, I'm going to tell her. Thank you.
So while Carmen is reaching out to Beatrice, I just want to be sure before we move on, we don't have Zania or Judith, Zania Castillo or Judith Paz. So I think we will come back to Beatrice if we're able to make it work. In the meantime, I am going to call up the next speaker on our agenda, which is Brooke Foley. So Yurli, you should probably mute yourself and
Sí, quería avisarle de que ella se va a conectar por el teléfono mejor porque por la computadora tiene mucho problema. Va a salir y se va a conectar por el teléfono. Por favor, ahora mismo.
Okay, yes.
Gracias.
So I'm gonna tell her she's gonna connect with us, but through the phone. I just wanted to say that Beatriz is gonna be with us through the phone.
Okay, if she's calling in right now, we will continue her. And I do see that we also have Jenny Canepa. But Jenny, is Jenny also speaking on the domestic workers bill? Okay, so why don't we go ahead to Jenny right now? And then Brooke, thank you for being patient, and we'll come back to you. But I think if we hear all the testimony here, it will be helpful. So Jenny, do you need translation?
No, I will do it in English, please.
Thank
you so much.
Go right ahead.
Good morning. Thank you, Co-Chair Senator Kushner and Representative Sanchez, for the opportunity to speak today. My name is Jenny Canepa, and I'm a member of the Connecticut Workers Center and the Connecticut Domestic Workers Justice Coalition. We represent thousands of domestic workers and employers across the state, primarily immigrant women of color who provide essential care and support in people's homes, including childcare, cleaning, and assisting individuals with disabilities and older adults. I'm here to request your support for SB 1428, which proposes $500,000 in funding for the Domestic Workers Education and Training Grants Program in both the FY26 and FY27 budgets. This program will help ensure that domestic workers in Connecticut can fully realize their rights and that employers have the necessary resources to comply with their legal obligations. There are over 35,000 domestic workers in Connecticut, while we have made significant progress, including Connecticut Domestic Worker Bill of Rights and the expansion of the paid sick leave law. Many workers still lack awareness of their rights and how to enforce them. In 2021, the legislature passed a law to establish funding to wage education and enforcement. This program was successfully collaborated with community organizations to provide education and support to workers and employers. However, the current funding expires in June 2025. We urge you to pass SB 1428 to continue and expand this essential program. These funds have allowed us to educate workers about their rights and help them prevent wage theft. We want more people in our community to be informed and aware of their rights to protect themselves from exploitation. We need the state to support us as we support families across Connecticut. Thank you again, Senator Kushner, Representative Sanchez, and committee members for your time and consideration. We look forward to collaborating with you to ensure domestic work is valued and dignified in Connecticut. Thank you for your support, your compromise, and your commitment. Have a good day.
Thank you, Jenny, for your testimony. We're going to pause for one moment. Beatriz, are you able to unmute?
Beatriz, puedes desmutearte ahora, puedes poner tu micrófono con volumen ahora.
Okay, we'll come back. Brooke Foley.
Good afternoon, Representative Sanchez, Senator Kushner, Vice Chairs, Ranking Members, and distinguished members of the committee. My name is Brooke Foley, and I represent the Insurance Association of Connecticut. The IAC opposes Senate Bill 1035 and House Bill 6517. Both bills place significant burdens on employers and could have unintended consequences that negatively impact businesses and workers. First, Senate Bill 1035 limits the use of non-disclosure agreements. While we understand the intent of the bill is to prevent harassment in the workplace, this bill is overly broad and goes too far in restricting legitimate and beneficial agreements. Employers rely on non-disclosure agreements to protect sensitive business information, proprietary processes, and confidential settlement terms. Without enforceable non-disclosure agreements, companies will be reluctant to resolve disputes privately, leading to prolonged and costly litigation. This bill would discourage companies from offering severance packages as they will have little assurance that the terms of an agreement will remain confidential. The bill's language is vague and subjective, relying on an employee's reasonable belief of misconduct rather than a clear legal standard. This will invite disgruntled employees to make exaggerated or false claims and make businesses defend against unproven allegations with no means of protecting their reputations. House Bill 6517, which mandates salary range disclosures and job postings and internal hiring processes, creates unnecessary administrative burdens, particularly for small and mid-sized businesses. Companies will be forced to regularly update salary ranges and benefits disclosures, taking time and resources away from business growth and job creation. Additionally, requiring public disclosure of wage ranges will put Connecticut businesses at a competitive disadvantage by exposing internal compensation strategies to competitors, and it will also affect an employer's ability to negotiate salaries based on an applicant's qualifications, experience, and market conditions. Connecticut already has strong workplace protections. Senate Bill 1035 discourages settlements, increases litigation, and ultimately hurts both businesses and employees. And Senate Bill 6517 adds layers of regulatory complexity that will hinder rather than help Connecticut's workforce. Both bills could deter businesses from expanding or investing in the state, and we urge you not to advance these bills.
Thank you. I don't see any hands, so thank you for your testimony.
Thank you.
Don't think that Beatrice is able to unmute at this time, so we'll keep you in mind.
No creo que Beatriz todavía pueda activar el sonido, entonces vamos a tenerte en cuenta.
Okay. Up next, we have Irene Tung.
Good afternoon.
Good afternoon. We can hear you.
Great. Give me one moment.
No problem.
So thank you to the committee for the opportunity to testify today. My name is Irene Tong. I'm a senior researcher and policy analyst at the National Employment Law Project. We are a nonprofit, nonpartisan research and advocacy organization specializing in employment policy. I'm testifying on my conditional support for HB 768 to provide safeguards for Connecticut's warehouse workers. I'd like to first recognize Governor Lamont for introducing this legislation, which shows his concern for the issue. His support for legislation that provides stronger protections for warehouse workers is welcome news. As I testified recently before this committee, these protections are urgently needed in Connecticut. The warehousing industry is growing rapidly, and the Connecticut Department of Labor is projecting faster growth in warehousing than any other industry between 2022 and 2032. With a few clarifying amendments to this legislation and the closing of loopholes, this bill can be improved and will help to address the injury crisis facing these workers. As I testified a few weeks ago, the latest available government data on worker injuries in Connecticut show that warehouse jobs rank among the most dangerous in the state. With almost half of the workers in the sector working for Amazon, this company is responsible for the lion's share of warehouse worker injuries in Connecticut, and injury rates at the company's warehouses are rising. A recent US Senate investigation uncovered evidence that the company knows that its quotas and management practices are the reason workers are so frequently injured. Amazon even developed internal proposals to lower its injury rates. But the company ultimately chose not to implement them, which is why it is so important for lawmakers to establish external safeguards like the ones proposed in this bill. However, this bill requires a few important amendments. 5 states across the country have now adopted similar laws. In those states, Amazon has asserted that the laws don't apply to it by denying that it uses quotas. This bill requires an amendment to close that loophole by ensuring that the definition of quota captures the full range of quotas that are being used by employers like Amazon. This is also in line with federal legislation that was introduced in Congress last year. I'd like to raise one other urgent red flag for the language of the bill. The language on attorney fees in this bill is out of line with how Connecticut law currently treats low-paid workers and could jeopardize any enforcement if this bill becomes law. The language in the bill on attorney's fees is inconsistent with Connecticut law for in the area of minimum wage. And what this means is that it would allow, changing that language would allow warehouse workers to recover attorney's fees if they prevail in the case, but would not require them to pay the company's attorney fees if they don't. The way the bill is currently written, it is unlikely that a warehouse worker would ever be able to enforce their rights by bringing a case. Thank you for the opportunity to present this testimony.
Thank you. Seeing no hands, have a good day. Thank you for your testimony. Trying to see, I think she dropped off the call. Okay, up next we have Paul Amarone.
Good afternoon, members of the Labor and Public Employees Committee. My name is Paul Amarone. I'm a Public Policy Associate and Advocacy Manager at the Connecticut Business and Industry Association. I'm testifying on multiple bills before the committee today. I have submitted individual written testimony for each bill, but in the interest of time, I wanted to highlight some of our concerns and support. I will start with House Bill 6517, an act concerning disclosures of salary ranges on public and internal job postings. While some employers make the decision to disclose salary ranges and benefit information for open positions, requiring the disclosure of salary ranges for all vacant positions eliminates an employer's ability to adjust a position to suit a candidate based on a variety of factors. It also leaves employers vulnerable to competitors who may adjust their salary and benefit packages solely based on other businesses' publicly displayed job descriptions. Employers often operate in a fast-paced environment, often looking for ways to hire and fill openings as quickly as possible. Mandating a one-size-fits-all approach that may vary candidate to candidate based on experience and negotiations is not in the best interest of promoting a pro-business environment and filling open positions. We urge the committee to take no action on House Bill 6517. Moving on to Senate Bill 831, an act concerning advance notice of an employee's work schedule to certain employees. Businesses in the retail, hospitality, long-term healthcare, and food industries are rapidly changing flexible environments that rely on their employees working flexible hours, changing shifts on the fly, or adjusting shifts based on customer or patient demands. The unpredictable nature of these industries, notably in healthcare, makes it nearly impossible for employers to abide by the provisions of this bill, notably the 24-hour notice period of any changes to an employee's shift and the 14-day notice requirement of all scheduled shifts. We urge the committee to take no action on Senate Bill 831. Moving on to Senate Bill 1035, an act concerning limitations on the use of non-disclosure agreements. Creating new, repetitive in nature causes of action based on employer conduct that a current or former employee or contractor, as taken from the bill language, quote, reasonably believes to be a discriminatory employment practice, end quote, is overly broad, opening the door to unintended consequences or abuse of the law. Ultimately, the broadly worded language of this bill is based on subjective belief as to whether discrimination occurred, opening the door for disputes that are based on perceptions rather than clearly defined evidence, leading to costly and lengthy legal battles, employer versus employee friction, and potentially damaging employer reputation. We urge the committee to take no action on Senate Bill 1035. And finally, in conclusion, moving on to House Bill 6414, an act concerning minors who have reached the age of 15 working in retail stores. As the state's largest business organization, one of the most important pieces to our member success is workforce development and finding young, skilled workers to enter the workforce and establish a long-term career path. It's also important to note that expanding opportunities for 15-year-olds to work in retail settings can have a positive impact on the 119,000 at-risk youth that have been identified in Connecticut. This bill would open another avenue for at-risk youth to explore opportunities that can provide them with firsthand work experience while being compensated for their work. We urge the committee to support House Bill 6414. And with that, I'm happy to take any questions.
Representative Canino.
Thank you, Mr. Chair, and thanks for coming to testify, Paul. Just a quick question that I asked previously that I want to ask to you on the NDA bill. Do you believe that this would bar an employer from having certain confidentiality standards for their HR employees regarding some of these, harassment or discrimination cases?
Yeah, thank you for the question, Representative. Based on my interpretation of the bill, there could be employees who do work in an HR department who would be bound to the provisions of this bill. That could potentially open up employees who might have a complaint or an issue that might make them hesitant to bring that complaint to HR if that HR employee, whether they're a director or an HR coordinator, is not bound to an NDA.
Thank you.
Thank you, Representative. I don't see any other hands, so thank you for your testimony, Paul.
Thank you.
Up next, we have Scott Dolch. Shelley Davis.
Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, and Representative Weir, and members of the Labor and Public Employee Committee. Thank you for the opportunity to testify today in support of SB 1427, an act expanding paid family and medical leave insurance program benefits to certain school employees.
My name is Shelley Davis, and I'm the president of the Hartford Federation of Paraeducators, as well as the AFT Connecticut Divisional Vice President for PSRPs. I am here today to urge your support for paid family and medical leave for paraeducators and other school-related personnel. These dedicated professionals are the backbone of our school, yet many are forced to choose between their health, their families, and their livelihoods when facing medical emergencies or caregiving responsibilities. Paraeducators and school-related personnel provide essential service that directly impacts student success. They assist in classrooms, support students with disabilities, ensure safe transportation, and maintain school operations. Despite their critical role, many of these workers do not have access to paid leave, leaving them vulnerable to financial hardship during times of illness, injury, or family crisis. Without paid leave, paraeducators and other school-related personnel often return to work before they have fully recovered from illness, increasing health risks for themselves and those around them. Others are forced to leave their jobs altogether, leading to high turnover and staffing shortages that disrupt learning environments and place additional strain on educators and students alike. Paid family and medical leave is not just a worker's right. It is an investment in the quality and stability of our educational system. When school staff have access to paid leave, they can care for themselves, their families without fear of financial ruin, return to work healthier and more focused, and provide the consistency our students need to thrive. Moreover, providing paid leave helps attract and retain skilled, dedicated professionals in our schools. Many states and private sector employers have already recognized the value of paid leave and implemented policies that benefit both workers and the communities they serve. It is time that we extend these same protections to the hardworking individuals who support our children every day. I urge you to support legislation that ensures paid family and medical leave for the paraeducators and school-related personnel. By doing so, we uphold the dignity of our workforce, strengthen our education system, and create a more just and equitable future for all. Thank you for your time and consideration.
Thank you, Ms. Best. I do have a question just in regards to benefits for paraeducators, and I know that that could vary across the board. Can you identify or share what sort of benefits, if you can, that paraeducators currently receive?
So we have health insurance right now. We have HSA, which is very high. It's unaffordable. Thanks to the controller, they do get a little stipend back on that. But that's basically the benefit they have. They have sick days. You can get up to 20. We now have the 40 from Connecticut paid leave. But there are no paid family medical leaves for paraeducators. So if you don't have the sick days and something happens, you don't get paid. And that's the issue right there.
Okay, thank you so much. Senator Kushner.
First of all, I just want to thank you and all the people who serve as paraeducators for the work you do in our schools, because I've been in our schools, I've seen paraeducators, and oftentimes you're working on the most, helping to educate some of the kids who struggle the most. And it's not easy. It's very strenuous work. And I know that we've taken up many bills in the legislature to gain more parity in pay. I know we're happy with the passage of the help that you're getting now on the health benefits you just mentioned. Certainly the paid sick days that we passed last year and went into effect January 1 is a step forward. But I really appreciate what you're doing and hope that with the opportunity to participate in paid family medical leave, that when someone has a serious illness or when someone in a family has a serious illness, now they'll be able to afford to care for themselves or for their family members. And, I think it's been a long time coming, and just, I feel like this is something that's going to move paraeducators forward. So I hope that we're successful this year in doing this. And thank you for everything you do.
Thank you both as well.
Thank you, Senator Kushner. Seeing No other hands. Thank you for your testimony. We will move on to Greg Lockwood.
Distinguished co-chairs and members of the Labor and Public Employee Committee. My name's Frank Van Baca, and I also have one of my members, Greg Lockwood, who's going through a courageous battle with cancer right now. I represent IFF Local S15, which encompasses State of Connecticut firefighters and fire inspectors for Yukon, Bradley Airport, Air National Guard, CCSU, and DDS. I appreciate the opportunity to share our experience navigating the current cancer coverage system while advocating for one of our members. At first glance, the process should be straightforward. A firefighter diagnosed with a covered cancer should have their case treated as a workers' compensation claim, with the employer being reimbursed through the cancer fund. The firefighter should be able to focus solely on recovery and caring for their family, because cancer is not just a personal battle, but a challenge that impacts the entire family. However, the reality we faced was entirely different. From management to judges within the workers' compensation system, the responses we received was the same. We'd like to help you, but we can't. Even worse, our member was handed a bill to pay for his medical insurance for both himself and his family while he was actively undergoing chemotherapy treatments. To ensure a smooth process, we took proactive steps. We educated management and the state third-party administrator, Gallagher Bassett, about the legislation, providing clear guidance on how they could confirm the details with state and access reimbursement from the fund. We then facilitated a meeting with management and the treasurer's legal team with the help of UPFFA and President Brown to confirm the employer would be in fact reimbursed. Despite making the process as seamless as possible, we encountered nothing but resistance. Ultimately, we were forced to take the case before a worker compensation judge who echoed the same frustrating sentiment. I would like to help you, but. The final blow came just 2 weeks before Christmas when our member, Greg, received a notice demanding payment for his insurance, along with the news that he would not receive his paycheck for the previous month. To make matters worse, his shifts had been covered by fellow firefighters, yet management refused to honor those shifts after they had already been worked. We had to take extraordinary measures by reaching out to the media, which thankfully WFSB ran the story to garner awareness for our dire situation. Through relentless pressure from the UPFFA, our local and public outcry, we were able to ensure our member was not only made whole, but was able to focus on his treatment and hopeful recovery. But this victory was secured on the basis of goodwill and pressure, not on clear, enforceable protections. The next firefighter diagnosed with cancer may not be as fortunate. What is needed is unequivocal language and guarantees coverage for all firefighters without the ambiguity of whether they are a state or municipal employee or a volunteer employee for that matter. A diagnosis from a physician should automatically secure their battle. Additionally, in the event of a dispute, worker compensation judges must have a
Sir, your
clear
3 minutes are up. Please summarize.
jurisdiction to make binding decision and enforcing them. Thank you for your time, and Greg would love to answer any question you members have.
I'd like to just pass the microphone back to you to complete your summarization of what you have written before you, but I also want to give you an opportunity to speak to your situation, and thank you for all that you've done.
Thank you, Representative. I'm actually finished, but I would love for you to hear Greg's story and all the battles that he has gone through.
Thank you. Greg, please.
Oh, thank you, sir. So September 6th this past year, I got diagnosed with colon cancer. Through our insurance and everything like that, I was able to get in, get the care that I needed to get moving. but obviously I was gonna be out of work for quite a while. So about 4 weeks after my surgery, we started going through the treatments. My brothers and sisters at the firehouse covered us. We're gonna work it on swaps, as they say, which is basically loan time. And 2 weeks before Christmas, I was told in fact, that was not going to be allowed. We don't have, you're not going to get paid. All the work that my brothers and sisters did is also not going to be paid. And by the way, you got to come up with a bill for your health care. So I went to my representatives and the union, UPFA, and they have been absolutely amazing through this whole process. And we were able to kind of leverage the situation to make sure that I was taken care of. But the main part of this is we need to make sure that no one else has to go through this process the way I did. They dispute over whether it's municipal or state firefighters, volunteers, whatever it may be. This has not been a pleasant process, and I really would like to make sure that anybody that has to come behind me doesn't have to do what we had to go through. Thank you.
Thank you, Greg. Senator Kushner.
I'm sorry that I had to step out for a moment. And unfortunately, I didn't get to hear all of your testimony, but I am familiar with your situation and with the reasons why we are amending this very important law. And I appreciate you being here today. When we passed this bill a couple of years ago, when we enacted this law, it was fully our intention that it would be there for you and for others in your situation. So the fact that it hasn't been a smooth process, was an oversight, unintended. And I'm sorry you had to go through that, because I know from my own family experience that the last thing you want to deal with when you're dealing with cancer is the bureaucracy and the hassles of being on the phone and having to call people and having to spend that time. I've been through that with my brother, and I know it's really not what we wanted for any of our firefighters or for anyone. So appreciate you bringing this forward and being willing to share with us your personal story. Thank you.
Thank you, Senator.
Seeing no other hands, thank you both for your time and testimony today. Up next, we have Jason Diaz. Gentlemen, if you'd like, you can sit around here if there are questions of you all, but you can stay back there if you'd like to. No worries. No problem. Jason, could you hit the button so we can get you on the record? Thank you, sir.
Dear chairs and esteemed members of Labor and Public Employees Committee, my name is Jason Diaz, and I'm a lieutenant with the Hartford Fire Department for 17 years. And to my right is Captain Desiree Dingle. We both came on together 17 years ago, roughly, right? Today we're here, we rise for firefighter Barbara Gallo, who's recovering from reconstructive surgery, and Captain Dingle is gonna read her testimony. I did submit a written testimony, a short one, unlike Jeff's, last night, but you can read that, very short, but Captain Dingle will read firefighter Barb's testimony.
Good afternoon. My name is Marisabel Barbagallo, and I'm a firefighter who was diagnosed with stage 2B breast cancer in January 2024. Thanks to the Connecticut Cancer Bill for firefighters, which was passed in October 2023, I was able to obtain the necessary coverage to support my treatment and recovery. From April 2024 through January 2025, I was unable to work due to my illness. Despite meeting all of the qualifications outlined in this bill, I had to seek legal assistance to ensure my continued coverage during this challenging period. The relief and financial support provided by this bill were invaluable, alleviating a significant burden from my family during a time of immense physical and mental trauma. I am profoundly thankful to the state of Connecticut for passing this crucial legislation. However, I am deeply concerned about the potential depletion of funding for this bill. As firefighters, we willingly face the inherent risks of our profession, including exposure to carcinogens. The possibility that our coverage might be compromised, despite our best efforts to maintain our health, is a source of great anxiety. Cancer does not discriminate, and it remains the most significant threat we face in our line of duty. The Connecticut Cancer Bill is not just a financial safeguard. It is a testament to the state's commitment to protecting those who protect its citizens. I urge you to ensure that this bill remains funded and continues to provide the necessary support for firefighters who risk their lives every day. Thank you for your time and consideration. Marissa Bell Barbagallo.
Thank you for your testimony. For 1 second, please, could you just restate your name for the record and the spelling of your last name?
Oh, yes, of course. It's Desiree Dingle. And do you need the spelling of it as well?
Yes, please.
Yes, DESIREEDINGLE.
Thank you. I will move on to questions or comments. Representative Hughes.
And I point out that's Captain as well.
Okay, Captain.
Captain, thank you.
That goes first. Sure, absolutely.
Thank you, Mr. Chair. And for the record, is firefighter breast cancer covered under this bill, or it was just a lot of hoops to get that
Yes,
kind
it
of?
is covered, but with firefighter Barb's situation, she and the city had to sign a stipulation agreement because of the language that we're trying to correct today.
Great, thank you. I just wanted that for the record to be clarified. Thank you.
Seeing no other questions and comments, thank you for your testimony.
Thank you.
Up next, we have Jose Miranda. There he is.
Thank you, honorable chairs and distinguished members of the Labor and Public Employees Committee. My name is Jose Miranda. I'm the political director for 32BJ SEIU, and I am providing testimony in Rochelle Palaci's place, our state director. We, 32BJ, represent over 4,500 members here in the state of Connecticut in the property service industry and over 175,000 workers throughout the East Coast. On behalf of our members, I urge you to pass Senate Bill 831, an act concerning advance notice of an employee schedule to certain employees, which would offer long overdue protection to working families from employers' abusive scheduling practices. Currently, too many hour workers contend with inconsistent and unpredictable scheduling practices that negatively impact their income, caretaking responsibilities, educational pursuits, or other commitments. Unpredictable scheduling wreaks havoc on Connecticut workers' health and economic security, placing undue strain on those who are already struggling. On-call practices force workers to remain available for work without any guarantee of compensation. Meanwhile, employers' ability to call off employees at the last minute shorts workers of their wages they had counted on, and can also erase the benefit of a pay raise. More than half of low-paid hourly workers say that they have little or no say on those numbers of hours they work or the timing of those hours. A third of workers in retail and food service jobs reports that they could have been required to open the morning after a night when they had closed, known as a opening. Denying workers of sleep and complicated caretaking responsibilities. A working parent who does not know their schedule until the day of a shift can't schedule a pediatrician's visit or secure childcare. Workers can't budget for household expenses when they can't count on working the shifts that they had planned on. And workers can't effectively pursue a degree when they may get scheduled to work during a class time, or when they have last-minute shift cancellations that means they're out of the tuition money. Abusive scheduling practices are concentrated among already vulnerable hourly service and low-wage workers who are disproportionately women and people of color. As of 2015, in Connecticut, 77% of Latino workers and 76% of Black workers held jobs that were hourly. Women in Connecticut hold 62% of low-wage jobs. Research on shift patterns for service workers during the pandemic found that compared to white men and women, women of color were 15 to 30% more likely to experience canceled shifts, on-call shifts, and involuntary part-time work. As a state with the third largest wealth disparity in the country, Connecticut has a clear responsibility to address abuses and disproportionately affect low-wage workers and workers of colors. A growing number of states, localities have already taken action to combat abusive scheduling, and in the submitted testimony, those are listed. Scheduling laws have been shown to boost industry conditions over time as employers come into compliance with the requirements. Several studies on the effect of policies in Emeryville and Seattle found that the Fair Workweek laws improve workers' well-being and financial security. These examples demonstrate the profound differences that the legislation like this bill can make in providing protections and recourse to workers who previously had none. Predictable scheduling is a necessary step for our state to take in addressing inequality and ensuring that all workers' peoples have a voice and dignity in their workplace. I urge you and the committee to stand with the working families of Connecticut and pass Senate Bill 831. And I open any questions you may have.
Thank you, Jose. Any Questions, comments? Representative Hughes.
Thank you, Mr. Chair, and on behalf of Rochelle. The pushback we get from this bill is that employers can't afford to give predictive scheduling. What's your response to that in your experience?
You know, I view it from the side that, you know, for at least for our employees for a long time through the pandemic, we're saying, hey, we don't have that, we can't afford it, that we don't have the flexibility to be able to pay. But, you know, business has increased during that span time. However, that relying on less workers with, you know, giving more and squeezing more out of the workers has not changed since, even though business has increased since then. So I would say that there is some flexibility there. And this, as you know, as a new parent myself, I know that being able to, you know, stuff comes up as a parent, and having that predictability is very important in being able to provide for your family. So I would say that there, you know, the increase in business doesn't illustrate that there's no flexibility there on their behalf, on the employers.
Senator Kushner.
I just want to thank you for your testimony here today. Obviously, this has been a tough bill for us. We've raised it in previous sessions. We've gotten it out of, at least out of the Senate. And I think it's something that's really hard to imagine the difficulty of the people you represent, the people that are working frequently in low-wage jobs, of managing childcare, of managing, you know, doctor's appointments, of trying to figure out how to really get to work when their schedule is changing with so little notice and no compensation. So thank you for being here again this year. And in past years, you've done some great work, your organization, in making sure that we're addressing the needs of, you know, these hardworking folks here in Connecticut. So thank you.
Thank you, Senator Kushner. And if I can just say, you know, when I started with the union, it was as an organizer position, and I got to talk to many of those workers who often told me, you know, these are people that are struggling to make ends meet, and, you know, every hour that they work counts. And they would tell me often, like, look, I had last week, I was supposed to work 20 hours, but they gave me 16 or 14. And that's a huge difference in some of these, you know, cases. And many instances where they were saying, hey, I was told yesterday that I couldn't come in today, or you know, the day before, that they were scheduled last minute. Again, when every dollar that they make and every hour that they work counts, it's a huge difference for them. So thank you for all that you do, and hopefully we can make it across the finish line this time. So thank you both.
Thank you.
Thank you, Senator. Seeing no other hands, thank you for your testimonials. I do see that we have Scott Dolce. So we will go back to you.
Can you hear me, guys?
Yep.
Hey, I apologize of not being there in person. As you guys can see, I'm in the Yard Goats conference room. We just had our culinary high school competition here, just finished up. So I apologize I can't join you guys in person, but thank you for giving me the opportunity here. Good afternoon, Senator Kushner, Representative Sanchez, Senator Sampson, Representative Weir, and members of the Labor and Public Employees Committee. My name is Scott Dolce, and I'm the President and CEO of the Connecticut Restaurant Association. On behalf of Connecticut's 9,100 restaurant and food service locations, I'm here today to oppose Senate Bill 831, an act concerning advance notice of an employee's work schedule to certain employees. This restrictive scheduling bill would negatively impact restaurants and small business owners across the state. Proponents of the bill argue that it will only impact large companies outside of the state, but this is untrue, as the vast majority of our franchise owner-operators are small businesses who live and work in Connecticut. Some of these franchisees have fewer than 30 total employees, but would be included in this legislation simply because their franchise brand has more than 30 locations globally and more than 500 employees. Additionally, this legislation would harm a key dynamic of the restaurant industry that currently works for employers and employees alike. The restaurant industry is known for this flexibility. In fact, many employees choose to work in restaurants specifically because of the flexibility that it allows. Managing or working in any restaurant is, by its nature, fluid and often unpredictable. Dinner reservations or events are added or canceled last minute. Weather forces restaurants to close or remove outdoor dining. Employees call out last minute and their shifts still need coverage. These are just a few of the many examples that make on-call scheduling an essential aspect of the hospitality industry. SB 831 would create a one-size-fits-all proposal that would be unworkable burden for all businesses that fall under the bill's definition of employer. Requires them to post work schedules 14 days in advance with little to no opportunity for changes. This would result in understaffing, eliminating shift swapping, and reducing on-call opportunities. All changes that harm employees as much as the employers, negatively impacting the very people that this bill is seeking to help. The current system does work, and it works for both the employer as well as the employee. I urge the committee to reject this proposal, and I appreciate the time today and allowing me to call in, and I'm happy to answer any questions.
Thank you for your testimony. Representative Canino.
Thank you, Mr. Chair, and thank you, Scott, for your testimony. I just wondered if you could speak to some of the cost increases that you've seen among your members in the past couple of years, whether from just the economy at large or imposed by the state of Connecticut, and speak to the margins that some of your franchisees are operating under and how this would impact that.
No, it's a great question. I appreciate it. I think most of you guys know I've been up here in front of the committee understanding our industry works on razor thin margins. The average restaurant works on about a 3 to 5% profit margin, one of the lowest margins of profitability in any industry, and everything affects that. And you guys can imagine it comes down to right now. I just did a study with the National Restaurant Association that we're seeing the rising costs are averaging anywhere between 28 and 30% across the board since COVID. So that is labor, utilities. We can have conversation about insurance, leases. Everything is food costs. We didn't even get into the tariff conversation that you can have. So our industry is constantly faced with rising costs across the board. And I think the last thing a restaurant wants to do is increase their cost to the customers. But they also have to worry about breaking even and being in business. And that's my worry as you start to look at pieces of legislation like this, that it can affect how they run their business, affect the employees, could potentially put these businesses out of business. And then there wouldn't be an opportunity to have the employees that we hope to have in hospitality, looking to grow that number, which is just south of 150,000 employees in the state. We want to see that number continue to grow. We are about 10% of the state's workforce. And that is why obviously we're opposed to this legislation.
Representative Hughes.
Thank you, Mr. Chair, and thank you, Scott, for coming before us. You've seen this legislation, a couple of sessions now. What would your solution be to last-minute disruptive scheduling changes, if not this bill? What would you suggest that the industry could do to make scheduling more predictive, especially for those parents with young children, or basically anybody who's trying to juggle a bunch of responsibilities?
Well, thank you, Representative. As I've said and been here, I want to continue to have conversations. I don't think this specific piece of legislation works. I think, the one thing, like I mentioned in my testimony, my worry is really those franchisees, and understand that, there's so many brands that are coming out, that someone could be like, hey, I want to start that in Connecticut. I'm only going to buy one. I'm going to have my own LLC. I have to pay into the franchisor to own and operate and put that. And so, making sure that they are being able to run their business very similar to other businesses. A lot of people will say to me, oh, well, this doesn't affect your whole industry. Well, any little bit can have a huge effect. And I want to make sure we're protecting all facets of the industry. But I also understand that scheduling and changes to schedules happen. And with technology and with everything that's happening, most, if not all, restaurants are well into that 2 weeks beyond posting their schedule. The concerns I have with this piece of legislation is more on the penalties, and really there's no protections for the employer. The employee can do a lot of things as you read this piece of legislation, but there's nothing for the employer. Even if someone calls out sick or things like that, they would have to then in turn find another employee, but there's potentially paying them time and a half or other concerns. Or also when they meet with somebody ahead of time, they think they know what their schedule is going to be, but also at the same time, there's penalties written in if you're not, holding to that standard you had with your employee that you hire. And I think that restaurants, as you guys all know, change every day. I was just talking to a restaurant this morning that was here judging the culinary competition. They had one of the worst Februaries they've had in the 7 years since they've been open. They don't know what tomorrow is going to bring, and they don't know how to, they're going to have to move on the fly and change and affect. And that's really that potential lack of of opportunities to change and make sure it works is what concerns me in this legislation. I think that wanting to work to make sure it works for both the employee and the employer is important with pieces of legislation like this, but also know, Representative Hughes, that scheduling is something that our industry lives by, and the flexibility that it adds, being able to have the on-call, the opportunity, that is something our industry, not just in Connecticut, but across the country. And I would just say, I'm happy to continue to work with this committee, continue to talk about ways to find a solution, but I do not think that this piece of legislation is that.
Thank you. Thank you, Mr. Chair.
Thank you, Representative. Hands. Scott, thank you for your testimony.
Thank you.
Up next, we have Bridget Quinn.
Sorry,
You're good to go.
my first time.
No, it's fine. Welcome.
Good afternoon, Chair Kushner, Chair Sanchez, and members of the committee. My name is Bridget Quinn, and I'm the Legislative Director for Teamsters Joint Council 10 New England. I just want to thank you for the opportunity to come and testify before you today. So Joint Council 10 New England represents 53,000 Teamsters across 6 New England states and 21 locals. So our Connecticut members, as you well know, represent work in municipal work, are police officers, brewery workers, professional drivers, freight workers, nurses, school bus and transit workers, home and heating fuel drivers. So I really want to thank you to testify today in favor of Senate Bill 1254, an act establishing protections for warehouse workers. And first and foremost, we really want to thank Governor Lamont for his leadership in filing this legislation and acknowledging the importance of protecting warehouse workers in the state of Connecticut. Just a couple of weeks ago, I think you heard a letter testimony from our Connecticut Teamsters in favor of Senate Bill 8, which is an act concerning protections for workers and enhancements to workers' rights, which really speaks to the immediate need to hold large warehouse employers accountable for using unfair secret quotas to discipline workers and forcing employees to work in unsafe working conditions that cause serious injury. And you're going to hear from 2 of our members of Local 671 who are back, Lawrence Sanchez and Roderick Medina are right over there. And they'll go into a little bit more detail about the experience that they've had at their employer, with their employer. And so we know that Amazon is one of the largest there's like top 5 warehouse employers in Connecticut, and Amazon has 43% of the workforce. And unfortunately, warehouse workers in Connecticut, especially those who are employed by sophisticated companies, are experiencing serious injuries at high rates compared to the rest of the private sector. In fact, the Bureau of Labor Statistics data show that injury rates in the 2 industries with the most warehouse workers, so that's warehousing and storage and courier and messengers, rank 1st and 3rd in the state among other industries, and far higher than other private sector jobs in Connecticut, like construction, manufacturing, and transportation. Warehouse work is a dangerous job. And we need to make sure that we're doing the very best to protect workers and making sure they come home to their families. Connecticut Amazon workers report being injured at a rate of 6.7 injuries for every 100 workers. And that rate has slowly crept up from 6.4% in 2022 and 6.3% in 2021. And so this is the equivalent of 1 injury for every 15 workers, which is more than double the rate of private sector workers in Connecticut. The overwhelming amount of these injuries which are classified as what we say serious injuries, meaning they're severe enough where workers could not continue performing their normal job duties and had to either be transferred or take time off to recuperate from their injuries. Among the largest 5 warehousing and logistics companies, Amazon workers' injuries are most likely to fall into this category, with 96% of their total injuries reported in the serious nature category.
Ms.
We're
Quinn,
really
your time is almost up. Please conclude your remarks.
Sorry. We're really excited about working with Governor Lamont and his team to pass this legislation, and we would like to recommend 2 tweaks to we really solidify and specify our language around quotas, because we want to make sure that Amazon is following the law, that we're really holding their feet to the fire, and as well as making sure that things relevant to attorney's fees, that no worker coming forward should have to pay for attorney's fees.
Thank you. Representative Weir.
Hi, good morning. Thank you. Or it's good afternoon. Thank you for your testimony. I have heard a couple times today in terms of the injury rates in the industry, and you just caused a question. Are we comparing warehousing in general to the rest of the industries, or are we comparing the large warehouses, the Amazons to the rest of other industries? Through you, Mr. Chair.
Oh, sorry. Oh, okay. Sorry. Sorry. We're comparing warehousing to other industries. And I can send you the list of statistics that I'm quoting from in my testimony, if that's helpful.
That would be through you, Mr. Chair, that'd be very helpful, because what I think I've heard, and I want to be clear, I've heard, large warehousing and, Amazon compared to other industries. And I would like to know what are the rates across the board, if we have that data on warehousing as a whole, small, large, medium, however they're classified, as compared to other, and also to see, is Amazon and are these larger warehousing operations, are they out of line or in line with the rest of the warehousing industry as a whole? So that's what I'm looking to see. Is this a warehousing thing, or is this an Amazon thing? So thank you.
I think it's both. And I think that Amazon, the injury rates that workers are suffering at Amazon outpace the other large warehousing employers.
Senator Kushner.
Thank you for the testimony today. I just have a quick question. I think that at the end of your testimony, you mentioned that there are a couple of tweaks to the bill. Is that included in any written testimony?
Yes, it's right here.
It is, okay. Because I think we'll want to take a close look at that. And if it's something that we agree should be in the language, we can make that change prior to voting it out of this committee. But we'll want to work closely with you to make sure we're getting it right and addressing it in the way you intended it, if we're in agreement, obviously. So that would be helpful. And in terms of the injury rates, I did hear recently, at least Amazon was saying that their injury rates have gotten better. But what you quoted today seems to suggest that it hasn't gotten better. In fact, it's getting worse. Am I correct in that?
Yes. And those statistics are from the Bureau of Labor Statistics.
So this is self-reported data.
Yeah.
By Amazon. And we know, because we have heard on Senate Bill 8 and the 2 companion House bills, we did hear testimony from some of the folks that I think are going to be here later, that this isn't strictly Amazon that is applying these kinds of injury-producing quotas. It's using those because we know other warehousing companies are using the same kind of production quotas that cause people to have to speed up to the point where they're being injured. But it is interesting to contemplate why Amazon might be higher than other warehouses, which I think is what Representative Weir was asking about.
Absolutely.
And if you have any data on that or even any thoughts on it, we'd be happy to entertain that.
Great. Thank you.
Thank you.
Thank you, Senator Kushner. Senator Cabrera.
Thank you, Mr. Chair. Thank you for being here today, and thank you for your testimony. I have a quick question because, I know I share, and I think other people in the committee too share, things have gotten so much quicker in our economy, right? And I think seeing the proliferation of warehouse work, accompanying that makes sense. I'm wondering if you're seeing anything in terms of a trend line. Do you expect warehouses to become more common, say, in the next 10 years as we roll out things like auto AI, as our people tend to buy more and more stuff online, which is at an all-time high now? Do you see anything on the horizon? Why legislation like this would be so important to set a parameter?
I think that this is, warehouse industry is an ever expanding industry, and we're going to see more and more, certainly growth. We want to make sure that we're protecting the workers who are working in these warehouses, who are working their very best to get the goods delivered to the folks who need it, essentially. And we want to make sure that they're not forced to work, to achieve sort of a goal that they don't know exists, and to achieve a quota that they don't know exists, and then get hurt on the job because they're trying to achieve some, secret quota, and then they're out of a job. We want to be able to protect those workers. And then, our members want to get the goods and the services delivered to the people that they, the customers, end of story. They want to fulfill their job, but we should not be asking workers to fulfill their job and get hurt doing that.
Thank you very much for that response, and thank you for testifying here today.
Thank you, Senator.
Thank you, Senator Kushner.
So the bill that, and I'm more familiar with SB 8, but I will check in with the governor's folks as well. The bill does not include the drivers that are, this is specific to the people who are packing the boxes and preparing them to be delivered by truck drivers. I know your union represents a fair amount of truck drivers in the United States, and I am interested, it has recently come to our attention after we raised this bill and got a little more public attention drawn to it again, that in many cases, there are third-party companies that are providing the drivers that do the delivery services. There may also be independent. Amazon may directly be contracting with folks that they consider to be, or that they're classifying, I should say, as independent drivers. And I don't really want to go to the question of independent contractor status and versus employee status, but I do want to know if you have any information. We're hearing from folks that have had that job that it's just as demanding with production quotas, with the strains and the stresses and the injury rates that the folks inside the facility are experiencing. And I wondered if your union or if the folks you've been working with have done any exploration in that area as well.
We're definitely hearing the same things that you're hearing in terms of their injury rates. And we also know that because those injury rates are not tracked in terms of what I just quoted from the National Bureau of Labor Statistics, because third-party employers are used. And so we know anecdotally that, yes, the injury rates are also high, but those statistics aren't included in what I cited earlier because they're third-party vendors.
We also heard,
unfortunately.
I heard from one person who had a family member employed as a driver, and it was a young person who had a really hard time, young, healthy person who had a really hard time in that job, that the other aspects of it, not just the injury, but the fact that these production or these quotas that are set, in this case, for drivers, that they're such that people have to run from the truck to the porch to make the delivery, that people are, not taking bathroom breaks, not taking lunch breaks because they won't meet their quotas. And then similarly, not even knowing necessarily what the quota is. So it is something I think we need to look at. I don't know that we'll do it in this bill or in this session, but I would thought since we had an expert up here, we could ask you that question. So thank you.
Thank you. And thank everyone on the committee for your leadership and your support in making sure that we're keeping our workers safe in Connecticut.
Thank you.
Representative Canino.
Thank you. And I just had a question pertaining to the secret quotas that were mentioned before. Because what we've heard, time and time again, is that an individual might get one quota when they're hired, and then it might change daily or hourly. But this is the first I'm hearing of a secret quota. I was wondering if you could expand on that a little bit.
So the quotas are not divulged to employees upon hire or any time when they're working there. And so that's part of the issue, right? Is employers should be telling their employees, like, this is what you need to achieve. This is what it means, a job well done. And Amazon and other employers simply do not do that.
Representative Canino.
Thank you. And just one more question. I was just wondering how the correlation between the quotas and the injuries was arrived at. I mean, it was noted before that Amazon is not the only company that uses these quotas, that there are other companies that use these types of quotas, and they have very disparate injury rates across those companies. So I was just wondering, where that correlation is drawn and what kind of data led to that conclusion.
I think if you're constantly working at a warehouse and doing that type of work, and you're trying to achieve, get the order and get it fulfilled, that the repetitive use of your body over time will simply cause you to have more repetitive injuries at higher rates.
Thank you, Representative. Senator Kushner.
The question about secret quotas reminded me of previous testimony we had about Amazon in particular, and I believe it was Amazon, where you might be disciplined or discharged if you fall in the lowest 5% of production. And I think that's what we heard in one of our previous hearings. So I don't know if you're familiar with that practice in Amazon. If you are, if you could elaborate on it, would be helpful.
So Amazon and other companies use their quota system to discipline or terminate their employees. And again, which goes to the fact that they're not disclosing what these quotas are to the employees. So you never know really how you're doing. And then imagine one day you're working really hard and you're working, 60, 70 hours a week, and you get a text on your phone saying that you've been fired and you thought you were doing a good job. But that is how, unfortunately, some of these companies are operating.
Thank you, Senator. I don't see any other hands. Thank you for your testimony.
Thank you.
Up next, we will have Timothy O'Flynn.
Good afternoon. Thank you for providing me the opportunity to present my support for two bills. The first one being my name is Tim O'Flynn, and I reside in Milford, Connecticut. I'm an attorney with Ferguson, Doyle, and Chester, and we're general counsel to the Uniform Professional Firefighters Associations of Connecticut. But I'm also an active member of the Stratford Professional Firefighters, IFF Local 998. And I'm here in support of two bills, the first one being SB 1426. This bill, otherwise known as the cancer bill, is to make a couple of corrections, so to speak. Is that one, the Workers' Comp Commissioner has taken a stance that Workers' Comp doesn't have jurisdiction over this language, even though the employee needs to file a 30C. There's a box on there that the statute references Workers' Comp. So we need that jurisdictional to be clarified so that we can now have administrative judges start adjudicating these claims. The other thing is somewhere in the mix of this bill getting passed, skin was excluded in the new bill. However, if you look at the funding statute that's still in place, skin's still there. So it's something that just got an oversight or lost in the shuffle, and it's just supposed to correct that. And the other bill that I'm here for is HB 5609, an act concerning retirement benefits and workers' compensation benefits. I support this bill because it will have a positive life-changing effect on my brother and sister firefighters in Stratford, and it will protect other public employees from an unjust loophole that punish them for getting hurt at work. The reason I'm specific to Stratford firefighters is because this bill originates from what is currently happening to two of our members that are receiving workers' compensation wage replacement benefits, both of which have more than 20 years of dedicated service to the town. These members have been out on workers' compensation for over 2 years and have recently requested to receive the retirement estimates for a disability pension, which were extremely low. They are actually approximately $16,000, and the other one was $28,000. And to put things in perspective, I looked up the 2025 federal poverty level for a household of 3, which is 26,650. The reason these numbers are so low is because their workers' compensation wage replacement benefits were not calculated into their pension based on the town's interpretation of our pension agreement. This interpretation has highlighted a potentially great defect in pension calculations and penalizes an employee for getting hurt at work, which in my opinion is against public policy. I support this bill not to settle a contract dispute, but to right an unjust situation that currently is having an immediate impact on 2 of our members, and if not remedied, has the potential to be exploited by other public employers. I understand that pension calculations can be a hot topic subject, and this is also in rebuttal. I have read some of the opposition to this. This bill is to fix an unjust calculation that creates a windfall for a public employer on the backs of injured employees. Passing this bill should not create an unfunded mandate for future pension calculations because workers' compensation wage replacement benefits are based not on an employee's actual weekly wage, but an average for the previous 52 weeks from the date of their injury, a rate that is also capped by statute. So if an employer includes workers' compensation wage replacement benefits, an employee's pensions calculations will not be inflated, but in fact more on par with their base pay. This also does not create any sort of double dipping because these are wage replacements. The employee is not receiving their full salary on top of these benefits.
Mr. O'Flynn, your time is almost up. Please
Okay.
conclude your remarks.
If workers' compensation wage benefits were calculated into the 2 members' benefits, I can safely say that they would have a reasonable pension more in line with base pay and allows them to retire with dignity. If not remedied, I foresee these 2 members' unfortunate situations having an undesirable effect on other public servants, especially those in dangerous jobs. When faced with a dangerous or life-saving emergency, you want your public servants focused on the task at hand and not thinking, if they get hurt doing this, will they be able to provide for their family? If they get hurt, will their employers support them, or will they lose their injury to reduce their earned benefits? And if they get hurt, will they or their family be destined for poverty? Thank you for your time.
Thank you, Representative Shea.
Thank you, Timothy. Thank you, Mr. Chair, for acknowledging me. I want to say thank you for providing such detailed perspective and facts in relation to definition of terms and the implications of, unfortunately, there are bad actors out there. There are employers out there who unfortunately utilize loopholes, and in a profession of public safety for firefighters, police officers, public service workers, where we want to make sure our intentions are that we are attracting, retaining, and taking care of our workers here in Connecticut. And the intention of this bill is to help protect workers so that they are able to retire with dignity for benefits that they have also paid into for 20 plus years. So I appreciate the extensive research and background that you provided in your testimony and appreciate your service.
Thank you.
Thank you, Representative. Senator Kushner.
Thank you for coming here today. And when we get to talking about workers' compensation and pensions, I have noticed that a lot of us glaze over. Unless we've had some personal experience with it, we're not typically real familiar with particularly workers' comp, but also, many people in this building have not yet retired.
Right.
So they don't even necessarily really fully understand the retirement benefits. I think it's very helpful if you could really, again, just lay out for us. So the 2 firefighters that we're discussing, and I realize we're talking about something bigger than 2 people, but it gives us a good case study in what the problem is. Those 2 firefighters in each case, how long have they been working as firefighters?
One firefighter is over approximately 22 years, and the other one is 25 years. And actually, the employee that has 25 years of service is eligible for what we call superannuation, which is a normal retirement or retiring, you hit your X amount of years of service. And that wouldn't solve this problem either, because based on the calculations, it looks back in Stratford specifically, it looks back your last 2 years. So these wage replacements wouldn't be calculated in there. So the only difference would be that he possibly could have a higher percentage, but it would, since it would not be a disability pension, it would be subject to tax also. So this is something that could affect anybody. Oh, I'm sorry.
You're going kind of fast for us. You're
I'm
so
s-
familiar
I'm-
with all
I'm
this.
sorry. I'll try to
But-
slow down.
So essentially, but just going back to the person who's got 25 years of service as a firefighter, in many cases, fire and law enforcement have the ability to get full pensions after 20 or 25 years because of the nature of the work. So that is not considered an early retirement
No.
in those cases. So that's just, I wanted to make that as a starting point. We're not talking about people who are retiring early. We're talking about people who would typically be retiring in this particular occupation. That was the first thing that I think is important for people to realize. And then when a person's on workers' compensation, are they receiving full wages?
No, they're receiving wage replacement. So the way the workers' comp statute works is that they look from the date of injury, and then they look back 52 weeks of your average weekly rate, which is any job that you had in those 52 weeks. And then they come up with an average, and it's approximately 75%, but that number itself is also capped. So if, say, you had an individual that had particularly high overtime in those previous 52 weeks, that's not all factored into this. It's capped by statute of how much that they could receive. Now, some contracts throughout Connecticut do provide for a make whole remedy, where since you're not collecting your full rate of pay, that it may be supplemented with sick time or something else where you get made up to 100% of your base pay. In Stratford specifically, I can tell you that that's only good for 1 year. So these people's numbers, for only 1 year out of the 2-year calculations, they're only essentially having that 1/3 pay calculation or 25%, and then any pensionable cash outs. So that's why the numbers are so low.
Before you go to pensionable cash out.
I'm sorry, yes.
Going back to, so essentially what is happening is that they're not even considering the workers' comp pay. Let's say you
No.
didn't get any additional pay on top of that. You would not even be getting this credit for
Correct.
the 75% of your earnings that you were receiving from workers' comp. They're only count, if you were in a position to receive the, almost like a top up or a top off, or, the difference being made up by a cash payment from the city because of your accrued sick time, that's all they would be counting towards your pension calculation.
That is correct.
So essentially, somebody who could have worked for 20 years without any time off, without any injury, when you do the pension calculation, which I think you described as being your average earnings over the past 2 years,
Yes,
in the last 2 years of
the
employment.
previous 2 years
Previous
prior
2
to
years
retirement.
prior to retirement. So this is why, instead of getting a payment that might have been $50,000 or $60,000 a year, you have somebody getting 16,000, or I think that was one of the examples. And I think it's really important for us to understand this impact. So for all those 20 years that the person was making $60,000 or $70,000 a year or more, 80 or 90,000, they're not getting any credit for all those years because they were injured in the last 2 years
Correct.
when the calculation was being made.
Correct.
And I know we are going to hear from representatives of the city of Stratford a little later in this public hearing. I think it would be really helpful to us. We won't bring you back up to, this isn't a debate, but it would be helpful if you're available. We may have questions. They may raise some issues that we haven't considered.
Absolutely.
But thanks for your explanation. It is complicated. And these guys know me. They know you have to explain things like 6 times to me to begin to understand what you're talking about. And I actually do get a pension. So at least I know that part of pension calculation.
No, it's a very confusing process. And most people don't understand these things until they actually go to retire and they start looking at, the numbers and all those things.
Thank you, Senator. Representative Weir.
Thank you for your testimony. And Madam Senator, I hear that a lot at home, that I have to be explained. That things have to be explained to me a lot, mostly at home. I try to be on my best behavior here. without making light of this, I just want to get a little better understanding of this situation because, you know, we hear an example of 2 people that were affected by this. I don't know how widespread, but you know, for now, I assume, you know, we're addressing these 2 specific people. I don't know if you can divulge, but what was the extent of the injury? Was this not something that they could, this is a permanent, not able to go? And I don't want anything, you know, proprietary, but I'm just trying to get. a
So,
handle for how this happened.
I guess I'll talk more of the workers' comp process. So, when you get hurt at work and you're going through the workers' comp process, and everything in workers' comp is doctor driven. So the doctors really dictate everything, if you can return to work, if you do return to work, what kind of restrictions, how long you need to be out. And everybody has a different recovery rate. So depending on the extent of the injury, you know, some people may recover in 6 months, or more extensive injuries or complications from surgeries could lead to somebody that is out for 2+ years while still recovering. And that's until they reach maximum medical improvement, or otherwise known as MMI. That's when the doctor is essentially saying, no matter what we do here, you're not going to get any better. So I don't believe that either of these individuals have reached MMI, but I can't speak to certainty.
Representative Weir.
And I think I can boil this into one question, but was this a situation where either or both of them decided to retire? Was this discussed up front, or did they put in their papers to retire and then found out retroactively, this is a huge surprise that, you know, geez, I thought I had this time booked and now I'm finding out that I have lost out on benefits I was expecting? Or did they put in their retirement papers knowing that, hey, I can't go back to work and I know I'm not getting what I expect to get, but this is the choice I'm making. I'm trying to figure out how that decision process went.
Yeah, it's very complicated. I don't think anybody actually plans on going for a disability pension. And in Stratford, these are the first 2 individuals in maybe close to a decade, maybe slightly under a decade. So it's in my tenure, we haven't had a lot of disability. I only know of 1. So it's not a decision made lightly. So I think they were caught off guard when they put in their numbers and they saw the shock of actually how low. And now that's why we're here today, is because this was highlighted. If we had known this, you know, earlier, we would have addressed it, but this is something that isn't right.
And finally, yeah, I'm not by any means taking this lightly or assuming that that anybody made that decision lightly, but I wanted to get a understanding of how the process in this situation went. It helped me follow along and my decision making and understanding of the situation. So it's fair enough. That's all I have.
I could just add on to finish answering. Also, when you go for a disability pension, again, that's doctor driven. So you may not be, 6 months in, you may not be anywhere close to thinking that you need to look at a retirement. It's usually farther along in the process. So it's a little hard to plan for based on your injury.
Thank you, Representative Canino.
Thank you. First question, when is the next contract negotiation that your union has with the city of Stratford?
So again, in Stratford, it's a little unique in the sense that in 2012, our CBA, our collective bargaining agreement, and our pension agreement are 2 separate documents. In 2012, we negotiated our last pension agreement, and it's essentially quote unquote locked out, as they say. The only way that it could ever be opened if both parties mutually agree.
Okay. Thank you.
You're welcome.
Thank you, Representative. Seeing none, thank you for your testimony.
Thank you. Thank you, everybody.
Thank you. Next up, we have Nelson Huang.
Good afternoon, everyone. Chair committee chair people. I'm sorry, this is the first time doing this, so I have to apologize. Representative Sanchez and Senator Kushner and members of the committee. Thank you for allowing me the opportunity to speak today. My name is Nelson Huang. I'm the president of IAFF Local 2687 in Hamden, Connecticut. I am here to highlight the urgent need to address delays in paperwork related to the cancer bill. First of all, thank you for passing this important bill. With the passing of this bill, it makes assurances that we will be taken care of. I've been a firefighter for 38 years, 17 as a volunteer. I just finished my 20th as a career firefighter for the town of Hamden. With that being said, I've been diagnosed with thyroid cancer, which I've beaten and gone into remission. And then right after that, I was diagnosed with lymphoma. So I have been battling with 2 different cancers. And I would like to tell the committee a little bit of my circumstances and experiences with filing paperwork. Thankfully, I'm in remission today. The Public Act went into effect on October 1st, 2023. On that day, I was able to file, but there was no direction from the state on how to file or submit the paperwork. It was clear from the standpoint of the UPFFA and Pete Brown's guidance on how to file, but no guidance from the comptroller's office. The town of Hamden had no clue on how to submit the paperwork. It wasn't until October of 2024, the town of Hamden submitted the first form to the state. I was just informed at the end of February 2025 that I had to fill out another form. Thankfully, I'm in remission and I can work together with the town to have my paperwork submitted. What if I was still undergoing treatment and had to have this on my mind also? Cancer treatment is difficult and someone should not have to go through treatment and have to worry about paperwork. Thank you.
Thank you. Representative Shea.
Thank you, Mr. Chairman. First, I want to say thank you for your extensive years of service and for everything that you have done. I'm very sorry that you have had to deal with, the lack of resources with someone who has a nursing background. It is always a struggle when workers become sick. And then if you are the head person responsible in your household, or if people don't have any family or networks to be able to help navigate the process. Just from hearing what you described, and I've heard it from other workers also across all labor sectors, do you think that it would be helpful if there was a caseworker or a social worker, some level of personnel within said organization or company, so that when in the event that, we become sick and we're trying to still get through the days and then try and make sure that the basic responsibilities and things that need to be taken care of in your household, your family, et cetera, would be helpful. Because my personal opinion, I think that it would be, if it's someone within an HR department in a municipal or private company, et cetera, to help workers so that when you're in that position, I mean, even when people, thank goodness we have paid family medical leave, but when you are the person that is sick or you have whatever the life circumstance, it's extremely difficult to try and navigate. And you have already overcome, persevered, and survived so much. I'm just curious if you think that that would be a suggestion, or if there's any other suggestion of how you would see this working more efficiently and effectively.
So on my experience with my cancers, I had treatment at Smilo down in New Haven at Yale. They offer caseworkers, and it is helpful. It would be great if there was clarity from the state to the municipalities on how and what types of paperwork need to be filed. There is a lot of confusion with, I can say the town of Hamden, they've been great. They've been trying to work with me. And I'm very fortunate with enough sick time that, that covered my illnesses. Going to your point of a social worker, I believe that would help, because I filed all the paperwork after my remission because I couldn't go through, worrying about paperwork and my treatments at the same time. Like I said, I was very fortunate with enough sick time, and the town of Hamden was very good to me. But I think that, social worker or someone in that position would help, where you wouldn't have to take the burden on yourself.
Senator Kushner.
I just want to thank you and Representative Shake for raising that question. Certainly something we ought to consider and think about whether having an advocate, like we have a healthcare advocate, we have a unemployment insurance advocate, we have people within state government who help constituents when they are having difficulty, get through the systems. I think in this particular case too, though, one of the added difficulties was that it was such a brand new program, and we wanted to get people enrolled immediately, even before we might have been ready with all the necessary systems in place that you discussed. But I totally understand what you're saying. I said earlier today that my brother suffered from cancer and fighting it, had real difficulty getting on the phone and just getting the things he was entitled to, even with social workers from, the oncology practice. It was much more about the bureaucracy of state government. It wasn't the state of Connecticut, so I'm not shining any lights on the state of Connecticut, but I think it's the same thing. It's just really hard to get through those systems without someone to help guide you. But congratulations on being in remission.
Thank you.
I hope you can have continued good health. And we appreciate you bringing we really want to understand every aspect that people go through, particularly when we're addressing firefighters. We know that, you're risking your lives, you're subjecting yourselves to these carcinogens in order to protect us. And so we feel we have an obligation to protect you.
Thank you very much.
Thank you, Senator. I don't see any other hands, so thank you.
Thank you for your time.
Up next, we have Jeff Sneller. Okay, we'll circle back. Following Jeff, we have Lawrence Sanchez. Seeing that you both are coming together, could you state your names for the records, and we will offer that time together.
Hello, my name is Lawrence
Yep.
Sanchez.
Roderick Medina. All right, good afternoon, Senator Representatives of the Labor and Public Employees Committee. Sorry. My name is Roderick Medina. I live in Harvard and worked at iHealth as a warehouse processor, and I'm a member of the Teamsters Local 671. Thank you for your chance to testify in support of SB 1254. This bill is needed to add much needed protections to the warehouse workers in Connecticut. Currently, companies can impose harmful production quotas that puts workers at risk of injury. In our warehouse, it was always a rush to meet the monthly number. This rush is because if we started to fall behind or the quota suddenly changed, they would then change the hours and enforce more mandatory overtime, often at the last minute. They would hint on having us come in on Saturdays, but not confirm it until the day before. Then we would be expected to cancel our plans and come in or get an occurrence if we were not able to. An occurrence was basically a warning. If we get enough of those, they would fire you. I'd now like to turn it over to Lawrence Sanchez. He has more to say on this bill.
Good afternoon, Senators and Representatives of the Labor and Public Employees Committee. This bill is desperately needed in Connecticut as it provides much needed protections for the warehouse workers. This bill will not only help us, but all warehouse workers in Connecticut. It calls for companies to have clearly defined quotas that will be available upon request by the workers. It also protects those workers against retaliation for asking to see those quotas. In our case, to reiterate, the quotas were always a number that was given to you that you have to reach by the end of the month. The manager would say, oh, we need to make 20 million this month. And then midway through, they would suddenly say, now the number is 36 million. They would let it be known that there would then be more overtime, but they wouldn't be specific. So they would basically be saying, oh, you might have to come in on Saturday, you might have to come in for overtime, but it's up in the air, and for right now it's up in the air. And then come Friday, they would finally confirm, oh, yep, now you need to be coming for Saturday, and you'd be forced to change your plans. So if you had planned and assumed that you wouldn't be working on that Saturday, because they never confirmed it, they just said it might be, then you would have to change it, because if you do not go in for that mandatory overtime, they give you an occurrence. What they would say is, oh, just manage your occurrences. Well, that's easier said than done when they are so sporadic with how they change the scheduling. Our story in this case is where they tell you the quota, but it kept changing with little to no prediction on how it will change. They just expect you to work faster and cancel your plans to meet that new number. At Amazon, they would not even tell you the number, but if you are at the bottom 5% of performance towards the quota, they would be able to fire you. The added stress in both situations makes workers rush, resulting in injuries, mistakes, and an overall toxic environment. While this bill is a step in the right direction, I would like to recommend two very important amendments to the bill. The first is tightening up on the specific language used for quotas, which is needed because in states where similar bills have been passed, Amazon would just claim the bill does not apply to them by asserting they do not use quotas. For this reason, language should be added to the bill that captures the full range of quota systems used by employers. The other amendment is regards to attorney fees language present in the bill. In my opinion, it should be changed to be more consistent with current Connecticut language in the area of minimum wage law. This change would ensure that warehouse workers have the ability to recover attorney fees if they prevail in the case, but not require them to pay the company's attorney fees if they do not. This protection is already common in low-paid workers and how it works in Connecticut in cases of minimum wage violations. I would like to thank Governor Lamont for proposing this legislation and the distinguished members of this committee for hearing our testimony on it. And I'm happy to answer any questions you may have.
Thank you for your testimony to the both of you. I do have, Lawrence, you and I have spoken quite a bit about this topic for a number of years, not necessarily just recently, right? And can you talk about the working conditions in addition to the socio-emotional stress of not having the sort of schedule assurances, in addition to trying to also argue in favor of better working conditions and better pay for not just yourself, but for the many people that you work with? And I know that's a lot in one, but I think we've covered it enough for you to speak to all of those areas.
Yeah, I could speak to those, and Ronnie can speak to some of the scheduling as well. Since your second shift, it's always you want to talk
Well,
about
yeah,
with the
so-
overtime for Saturdays.
And it's funny about the quotas because even if we wouldn't know the quota, it wouldn't matter because if we start hitting the quota, they start calling up the salespeople and try to get more money in. So it really wouldn't even matter. Like it was on them. If they wanted to make more money, we had to be there.
And part of the issue too, is especially in our warehouse, is that for second shift employees, when they were told last minute, you need to come in on Saturday, it was not a Saturday second shift, it was a Saturday first shift. So basically, they would have workers come in on Friday, they stay late for second shift, you guys were leaving at 10 p.m., and some of you have a 40-minute commute. So they would get home at 10:40 or 11, depending on the traffic, and then you're expected to basically prepare everything for the next day. If you take a shower, make dinner, if you haven't even had dinner, and then you'll be expected to wake up at first shift hours, which is 5 a.m. So you don't have much time to even rest, and they expect you to come in the next day, work the mandatory 5 or 8 hours on that Saturday, all last minute, because they would tell you that Friday, by the way, come in Saturday. So this is assuming you've already managed to cancel your plans. Now you need to be unsafe when you're driving after working a second shift to work first shift.
And the hours used to be from 3 to 11:30, so I would get home at 12 a.m. to be in at 5.
Thank you for that answer. And so I have just a second question for you. And so when you start to argue for better working conditions, better pay, better predictability, and then you guys took it upon yourselves to unionize. Can you speak to how management treated you and what some of those practices look like thereafter as you tried to negotiate a better contract?
So when we were there and they were just trying to squeeze every drop out of us, and they were like, hey, there's no one coming through the doors. It's not like we have a line of people to hire. And when we unionized and they fired us, they suddenly hired everyone they could, and they got way more people than when we were there. So that just showed that they could have done it if they wanted to. They could have got more help. They just wanted to get more profit.
So while we were unionizing and when we unionized, it was normally common practice to have around like 12 temps that would bring in. But immediately after unionizing, there was barely ever 4 to 5 temps. They didn't hire more people, even in a temporary position, in retaliation to us to force more overtime. They used that to justify, oh, now we need to force you to do 12 hours Monday to Friday and then come in Saturday for 8 hours. So it was in retaliation to our unionization efforts. And again, I keep bringing this up because on Memorial Day, which is a company-approved holiday that they gave us previously and was in writing that they gave us previously, they made us all cancel our Memorial Day holiday and come in to work. So they basically did that in retaliation. And again, when we did a petition saying stop taking away our holidays that you've previously agreed to, and we had a petition and we gave it in a march on the boss, suddenly July 4th, which they were hinting at, making everyone come in, they did a 180, gave it back to us, and then gave July 5th with pay. So it shows that they were, again, afraid at that time of pissing off the workers, but then they just doubled down. I don't know. I don't understand the reasoning for it. Maybe they're more confident with the change in the federal administration, that they're comfortable with breaking labor laws and just trying to enforce draconian conditions in the warehouse.
Thank you, Representative Gauthier.
Thank you very much. Thank you, Mr. Chair, through you. So I'm not asking you guys necessarily to testify to other bills, but we have talked about in this committee and various public hearings about things like non-disclosure agreements, and other bills that address transparency and hiring practices, in making sure that employees can and are allowed to make a free choice and make a free association when they are choosing which job to work and under what conditions of employment they have. I guess my question would be, for all of the practices you're describing that cause, I would describe as chaos in people's lives and workers' lives, how much of those practices, how much of those changing of schedules, as you just described, how much of that was explained up front, like during the hiring process? How much of it did you know beforehand that you were getting into when you were applying for this job, being interviewed, and before you started doing it? Thank you.
So for me specifically, I was told that there would not be much overtime. So that was what was told to me. And Ronnie can say what was told for the warehouse people.
Yeah, it was never an issue at the time when I started. Everything was just voluntary and it was okay until I don't know what happened. I don't know why it just ramped up. They actually said that every year we were doubling up in business and all this, and they were expecting all these people, but the people never came, and we were there.
And again, for his, they hinted at being voluntary, but ever since we unionized, it's been mandatory. And if you don't show up for a mandatory overtime, where they basically treat it like your normal work hours, then you get an occurrence, and their response is manage your occurrences. But if you get enough occurrences, they fire you. So they're basically saying, well, tough luck, deal with it.
Understood. And thank you for describing that. Again, for me, that does not sound like workers making a free choice and having free association and being able to make choices based on full, background of knowing what you're getting into. So thank you guys for choosing to organize and stand up for yourselves, of course, but also for your fellow workers. Thank you, Mr. Chair.
Thank you, Representative. Representative Weir.
Thank you, Mr. Chair, and thank you both for coming to testify. I remember listening to you one of the last public hearings that we had, and obviously this is shedding a little bit of light on it. I had a question. Former representative asked, I think clarified, I think that question that he asked you did a good job of, my mind, like the situation changed, like, all right, we got hired with one set of expectations. For reasons unknown to you, things change and it's not the same thing you signed up for, which I think you should have an expectation of what the job is going to entail. And when things change, I think that needs to be communicated. And it sounds like maybe that did or didn't happen, but the bottom line is the situation changed. So what I intended to ask was, is the job that you're performing, did you see that demand? I'm trying to figure out if this is a seasonal thing. Was this a Christmas rush, or is this something like companies' volume increased and they dumped all the responsibilities on you because they couldn't backfill with additional resources? Or is this a year-round thing, like it was steady, or like, hey, it got real busy and, well, you described Memorial Day, so through you, Mr. Chair.
So it's a little bit of both. There are peak seasons where they would normally hire more temps. Again, we unionized and they barely hired 4 to 5 when normally they would have 12. So our peak seasons, for example, Christmas, and then April through July, there was only 4 temps when normally there's 12, and their solution was, oh, we can't hire anyone else, we can't find the people, you just got to work more overtime, keep working, because they know it's a peak season. They just didn't do that. And that excuse, we couldn't find people, is really hollow when they, in 2 weeks, swarmed in with a bunch of people from Manpower, found the work, hired whoever they want to be scabs. So they could have done this. They could have hired full-time employees to begin with. Instead, they chose to punish us, to try to disenfranchise us and try to break the union because they didn't want us there. They wanted us to give up, which we're not doing.
And every peak season, they were making more and more money. So like this last year's peak season will be different from this year's. Like they were like, oh, got to do like 20 million more this month. But we're like, how are we going to do that? We barely did it last year.
Yeah, so they knew the expectations were that it was going to be even busier. They knew that ahead of time, and they were wondering how are we going to do it. But then their response is, oh, just do more overtime instead of hiring more people. So they had an idea of it. They just chose not to do the common sense thing and hire more people or even hire temps if that's an issue for them.
Representative Weir, sorry.
And through you, Mr. Chair. And are you both no longer with the company? I assumed you were, but then something you said today that you're not there. So, but can you clarify that, please?
Yes. So we went on strike. 2 days in, we went on a ULP strike. It's unfair labor practice because we have numerous ULPs filed against this company. And then 2 days in, they fired all the striking workers via text message. So that's becoming a common practice to just fire people via text message, saying voluntary resignation, which we didn't do. We went out on a protected strike, and their response was to fire everyone. And then they immediately got their office people to come in trying to do the warehouse job for the first week. That wasn't working out. So by the second week, they managed to come in and get Manpower from the company that is called Manpower, that they back all their scabs come in. And they were always repeatedly saying, oh, we can't find people, we can't find people. And then within 2 weeks, they were able to find everyone and replace us, which in a protected strike, you can't do that. In an economic strike, you can do that, but you would have to have those people already hired, which they didn't even do that. They were rushed to do that, and were just basically assuming that they can get away with it. And again, with the NLRB board being crippled currently, with the general counsel being fired, and then them not having quorum to rule on cases, maybe that's what they're thinking.
Representative Weir.
And what was the time frame on that? I know you were here testifying to this last time, but when approximately did this occur?
So we were fired on December 2nd, which should have been the Tuesday, and that was just 2 days in. And that was right before Christmas. It didn't even happen, and we've still been on strike even right now. This company refuses to negotiate in good faith.
Representative Weir.
And you talked about some of the conditions that, at Amazon. Have you worked at Amazon by comparison, or is this stuff you've heard about?
This is stuff I heard about from other testimony. Again, it's common knowledge that or at least based on their testimony, I'm sitting at from when they testified on SB 8, and other House-related bills, that if you're in the bottom 5% of that they would be able to fire you. I have not personally worked at Amazon, but I just wanted to reiterate that that's in contrast to ours, where we do know a quota, and we do, and regardless if you meet it or not, it keeps changing. Theirs, they don't even know it, and that adds, in my opinion, it makes it worse for them, because they don't even know if they're meeting it or not, and if they're at the bottom 5% or not, and that adds an added additional fear for those Amazon workers.
Thank you, Representative. Senator Kushner.
Thank you. So you referred to the fact that you're on a protected strike. I assume that means that you're on an unfair labor practice strike, so that your position is that there were charges have been filed that the employer broke federal labor laws, and that puts your strike in a different class than if you were just fighting over how much they were going to pay you. Is that accurate?
Correct. We had numerous filed unfair labor practices. One of them, for example, was that as we unionized, they were normally supposed to give a raise in April. They withheld that, saying the union's holding it, which we weren't. The union sent them an email saying that you can raise them as you did normally, because the common practice is that you keep things the same until a contract is negotiated. So every April, they gave everyone a raise. They withheld that. And that's one of our unfair labor practices, on top with the increasing hours and retaliation, on top of them taking away the holidays, on top of them not hiring enough temps, on top of all of those issues, as well as threatening to close down the warehouse or hinting on it in their intense anti-union, union busting campaign. This was all filed with them already, and them not bargaining in good faith and them stalling and delaying for over 9 months. That is why we decided to go on an unfair labor practice strike, to try to get them to take this seriously and stop stalling and actually treat us with respect, instead of just punishing us and trying to disenfranchise us.
So when you say that the common practice, so just for clarity, under federal law, an employer, when there is a first contract being negotiated or any contract being negotiated under federal law, they're not allowed to make unilateral changes. They're required to bargain those changes. So your position is they were making unilateral changes while you were bargaining, which is why you could file an unfair labor practice charge.
Correct.
And then the other thing you said, which people may not be aware of, is that the general counsel of the National Labor Relations Board was fired about 3 or 4 weeks ago. First time in the history of the National Labor Relations Board that a chairperson has been fired by an incoming administration. But the direct, I mean, that set aside, that the direct impact on you is there's no quorum, so they can't rule on any unfair labor practices at this time at the federal level, because there's no quorum on the board.
Correct.
So you're kind of stuck.
Yes.
As are many workers right now. So yeah, I think that's all very important. The thing we do hear a lot, and you referenced it in your remarks, that, if you don't like it there, go somewhere else. And I think I said this to you the last time you testified, both of you, that, clearly going somewhere else means that someone behind you is going to suffer the same difficulties that you're suffering. So it's not a real solution. But more importantly, how long have you worked there? Because I know going somewhere else might be to your detriment if you've been there a while and if you've invested in this company, and if you have maybe a 401k or some other retirement program. It would be helpful for us to sort of get the sense of why you are so attached to that particular employer.
So I've been there for 2.5 years, soon to be 3 years if I was still there. One of our members, to explain this more, has been there for 26 years. So if you've been there for 3 years, you get fully vested into the 401k, and you get a higher match for it. And if you've been there for 26 years, you kind of don't have the option as much to be able to move around. So for this member in particular, he it will be difficult at his older age to go to a job because the employer will look at that and say, okay, there might be some age discrimination there, but it just becomes so much harder because he also hasn't been, around and haven't made a resume in many, many years. So that becomes a difficulty there. On top of just wanting stability of this workplace that he's basically witnessed change for the worse over the years. Part of why we unionized was to get better working conditions and stay here where we have our 401k, where we have our healthcare, because that also is up in the air when you're going to a new job. When you're going to a new job, you don't know what their 401k match is, and it may not be to the match what you currently have, or for their health insurance, it may not match what you currently have, and you might have to give an additional, who knows, 5 years to get vested in their 401k, whereas you're already vested in the current 401k. You've already been there for over 3 years, so that adds to making you not be able to realistically just find another job.
Thank you, Mr. And thank you for being here. I guess it's not quite as late as it was the other night when you guys testified. So this is early for you guys.
Yeah.
Thank you for being here.
I don't see any other hands. Thank you both for your testimony today.
Thank you.
Up next, we have Zachary Mikione.
Good afternoon, members of the Labor and Public Employees Committee. For the record, my name is Zach McEwen. I'm an advocacy manager with the Connecticut Conference of Municipalities. Thank you for the opportunity to testify. I wanted to concentrate my comments on SB 1426, which is an act making changes to the firefighter cancer relief program. So I just wanted to kind of go over some background on this and some history regarding cancer and firefighters because it has a long history and there's been a lot of iterations to what we have done since 2016. Starting in 2016, CCM was part of a bipartisan effort to address cancer amongst firefighters. That bill really centered around wage replacement. So once a firefighter exhausted their sick benefits, this was intended to provide wage replacement benefits to firefighters that had cancer. In 2022, we made some changes to the law, and we wanted to address safety issues for firefighters, which had to deal with firefighter turnout gear. So we created a plan for that. And then our members at CCM understood really that there needed to be skin within the game for our members. And so we established a fee per firefighter, volunteer and paid, that would go into that fund. In 2023, we met with the stakeholders. There were some shortfalls with just wage replacement. And so we created a system specifically in which the program allowed firefighters that had certain cancers and met certain criteria to receive essentially similar workers' compensation benefits, but it was outside the formal process of workers' compensation. And so that leads us to the technical revisions of this bill, in which we're trying to essentially make this more efficient and make sure that there's no bottlenecks when we're trying to process these claims. So CCM has some recommendations on this. We do have an oppose and have some serious concern with changing the reference of personal injury within the statute to occupational disease. I think, during the 2023 negotiation with our members and other stakeholders, we deliberately avoided using, workers' compensation terminology, particularly language that related to presumptions, which our members oppose strongly that there would be a presumption within the workers' comp system. So we would like to see that the personal injury termination or terminology, excuse me, would be left in the bill unchanged. We strongly support the administrative judge's authority to adjudicate claims. Right now, there's a bottleneck, and if there's a dispute within the claims system, right now in the bill, it does not specifically say that the workers' compensation judge or commission can make a ruling and adjudicate claims. So essentially, if there's a dispute with a claim, it is left in limbo. and that's clearly not the intent of the bill. So we would strongly support having that provision be laid out so that the judges can make a determination on these claims, and then payments would ensue. And then lastly, we would just urge caution on expanding the qualifying cancers within the fund. Right now, skin cancer, I believe, is not included. This bill would seek to add that in. Again, we just have concern that adding certain cancers within the fund might have more exposure with the fund when we are still trying with the stakeholders as well to create a sustainable funding stream to the Cancer Relief Fund. Right now,
Mr. McCowan, your time is almost up. Please conclude your remarks.
yep, and I'll just finish up quickly here. Right now, we have the municipal, contribution to the fund every year. I believe it's $10 per firefighter, and we also have appropriations in the previous years. Obviously, with the state budget and appropriations, those can be hit or miss essentially. And so we want a sustainable funding stream, which would be, which is actually now in the Public Safety Committee, SB 1318, which would do a 5-cent surcharge on phones that would go into the fund. That would give us a more sustainable funding stream for that, for those qualifying cancers. Happy to answer any questions. We submitted testimony on a couple other bills too, but happy to answer any questions and would refer you to testimony that we submitted on those other ones.
Thank you for your testimony. Representative Carino.
Thank you, Mr. Chair, and thank you, Zach. First question, because kind of get confused in this area sometimes because
Yeah.
there's two buckets of money really where people can go after for the firefighter bill. So this is pertaining to the firefighter cancer relief program that you guys pay, what, $10 per firefighter?
Yeah, so we pay $10 per firefighter and volunteer. Honestly, it's a pretty a low amount. And so
Yeah.
depending on the actuarial analysis and such going forward, we can definitely look at that. For right now, it's very confusing. There's 3 different avenues a firefighter can take, essentially, from my understanding. You can go wage replacement with the Cancer Relief Fund, in which there's a committee in which they would review these claims and they would determine whether or not wage replacement was necessary. I believe that committee is made up of both municipal and labor representatives. Then you can go through the Cancer Relief Fund again, but through the 2023 law that we passed. That would provide similar workers' compensation benefits that you would get in workers' compensation. And so that would also be, medical treatment as well, et cetera, with that. And so, I think that would probably be the fund that you would want to go through. And then the third avenue is you can go through workers' compensation. Right now, there's not a presumption within workers' compensation. And so essentially, if you go through the workers' compensation process, the employee would have to prove that the injury was, a job related, essentially. And so those are the 3 avenues. And I think that's where some confusion comes in with our folks and maybe also to others going through the system.
Representative Carino.
Thank you for that clarification. And so I'm just trying to understand the municipal concern about any cost increases. So can you just kind of broadly explain how changing that definition from what was that?
Yep.
Personal injury to occupational illness.
Procedural wise, I don't think there is going to be any structural change within the statute. I think our concern from our members is, when there was a specific request during 2023 when we were meeting with stakeholders to keep that terminology, occupational disease, which our members thought moves closer to a workers' compensation presumption language, because that language essentially mirrors what, a workers' compensation presumption, which our members strongly oppose. They felt as though it would move closer to that within the statute. I don't think, from my conversations with different stakeholders, I don't think the actual definition change would have any type of change in the intent of the legislative intent of the bill. And so if we can keep the personal injury language and it's not affecting really the, legislative intent of the bill, I think that our members would like to see that language stay the same as they, do not support presumption within workers' comp. if that makes sense.
Representative Khalid.
So if I'm summarizing this correctly, you guys believe that this would kind of create a slippery slope that could be used to bring this towards a workers' comp?
Yeah, your term, not mine, but whenever we hear occupational disease and you know, and the framework of a workers' compensation presumption, it gives our members pause.
Thank you.
Senator Kushner.
So I wasn't included in the meetings with you around this drafting of this bill, but I was included in a lot of the meetings on the drafting of the bill. And it never was a part of our conversation that we were explicitly leaving out occupational illness because of some concern that it would present an opportunity to make a claim and presumptive claim in workers' comp. I think the whole way the program is structured is to provide a resource that is not workers' compensation. And that was done in consideration of this, you know, CCM and its affiliates, because we recognized that you didn't want to take on that potential risk of expense that you would have to, that the cities would have to pay, and finding another mechanism. I'm pleased that there's another bill this year around funding. I think that's great. I know there've been many efforts to fund, including state monies that also get contributed into the fund. It's not just the municipalities that pay, and the state also pays into the fund. I know you recognize that sometimes that didn't happen in the past. Before I got here, I know that money was not deposited, and the legislature since 2018, we've made it a point to not only put in the money that was required, but also to pay into the fund money that was not placed there in years previous. So we sort of made up the difference that we had on payments that were missed, which is all good because we want to have a viable fund. I just don't think, I don't think it was ever our intention to leave out the language that's been proposed here today of personal illness, because it is so well established that this statute does not create any kind of presumption in workers' comp. It's very, very separate. The other thing I would caution is, and I appreciate, I think you said this at the very outset, but I would caution your description of what the three approaches are. I think we should probably, if we have an interest in knowing that, which is a good thing to know, we should ask OLR to provide that analysis for us, because my recollection is a little bit different than what you stated. I don't know, you could be right and I could be wrong, but rather than either of us guessing at it, I think we should ask OLR for that analysis.
Yeah, if I could just respond to that, you know, even a lack of clarity on that, I think is, you know, is what's confusing, I think, to a lot of stakeholders with municipal employers and also, you know, people that are affected and diagnosed with cancer. And so clarity on that, that's what our members and I believe is the three avenues. But clarity on that, I think, would be good. And I know we talked about, you know, I've been listening to a lot of the conversation today, and, you know, maybe even having case workers and educating on kind of, you know, what the different avenues are could be also a thing to explore. But I do agree that it's, you know, when we decided to go through this statute and negotiate it, it has a lot of layers, and it's it can be complex. So any way that we could smooth it out and make it, you know, easier for everybody, I would agree with that.
I just want to, it's fine if you want to say you have lack of clarity on it. I don't have lack of clarity. I don't have it in front of me.
Okay.
I think that it was clear, and my recollection is different than what you stated, but I do think it was clear. So that's all I'm saying, is that we should get OLR to, you know, lay out the specifics rather than either one of us
Sure.
relying on our memories of it. But I don't, and at least from my part, I don't think it's a lack of clarity. I think the changes that are being proposed today are changes that will provide the authority, first of all, to, which you agree with, the authority to workers' comp to adjudicate disputes, which I think is critically important. And then to clarify that state firefighters, employees of the state that are firefighters, are also covered. And several, and the personal, the occupational illness issue. And I guess what I would say about that particular issue, I'm questioning why that's a concern to you if you don't believe it's going to change the ability of someone to claim this benefit. What we heard earlier today in testimony was that the reason for the clarity, the reason for the addition of occupational illness is because cancer is not an injury. And so we're actually having statute something that could lead to someone challenging it and saying, oh, well, cancer's not an injury, it's an occupational illness. So that's the question I think that we have to grapple with as a committee.
Yeah, I know you mentioned that, in our iterations in 2023, or maybe this is something that you had not had discussed about. Since 2016, the presumptive language has been a huge concern for CCM. And so I think it even dates far back before that, really making sure that municipalities are not going to be the sore financial, because essentially right now, if you want to go through the workers' compensation system and there was a presumption, obviously the property taxpayers would pay that. And so our members are very concerned about any language that could shift it into a presumption. And I'll leave it at that.
Okay, I think you just repeated yourself, but it's okay. You can do that. We all do that. So thank you, Mr. Chairman.
Any other questions from the committee? McEwen, correct?
Yes, McEwen.
I said it 10 times before you got up because I always butcher it. So I apologize.
No, it's
about
okay.
that.
It's okay.
I wrote it down
problem.
for my reference moving forward, but thank you for your testimony.
Yeah, thank you. I appreciate it.
Next up, we have Ronald Ing.
Yes, good afternoon, everyone. I'd like to thank the co-chair, Senator Kushner and Representative Sanchez, as well as the members of the Labor and Public Employee Committee for allowing me to speak today. I represent the town of Stratford. Again, my name is Ronald Ing, and I am the Director of Human Resources and Risk Management for the town. And I'm also a member of the CCM Labor and Municipal Law Policy Committee. I oppose this proposed bill of 5609 for several reasons. One of the first and foremost is the bill, in essence, takes away some of the rights from the municipalities to negotiate, as stated in the Municipal Employee Relations Act, which is also known as MERA regulations, which are enacted in 1965 to make sure that both parties would have guidelines to negotiate fairly amongst the two groups. This also includes binding interest arbitration when the parties are in an impasse and is agreed by all parties. And the reason why I bring those up because there are issues with, in particular, as you've heard testimony from our town regarding our pension plan and so forth. But our pension plan went through an interest arbitration to the Department of Labor with an agreement by both parties. And this portion of the pension was in place well before I was even working for the town, which has been for 15 years. And the language was still stood up in the interest arbitration. And now this bill proposing would basically negate that interest arbitration award, which was technically considered, it was binding. And now that's basically being circumvented from that perspective. In general, with workers' compensation as well, that the benefits that the employees receive is based on, there are 52 weeks of their last working days, which includes overtime. So a lot of time they can have a lot more funds than their normal pay. And as previously testified by Attorney O'Flynn, was that in our town, we do have the provision where people get made whole for their base salary at minimum to make sure they're not losing those wages. The fact of the matter of not including the workers' comp benefits are there is the hope is for people to come back to work. And that's why we go on workers' comp. And we're hoping that the employee is successfully addressing their injury and can come back to work full duty. The issue is that if they're extended beyond a year, as you heard, they're beyond 2 to 3 years, that the town is now incurring additional costs to not only pay them whole wages, if you will, but also to replace those same employees with overtime from other employees to fill those roles. These are all unanticipated costs to the town, which basically trickle down to the taxpayers who have to fund these cost that the town incurs. And so we are looking at that as an issue because, again, it's unexpected costs to the town that, again, through fair bargaining, negotiations, and interest arbitration, these are the rules of the pension. A lot of the employees are aware of those pension rules, and if they're not clear on those, we do meet with them when they come to the town HR department to
Your
discuss what
time is
their.
almost up. Please conclude your remarks.
Okay, I will. Thank you very much. So I just want to in general point out the fact is that we are there to help guide our employees, to let them make sure they understand what they're coming to and what their potential pension impact will be. And basically, I would like again to thank you guys for letting me present my testimony today.
Thank you. Any questions or comments from the committee? Senator Kushner.
I apologize. It was a little difficult to hear you. It was a little muffled in terms of the transmission of the sound, but I know, setting aside the legalities for a moment, what we heard today from folks was very compelling testimony that essentially somebody could work for 20 years, full wage, get hurt, and then in retirement, if they retired and that was the calculation, there was no calculation for the previous 20 years that they'd worked. So basically the city of Stratford was, having the services of a firefighter for 20 years and then paying a pension that looked like they had hardly worked. And that's the part I think that we find so hard. Setting aside all the legal questions, it just appeals to us, I think, as, our job is to protect workers. That's our cognizance. We're supposed to protect workers in the state of Connecticut. And it just seems like this is an issue that we should take up, where workers couldn't be put in a position where they would lose 20 years of service because they were hurt on the job and received workers' comp in the last 2 years that they served. So I'm just curious how that, whether we're hearing something wrong, did they in fact get really substantial pensions and we're not aware of?
Well, they don't lose their years of service with the town. What happens is based on, again, negotiated and agreements with the union in this case. It's agreed that these are the criteria that you factor into negotiating and coming out to your pension basically calculations. So the hope is
so that when there's a formula, and it's the last, and I apologize for interrupting, but I want to make sure I understand. If the formula is X amount, let's say 2.5 times your last, your years of service times your last 2 years of salary. If your salary was 0, once you have a 0 in that formula, that brings it down, considerably, right?
Yes, that would.
So is that what the issue
But the
is?
hope, well, the hope is that the employee understands their contractual requirements and understand that this would be impacting them, and hopefully they could get, and we understand that it's up to the doctors to let people come back to work, obviously based on input from the employees as well. And it's pretty much out of the employee's hands as well as the employer's hand to a degree. I think the employee has more control than the employer on that aspect. But the functionality would be if you, unfortunately, if you had the situation where you were out for a year, you would know coming up to that year's time that this would impact your pension, and a decision should be made on what we should be doing, because it's not based on just the last 52 weeks. It's based on their last 104 weeks in our pension plan. And I'm not trying to make a debate out of our plan to everybody, but that's just the way our plan works. It's the last 104 weeks of pay that an employee works for the town. And then there's a percentage taken out of that factor. As you said, there's a calculation. So it's the average of those last 104 weeks. So the hope is that people would.
But you're not calculating in any payment that they got from workers' comp. You're only calculating in the payment that they got from the city?
Well, based on the definition, it's all the definition of what a compensation is in our contract with the union, which we're adhering to, is it's all taxable by federal government income. So it is not just their pay. If they have, as I think Attorney Flynn was trying to mention, there's some cash out of holiday time, vacation, they can factor that into their pay as well to calculate for their ultimate pension dollars. So it's not just base pay or their pay that they receive, it's also other factors that come into play.
I appreciate your answers because I think they were very clear, and I appreciate that you are sticking to, as you should be, to what is in the plan. But I think it does confirm, for me anyway, that this is precisely why we need a law that says you can't do it that way. Because in fact, it harms someone who's provided good service to one of our municipalities. It just harms that person too much to allow that kind of negotiations, whether it was agreed upon or not. I think our obligation is to make sure that when people retire from fire service, you know, from service to our municipalities, that they have something they can live on. So I appreciate that, you know, you're technically required to take that position, but I hope you understand why we feel like this is an important bill for us to consider as a committee, so that state law would prevent that from happening in another situation. But thank you very much for your testimony.
Thank you.
Representative Big.
Thank you, Mr. Chairman. Good afternoon, Ron.
Good afternoon, Representative Shake. How are you?
I'm good, thank you. I just wanted to know if you could share with the committee if anyone has retired on a disability after the arbitration, and if so, were there wage replacement wages included in their calculations?
Specifically to the fire department or in general for the whole town?
For the town.
We have had a few folks, different unions have different agreements. So we adhere to those contracts. So there was at least one firefighter where the pension was calculated. It did include wages, but we have recently corrected that because it was done by a former employee that did not follow the rules from what was stated, but it was corrected. So their pension has been realigned to what it should be per the contract. Like I said, again, other unions have different verbiage in their pensions. And as Mr. O'Flynn mentioned, the fire union as well as the police union, the pensions that are available are all locked. So you can't change them unless both parties agree to do so, as well as some of our other unions all have, they all have some locked language they can't touch their pension documents and change the language, because you open up not just a piece of it, you open the whole document up to negotiate. So I'm sure there's plus and minuses to both parties on doing that.
Thank you. And if I heard you right, Ron, you referenced that there was one worker within the fire department, and that
is correct.
And that was corrected.
That is correct.
And how long ago was that retirement? Did that person retire?
I believe they retired in maybe 2018.
Okay, and just for
2019.
clarification, could you explain to us, when you say it was corrected, what were the implications to the employee?
Well, their pension was reduced because they were out over 2 years as well. So their pay was not factored into that. Should not have been. Some additional pay was factored into it. So it was modified, again, to meet the requirements of the negotiated agreement and locked pension document that we have with the union.
So does that then imply that the pension had been corrected in being reduced? I'm just trying to understand.
Yes, the amount that the person was receiving was reduced in accordance with the contract language. As you know, we have to treat everybody the same, and so we can't allow, when we discovered that someone was paid incorrectly, we have to correct that. That's a fiduciary responsibility.
I'm just trying to understand how many, in this particular case, firefighters have been subjected to what we're trying to tackle here as a legislature. And just to be clear, this bill is not just intended to protect firefighters, it's intended to protect Connecticut workers, public workers, across all different areas within departments. So I look forward to hearing more. Thank you.
Thank you.
Thank you, Representative. Representative Weir.
Thank you for your testimony. Mr. Ng, can you I guess if I'm understanding this right, maybe you can just either confirm or clarify or correct me. If this person or people who are injured, they went out on workers' comp, um, if they had if the situation were different and instead of going out on comp with the intent to come back, and as I understand it, they retired during that period. If they had gone out on disability, like taken a permanent disability, would that have resulted in a different calculation through you, Mr. Chair?
Yes, Representative Weir, that would have changed if they made a decision sooner than the scenarios that have arisen. They would have received a much higher pension. That's why we don't tell them they have to retire. We try to inquire to what their nature of the possibility of return to work is. We send letters and notifications to them to please reach out to your doctors and try to confirm that, so that if you can make a decision sooner rather than later, there's less impact to you from that perspective.
Representative Weir.
Thank you. And I think this dialogue between everybody who's testified on this today has helped me understand the picture a little bit better. If this was communicated, I guess somehow during the time, it just, again, the way I'm processing this is the person people made the decision to retire, and somehow the visibility of, hey, my pension is going to be affected by this. I can't say that happened, but it just seems like if they had visibility of that, then maybe that would have resulted in a different outcome, or maybe a different, I don't know this to be the case, but it just seems like this was a surprise. Did they have visibility of their final pension calculations prior to submitting their paperwork to retire through you, Mr. Chair?
Yes, they can get what we call an estimate on their pension to see where they would stand before they actually retire, so they can make those decisions, so that it's not just a guess from the individual, but it gives a best estimate of what it would be if they give us a specific date and say, okay, by February 1st, then we can calculate through our finance department of what that pension would be based on the February 1st date that they would retire upon. It's also just to note too that the employees, when they retire on a disability, they do have the ability to work at other employers. Their main issue is that the disability is given to them based on the fact that they can no longer be a firefighter, a police officer, a public works employee, but they are allowed to work elsewhere should they choose to. So it's not limiting them just to survive on their pension, because we know it's been reduced. There is provisions in it for them to work at other employers to increase their personal wages.
Representative Canino.
Thank you, Mr. Chair. So just to kind of get my head around the situation going on down in Stratford, first, I'd just like to ask, what type of retirement plans does the town have? And are these retirement plans negotiated with the employee and or the unions?
Yes, Representative Canino, the town has multiple pensions with each union. We have 6 different unions. In essence, we basically have almost 2 with every union, because back in 1999, the town had elected to eliminate pensions for 4 union groups and 2 non-union groups, and stopped the defined benefit pension and put a defined contribution plan in play. In more recent years, since I've been employed by the town in 2011 and 2012, the town stopped or proposed to stop the defined benefit plans for both police and fire, which was negotiated with the union. So all of the pensions and retirement plans are negotiated with the unions. Once, though, the unions state that they want to freeze or lock the pension, the town had no problem and agreed to those things. And now the new employees that we hire go into defined contribution, and those are continuing to negotiating every contract. That every time the contract comes up for renewal, we can then renegotiate the defined contribution plan regarding those newer employees, but we're not able to touch the previous employees' pensions.
Representative Canino.
And have any individuals from the union down there in Stratford indicated a willingness to reopen this pension agreement to kind of take a look at this? And if so, I don't want to force you guys to negotiate in public, but is that something that the town would consider?
It might, it depends on, if we open up the whole thing as opposed to just this one piece, which was discussed. But we declined just to open up this one piece because there's other factors that the town would look at as well to be fair to the town as much as it is to be fair to the employee. Again, we represent the taxpayers. It's their dollars that we're spending, and we're trying to be fiduciary responsible to those taxpayers to make sure that we're spending them accordingly.
Thank you. And then just my last question. Do all of these retirement plans have a disability provision that you guys offer, and how do those plans work regarding the disability?
All the plans do have disability provisions, even a defined contribution. There's long-term disability insurance they receive. There are limits that they cannot receive less than, once they've retired, they can't receive less than 30% of what they're getting. So if they are injured on the job, their workers' comp factor is not in there, but their wages are still saying here's 100% of their wages. They can't receive less than 30% of that wage that's taxable based on the contractual language. So we ensure that doesn't happen. No one loses pay. There is a requirement that if you do get a job elsewhere, that you can't make more money than the top step of the position that you retired from. So if you were a public works employee at the sanitation division and it was $60,000 a year, and you receive a pension that's typically 50% on disability, so you receive $30,000, you can't make more than $60,000 from another employer because then you'd be making more than your top step. If it was a firefighter or a police officer, whatever their wages are, if it's $90,000 or $87,000, they can get employed up to that point before any kind of reduction is put in play for that individual. They also all receive medical benefits from the town, so it's not like we're not like cutting them off and just giving them pay. We are covering them medically for their medical needs that they may have. So there's provisions in the pension, defined benefit pension plans, as well as defined contribution plans to provide medical for the individuals as well and their families, should they choose to.
Representative Canino.
Thank you. And just one more thought popped up. So, for those of us who are new to this sphere, can you just kind of go into what the purpose instead of disability, what the purpose of workers' compensation is, and how does those workers' comp benefits work?
So, and try to simplify it as best as possible because it's not that easy. But when an individual goes out on injury, if they're out for more than 3 consecutive days, they meet the workers' comp definition, and then they receive workers' comp pay, which is tax-free dollars, which is another benefit to the employee. So they're not taxed due to the fact that they're out on injury. And it somewhat supplements some of the additional losses of wages if they work overtime and so forth. So the amount they receive is approximately 75% of their last 52 weeks of pay. And as Attorney Flynn indicated, there is a cap. I don't know the exact cap number off my top of my head. But again, if it was below their base pay, there's provisions for them to use some sick time, and then to a point, then the town picks up the additional pay depending on what group they're in, because our police and fire have a different agreement than all the other unions. So that's what we just, again, follow the contractual language to properly afford the employees their proper pay, whether it's using their own accrued time or where the town would pick up the pay after a period of time. So the benefits are used, again, to help the individual. We pay for the town is self-insured, so we pay for all the medical bills, and treatments, mileage, whatever is necessary for the employee to get well. That's what the town is hoping to do, is get the employee back, because we have a heavy investment. As you pointed out, some of these 2 firefighters have over 20 years experience. We don't want them to be leaving. We'd rather have them working for us still, as we invested a tremendous amount of money and effort into their employment with the town. It's not something the town takes light of, and it is encouraging to try to get people back to work. So that's what the workers' comp is designed for, to help people come back to work as quickly as possible, make sure they're recovered from their injuries, so that they're capable of performing their full duties at 100%.
Thank you, Representative Shake.
Thank you, Mr. Chairman. Ron, do you know of any other municipal and what their what their contracts are? If they're similar, I'm just trying to understand if this is a common practice of municipals, and how they treat their employees?
I do know in general that there's some that have something similar. Some of them have different ones than we do. And again, a lot depends on the type of municipality you have, what kind of services you offer. Some can be a little bit better than others because there's less services. You mean, you take into account the services that we offer to our constituents. You know, we have only a certain amount of funds to cover things. So people, you know, get either more or less services depending on the municipality they live in. And so there are municipalities that have something similar to us, I guess, to a degree, and some people have something a little bit different than we have. Some people have the state plan, so I don't know. I'm not familiar with all the specifics of the state plan, but some are under the state pension plans as well. So they all vary to a degree, but I don't have a specific number of how many actually equate to the same as the Stratfords and how many are different than the town of Stratfords.
Okay, and then in the Stratford Fire Department, we have currently upper 90s of employees. Is that correct?
There's a total of 92 firefighters.
92. And of the 92, how many of them still have a pension?
I'd probably say at least maybe 60%. It could be a little bit less than that.
So it's a possibility that if in the event the workers ended up getting injured and then going out on workman's comp, that they would also be subject to this process that you're describing, where some of them are estimated to receive $16,000 for a pension payout.
Well, no, I disagree with that. It's not necessarily true. A lot depends on when they make their decision to retire. Like I said, again, we reach out to the employees to
Well,
help
with those
educate
with
them.
20, I guess with 20 plus years of service.
It wouldn't make a difference how many years of experience you had or how much time you have at the town. The contract still is the contract, but it would only impact everybody that was hired prior to April 12th of 2012. So anybody hired prior to that would be entitled to this type of a pension. And again, we would still try to review with the employee if they're willing to meet with us to discuss how their injury situation may impact their pension. That's what we're here to do. I can't tell you that everybody comes and sees the town. They do have union representation, as they should review with the union as well. So they may have financial advisors. I don't know who they're listening to, but basically we do try to advise them of what the impact would be if we have that privilege to do so. And we would try to guide them into saying, here's what the impact would be. And hopefully they would make a decision of whether they feel they could or could not perform their duties in a full-time position at 100%.
And doesn't the town, through the insurer, control how fast medical services are approved?
Well, the town is self-insured, so we are the insurer. So we try to get people in and out as quickly as we can. I can't tell you what the doctor is going to assess, and I can't tell you how the employee is going to say how they feel. So we really don't have that much control of how fast they get. They go in for their medical services, they see their doctors, and the town pays those bills. We don't really, the only thing the town tries to do is get a clarification of whether, if and when the person can come back to work at the full capacity so they can perform their duties. If they can't, then obviously there's other things that the town has to discuss with those individuals.
And when those employees are able to have those discussions, or if they end up going into arbitration at that level of the process, would you describe it as an amicable agreement, or would you describe it a different way?
I'm not sure if I get your question. If you could maybe rephrase it.
When you have employees, if they choose to challenge whatever the outcome is, because you were talking about employees being able to go to the to you, or in this case specifically through you and with the mayor, if they're trying to have those further conversations, discussions, or go through arbitration, if there's an agreement, would you describe the overall consensus as an amicable process, or there's still issues, concerns?
Well, of course, we're trying to resolve anything we can. We don't want to have any concern. We got to do what's best for the employee as well as for the town and the taxpayers that we represent as well. That We're trying to be, again, fiduciary responsible to the taxpayers. And if we can come to an amicable agreement, then we do so. If not, the employee does have a right to take this to the State Board of Mediation in our Department of Labor, as we did with this pension program. This pension document was done well before I was employed by the town, but I think it was done like in 2006 or 2008. And so they always have those provisions. That's what the mirror regulations stipulate, and that's one of my concerns about this, is that it circumvents that negotiating ability. But there's always negotiating abilities for any time an employee feels that they feel that they're not being treated properly per their contract.
Thank you.
You're welcome.
I don't see any other hands. Ron, thank you for your testimony.
Thank you, everybody. Appreciate it.
Take care. Up next, we have Bruce Ewan. I don't see him online. We'll scroll back. Rosa Rodriguez.
Good afternoon. Thank to the Chambers of the Labor Committee for offering me time to speak today. My name is Rosa Rodriguez. I am a worker leader at Connecticut Worker Center and part of the Domestic Worker Justice Coalition in Connecticut, which is made up of domestic workers and employers organizations affiliates of a National Domestic Worker Alliance. Together, we represent thousands of domestic workers and employers across our state, mostly immigrant women of colors who provide care and support in people's homes, caring for children, cleaning houses, and supporting people with disabilities and older adults. Those years of continuing work on supporting the education program helped me to engage many domestic workers in the movement, and they learn to defend their rights and have access to informative materials that we distribute in different places like schools, libraries, parks, community centers, and more. Today, to request your support for SB 1428, an act approaching funds for $500,000 in the FY26 budget and $500,000 in the FY27 budget for a domestic worker education and training grants program. By passing this act, our elected officials will ensure that domestic workers' rights in Connecticut are fully realized and the employers have the information they need to comply with their obligation under the law. The work experience with my community helped me to engage many domestic workers to be informed about the Know Your Rights program in Connecticut. I am very proud of all we accomplished during those years. We have celebrated many transformative wins over the past decade, including the Connecticut Domestic Worker Bill of Rights, and recently, the expansion of paid safe and sick leave law. Many workers still do not know their rights or how to enforce them. The Connecticut legislature passed an act concerning wage education and enforcement relating to domestic workers in 2021, establishing a funding program with the Connecticut Department of Labor to collaborate with community-based organizations to educate domestic workers and employers about their rights and responsibilities under the law. Through this partnership, organizations have provided on-the-ground outreach, assisting domestic workers in understanding their new rights and employers in understanding their new responsibilities, as well as supporting workers whose rights have been violated to assess remedies. This successful program is now in our 4th year with existing funding expiring in June 2025. We urge you to pass SB 1428 to continue and expand this existing program and strengthen our collaboration with the Connecticut Department of Labor in outreach and education, support investigation of right abuses, creating referrals to legal service, and broader enforcement to pay sick leave. We need our state to support all domestic workers across the Connecticut. We need those funds to continue educating and making difference in domestic workers' lives. Thank you so much.
Thank you for your testimony. I don't see, oh, we do.
I say thank you for waiting all day. I know you've been here since the beginning of the hearing, and most of your colleagues spoke much earlier, and I appreciate that you stayed in, delivered that testimony. And we had a lot of comments earlier in the day. I'm sure you heard them all, but we're pleased that you were here and able to stay for the day. Thank you.
Okay, thank you so much.
Thank you for your testimony. Up next, we have James Demetriadis. He's right there.
There we go. Sorry about that. Took a second for me to pop on up. Good. Can everyone hear me okay?
Yep.
Perfect. Good afternoon, members of the Labor and Public Employees Committee. My name is James Demetriadis, and I've been before you before. I'm an attorney at Ferguson, Doyle, and Chester. I work with Attorney O'Flynn, who testified earlier today. I'm here initially to speak on Senate Bill 1427, an act expanding paid family and medical leave insurance benefits to certain school employees. But I also can speak if any of the committee members have questions either about the cancer bill for firefighters or about the particular employee down in Stratford. I've been intimately involved in both of those cases and can expand on that. But with regards to paraprofessionals and non-certified staff, what Senate Bill 1427 would do would be to expand the Connecticut Paid Family Medical Leave Act to include those individuals. The average paraprofessional makes about $24 an hour, and their salaries range from $33,000 to $44,000 a year. And as somebody who has a family member that is a paraprofessional, my mother's been a paraprofessional for 18 years, I know and I see the work that paraprofessionals do every day. And in my job, I represent paraprofessionals every day. They've been excluded prior from the Connecticut Family Medical Leave Act, and it is really to their detriment. The average paraprofessional gets about 10 days of personal and sick leave. And if they have a family medical emergency, a personal medical emergency, or other qualifying condition, they're often taking weeks unpaid. And so the inclusion of the non-certified staff through the payroll deduction as set up for most private employees would be a huge benefit to this group of employees. These are underpaid employees. These are employees that are working really, really hard for mostly special education students and providing one-on-one support to the students who are the most vulnerable. And I think by expanding the act to include them, we would be showing them the same deference and respect that they deserve, and allowing them to take family time or sick time as needed so that they can take care of themselves or their families. This is a much needed addition, and I think it would help with the retention and recruitment of paraprofessionals. When I talk to paras, my mother included, I ask, why do you do it? And they say it's because of the work. It's because of the way that they can give back to the kids who need it most. And so I think this is an opportunity. This expansion of the act is an opportunity to give back to those who need it the most by allowing them to have the access to the sick time that they need. So I'm happy to answer any questions on that. I'm also happy to answer any questions on the cancer bill for the firefighters and the Stratford workers' compensation issue as well, because I'm intimately aware with all three.
Senator Kushner.
That's right.
Representative Hughes.
Thank you, Mr. Chair, and thank you for your comprehensive testimony. What do you say to the opponents of the para educators being included in the paid family medical leave that say it's too hard to replace them when they're out?
Well, I think that raises a really important point. If you are a paraprofessional and you are choosing to have a child or you have a family medical emergency, after 10 days, you're unpaid. They're going to have to leave their jobs because they're unpaid and try to get on to, they won't be able to continue their jobs. I think the issue is if you say to your employees, hey, you have access to a program that's going to give you 12 weeks of paid leave if you have a family emergency, they're going to stay in that job. They're going to know that that job values them and values their time. Right now, they're only paid for 10 days. And if a para chooses to have a child and they want to have time with their child, they are often taking the majority of that time unpaid. Unless they time it perfectly and it's over the summer. But most paraprofessionals are not eligible for unemployment benefits over the summer. So they are working other jobs over the summer to supplement their income. So I know that this is a staffing shortage area, but if people know that this is a benefit that they're entitled to and pay into, because that's how it works, they would be paying into it, that would ensure and enable better recruiting for the positions, because that if other positions in the private sector, a comparable position in a private sector would allow for 12 weeks of paid leave. So I think this actually makes the position more competitive with the private sector equivalents. And remember, we're talking $20.24 an hour on average for the paraprofessionals, $33,000 to $40,000 a year. So, you know, they could work in the private sector making similar wages and have access to these benefits. So I think it actually would help with recruitment.
Thank you for that. That is what I suspected, but wanted to hear from your perspective. Are there any other school employees that you think would be similarly, help with retention that this bill is looking to address, to include?
Yeah, I think all of your non-certified staff members are in a particularly vulnerable position because they do not hold the same certification as, say, a teacher or an administrator, and their wages are normally hourly. So I think any of your non-certified staff in the educational setting would absolutely benefit from this act.
Thank you. Thank you, Mr. Chair.
Representative Wilson.
Thank you again for that testimony. I just kind of want to piggyback on where Representative Hughes was going. About dealing with the retention piece and just the clarification that the employee they're paying the contribution towards this benefit, correct?
Correct.
And this is somewhat of a savings to a school district in the sense that during that time that an individual's out, say 8 to 10 weeks, they may be paying for a replacement cost, but the overall benefit, because these individuals are well under the threshold of as for a salary, the school district is kind of getting somewhat of a benefit on this, correct?
I would agree with that.
Thank you.
Thank you, Representative. Senator Kushner.
So I want to go back to the Stratford situation since you offered.
Sure.
I still am not clear on, and I don't know if there was anything, I had a hard time hearing the representative of Stratford. I think that it was somewhat muffled in terms of the microphone. And I'm not talking about you, Representative Shake. I'm saying the person who was testifying, the Director of Human Services. And I said that, like I was having a little bit of difficulty hearing it. It was kind of muffled. But I wanted to see if, in your opinion, there was anything that you could shed light on that he said that maybe we need to understand better, and particularly around whether it seemed to me what he was saying is that if a firefighter had chosen to go out on a disability, a workers' comp disability, permanent disability pension, that they would have had a better income. It was the choice that was made. Perhaps they thought they were going to get back to work and then found they couldn't, but the choice that went beyond a certain time period, so they were no longer eligible for that. I'm guessing they were no longer eligible for the disability pension and therefore had to just draw a regular pension from the city. Could you clarify that a little?
Sure. The fundamental issue, and I think the dispute between the parties here, is that the look back is for 104 weeks. Now, when somebody goes out on workers' compensation, the goal is always to be rehabilitated and be able to return to work. Firefighting is a unique profession insofar that there are very physical demands of that position. And so a year into an injury, somebody may not know whether or not they're going to be returning to work in the next 6 months. They may have a longer recovery period. And again, there's only 3 firefighters in the town of Stratford that this particularly has affected over the last decade, one of which received their full pension, and the other two now are being denied, and now they're looking back at the 2018 retirement to amend it. And here's the issue. When you are 1 year out after a catastrophic injury, you may need further surgeries that may have further recovery periods. And so you may not be at the place to say, am I going to be permanently disabled totally and permanently in the future? Maximum medical improvement can often take a year after the last surgical intervention to be reached. So if somebody is injured, let's say it's a shoulder injury, they do physical therapy, they do injections, they do conservative treatment for 8 months post-injury, and then they have the surgery. They won't know what their maximum medical improvement is until 1 year after that. So you're talking 18, 19 months post-injury, maybe 20 or 24 months. And if there's a second surgery needed, you're talking further than that. With the individual in Stratford, if they were to retire today, their benefit would be $16,000 a year, even though they are a 23-year employee of the town, because the look back is only for the last 104 weeks. So what in effect has happened is, even though they've paid into their pension for the entirety of their career, because they happen to get injured towards the sunset of their career, they are now left with, if they wanted to do a disability pension, having a greatly reduced rate, because the look back counts the workers' comp pay as goose eggs, as zeros, that they weren't working, so they didn't earn any income. So the entirety of the look back then is based off of other benefits that they may have banked or stored. And even if it's a disability in the line of duty, that member then would be only getting a pension, in this case, of $16,486, because their income for the last 104 weeks was strictly workers' comp, which doesn't count under the pension plan. And we think that's fundamentally unfair. We think that it's somebody who's paid into their pension fund for the entirety of their career, who happens to get injured at the sunset of their career, and then is unable to return to work after extensive treatment. It's not the onus on the employee shouldn't be, well, I'm only 1 year into my treatment, I guess I should throw in the towel and not want to come back to work. These employees want to come back to work, but the disability that they have or the treatment that they have prevent them from doing so. And I also caution is workers' compensation is not meant to be punitive. It's supposed to be restorative for the employee while they're out on leave. And I do think it's punitive for them to have to make a decision maybe 1 year into their recovery if they need to retire permanently when they're not permanently disabled yet, or they haven't reached maximum medical improvement yet. I don't know if that answers the question entirely, but
I want to make sure I understand. Is there a limit on when you, after the injury, when you can get a permanent disability pension?
So not on the amount of time after the injury. The permanent disability pension under Stratford's rules, and every town can be a little different, is if the injury arose out of the course of employment and has resulted in permanent disability from being unable to do the duties of firefighters. My point is, you may not know if they're permanently disabled until 18, 20, 22 months after the injury, depending on the extent of treatment that is necessary. I think everyone's goal is to go back to work. But if the injury has a 20-month recovery period, multiple surgeries, and the look back period is 104 weeks, you may not know you're permanently disabled and unable to be accommodated until week 120, and your look back is 104. So you've gotten a bunch of zeros on your record for the weeks prior.
So this is probably where I'm confused. I thought I heard him say that if they had taken a permanent disability pension, they would have gotten a pretty decent pension. But so please clarify, what was he referring to?
I think he's saying that at any point, the employee could have gone in and seen how the workers' compensation is affecting their numbers and chosen to apply earlier for the pension. They could have said, hey, listen, I think I'm not going to be able to come back to work. I think I'm permanently disabled. Even though I may have another 10 months of my treatment ahead of me, I want to put in my paperwork today. And then that would be the date that the look back would start from.
So they might not have suffered a loss of 18 months. They might have just suffered a loss of 2 months or 3 months as opposed to 18 months. That's still, though, it still doesn't answer the basic question is why are they suffering a loss at all? That's the part that's really hard to wrap your head around, because if you get injured on the job, I still don't get why we think it's okay that that worker should suffer some penalty. It is a penalty then in terms of your pension. That's the part I still have a hard time with. And I guess somebody, I think Representative Shake asked the question, and I don't think he knew the answer to it, but maybe it's better to ask you this, because I assume you represent not only, do you represent other fire departments besides Stratford?
Yeah, our firm is counsel to UPFFA, so we represent firefighters across the state.
And so is this a typical interpretation of how workers' comp would impact a pension benefit?
So it all goes back to the pension plan and how it's written. I believe in the state pension plan, it will include workers' compensation into the calculation. But every pension plan is different. The issue we run into here is it says the 104 weeks prior to the date of retirement. It doesn't say the 104 weeks last worked, which would solve the problem because then we would go before the workers' comp period. It says prior to the date of the application of retirement. So this pension language pigeonholes us, and we've tried, I mean, I have made overtures to try to negotiate this particular issue narrowly, and those have not been successful to date, which is why I think the union has been advocating to a legislative fix to this, because we think it is unduly punitive that somebody works their entire career and at the sunset of their career, they have an injury. They don't know if they're going to be able to return to work, and then they're being forced to make pension decisions without knowing, am I going to be able to go back to work? Because hypothetically, if you have a successful surgery and you're able to fully recover, you could go back and have another 10, 15 years of your career, hypothetically, but you're cutting it short.
I think that's essentially what the conclusion I came to at the end of his testimony was that it really doesn't, I don't think we should be inserting ourselves into the actual interpretation or the arbitration or the negotiations. I think that we as a committee, though, can say, and as a legislature can say, this shouldn't be up for discussion, because if you've worked for 20 years as firefighter in our state, you should be getting a pension, you shouldn't be penalized because you got injured on the job. That we shouldn't allow that kind of negotiations to go on. I mean, even if somebody said, well, even if the union said, I want that kind of penalty because you're going to give me something else that I really, really like and want. I mean, I just don't think that's forward thinking. And as a state, that's why we're looking at this as something that statutorily needs to be addressed. So, and that's more commentary than a question. So I apologize to the whole committee. But I really am thinking about it out loud, which sometimes we do. So, but thank you all.
Any further questions? Don't see any hands, so thank you for your testimony.
Thank you. Have a great rest of the evening, everyone.
Likewise. We're gonna go back. I see Jeff Sneller's on the call. Good to see you, Jeff, again.
Hello. So sorry I had to run out to a doctor's appointment. So thank you, members of the Labor and Public Employees Committee, and allowing me to speak today. I'm here to speak in support of HB 5609 and SB 1426. Specifically, I guess I'm just kind of like a little bit of the face with the skin cancer part. IARC, the International Agency on Research for Cancer, listed firefighting as a group 1 carcinogenic to humans themselves. We're getting more aggressive cancers at a younger age than the general population. And I know Mr. Tomczyk spoke about a little bit of the percentages, but we also are 32% greater chance with melanoma. My personal deal with it is I'm a 3-time cancer survivor. And my last one was in 2016, and that was skin cancer. I don't really hang out in the sun at all. If I do, then I'm wearing a shirt and a hat and sunscreen. And luckily, my wife, she had scheduled a dermatology appointment and couldn't go because I wouldn't never have gone to the dermatologist. So I happened to go in her place, so we didn't get charged a fee. And they actually found cancer on my back where my air pack strap sits. I've been a firefighter for 25 years in Manchester, and before that, I was a volunteer. So that spot, had I not gone, who knows what would have happened. Skin cancer is actually one of the many cancers that we're at risk for as a firefighter. So I just urge you to please support these changes, and thank you. Thank you for allowing me this time.
Thank you, Jeff. I had the pleasure of meeting you at an event that my cousins brought me to, and I got to hear from so many men and women who were, we packed the place up, but for the benefit of supporting you all. So thank you for allowing me that opportunity to speak with you and bringing people to me that are true believers and understanding of wanting to see the support for these funds. Any questions or comments? Representative Hughes.
Thank you, Mr. Chair. And thank you, Jeffrey, for your testimony. Did you or any of your colleagues have any direct experience with the paperwork and trying to get coverage for your treatment?
Yeah, unfortunately, my cancers were so long ago that I haven't had any experience. I do help out with an organization called the Cancer Awareness, the Firefighter Cancer Awareness Prevention Group. And everywhere I've talked to, I've run into folks that have not had a real easy time with this bill so far, although I am thankful that we at least have some presumptive coverage. But no, the short answer.
Thank you. And through you, Mr. Chair, did you hear an earlier testimony asking whether a navigator on staff with that maybe awareness fund or whatever that could help with the process of expediting these applications? Would that be helpful?
I'm sorry, is that question to me? Is that?
Yeah, just in terms of dealing with your colleagues.
Yes, I apologize. Yeah, I think a cancer navigator would be a perfect thing. And I see Dr. Candler's on here in a little bit, and she is way more knowledgeable at this, but a navigator would be a great help. Maybe also teamed along with somebody who knows the routine to get over these hurdles for the workers, the compensation.
Great. Thank you for your testimony. Appreciate you.
Representative Weir.
Jeff, thank you for your testimony. Manchester's a town right around the corner, and thank you for helping us on this topic. I have good friends with Battalion Chief, former Battalion Chief Huppy and Scott Porter, so I will let them know I saw you here, former coworkers.
Seeing no other, do you have some? You're good? Okay. Jeff, it's good to see you. Thank you for your testimony. Take care. Up next, we have Sarah Ganon.
Hello, everybody, members of my favorite committee. Good to be here, and good to be here while the sun is still shining. That doesn't always happen. My name is Sarah Ganong. I'm the state director of Connecticut Working Families Power. We're an independent political organization fighting for an economy that works for everybody and a democracy where every voice matters. And I'm here today for SB 831 and concerning advance notice of employees' work schedule. Also just want to appreciate for a moment the many workers who are here, both virtually and on in the room today, the domestic workers, warehouse workers, Amazon workers, and particularly the Hartford firefighters. As a Hartford resident, really just appreciate the work they all do as well, and here in solidarity with their bills and ideas. Regarding 831, for far too many workers in our state, rather than being a source of financial and schedule stability, their jobs are instead a source of stress, confusion, and instability due to unpredictable schedules. This anxiety and hardship is just simply unnecessary and can be addressed by the bill before us today. We've heard from many workers over the years in this room and others around the building about the huge challenges and obstacles of these unpredictable schedules. They cost workers money, from last-minute childcare needs to having to take an Uber to work rather than public transportation because your schedule shifts at the last minute and you can't get it on time. Workers are dealing with unpredictable income from week to week as hours can often change drastically. This makes it hard to balance classes, working a second or third job, attending medical appointments, and even time with family, such as a child's birthday party. Here in Connecticut right now, there's hundreds of thousands of hourly workers currently facing these conditions in retail, food service, hospitality, and long-term care industries that we're proposing covering. A national study found a few years ago that individuals with unstable work schedules were much more likely to face food insecurity, housing insecurity, fluctuating and unstable finances, and utility bill hardships. Thankfully, we actually have a really easy solution that's proposed in the bill. 831 follows the design of similar legislation, including in Seattle, Philadelphia, New York, and Chicago. The simple legislation would require notice periods for changes in shifts for workers in large companies in these four industries, with really small penalties for employers who don't comply. The legislation also reduces harmful practices such as clopenings and allows workers to understand an expected schedule before they accept a job. In addition to being good practice for workers, predictable schedules can help businesses as well. For example, a 2015 study from the retailer Gap demonstrated that pilot in several stores that there was actually significant increases in labor productivity and reduced staff turnover. The company found this schedule change so successful that they immediately implemented it in all of their stores nationwide. We know workers appreciate when you respect their lives and time, and thus stable scheduling is associated with reduced staff turnover and unhappiness. Workers become more productive as they gain experience and don't switch between jobs. Under this bill, workers and businesses still have the flexibility that they're going to need to operate. They can still choose to swap shifts if they want, and there's no restrictions around that. If they want to work more hours, they're able to make themselves more available, and their employers will be able to ask them to come in. Under current law, we see hourly workers are faced with really a one-sided contract. They have agreed to work for a wage, but their employer can unilaterally change how much work they have access to with no advance notice. This bill levels the playing field, setting a clear standard so workers know what to expect and how much they'll earn. Thank you again for your time and attention, and happy to take any questions.
Senator Kushner.
Thank you for being here tonight. And I know we have had this bill before and this conversation before, but earlier today there was testimony given that protested the inclusion of franchises. And I wonder if you could just take a few minutes to talk a little bit about how this would impact a worker in a franchise, and why that would apply to a franchise versus maybe somebody across the street who's a mom and pop deli.
Yeah, absolutely. Thanks for the question. The way the bill is written right now is, as you said, individuals who work for franchises of sort of the largest corporations, we're talking McDonald's, Dunkin' Donuts, kind of all those big name brand companies would be included in the bill, and the smaller mom and pops with the fewer employees are not included. And one of the reasons that is we know a lot of those large franchisees own several restaurants and several sort of chains, so are examples of larger businesses, even if each of their individual restaurants only employs a couple of people. And also a lot of those organizations, McDonald's, Dunkin', et cetera, have sort of different kinds of tools that they're already using at the corporate level that the franchisee has free or cheap access to in terms of scheduling employees, whether that's sort of just different kinds of software we've heard from in previous testimonies over the years and things like that.
Thank you for that clarification. And it's good to see you again.
Yes.
Representative Weir.
Thank you, Mr. Chair. Thank you for your testimony today. I heard you reference a couple pieces of data. One was on a company, I don't recall the name, that kind of voluntarily implemented these and was seeing success. And then you also referenced some data on the worker insecurity, food insecurity. Where was that reference from? The first one, I got the second one I understood. But
yeah, I believe I linked it in my written testimony. I don't have it in front of me, but happy to follow up via email afterwards if that works.
Yeah, if it's written, I can go.
Yes,
look for it.
absolutely.
I appreciate that. And then you also cited 4 cities that have implemented this in practice. Are there any other states that have implemented this outside of cities?
Not particularly in the way that this bill is written. But I think it is important to note that a lot of these cities are sort of equivalent in size to Connecticut, right? Like we're talking about Chicago has many more people than live in Connecticut and many more workers.
Thank you for that. One more question, Mr. Chair. Have you had experience in the restaurant industry or have personal experience in what we're talking about here?
Yeah, so I'm testifying on behalf of a lot of the members of our organization and individuals who have worked and advocated for this bill for many years, who have been speaking to us both here in this committee and sort of out when folks are organizing in restaurants, talking to members in the McDonald's and Dunkin' Donuts, and have shared both personal stories with our organization and other organizers over the years about how this would be important to them.
Thank you, Representative. Representative Hughes.
Thank you, Mr. Chair. And Sarah, can you just describe, is this a bill that's before us this year a little bit more narrow than the previous version that you've testified for? And how is that part of the feedback that you've gotten from your members?
Yeah, thanks. That's a great question. This bill is similar to what was before this committee in the last couple of years, but it has evolved over the course of, I think, the 7 or 8 years that the coalition has been kind of coming together and working on it. And one of the ways is both narrowing the scope of the types of industries covered and also sort of increasing the business size. So I think when the bill was first introduced, it was maybe businesses of like 15 or 20 employees, and that has moved up to 50 over time.
Thank you. And just one more question. In terms of the penalties, do you see that as being more for the employers unworkable for some of these smaller franchisees that were referenced earlier?
No, I don't think so. The intent of this bill is absolutely not to put anyone out of business. It's to make sure folks are complying in a way that works for both the business or franchisee owner and the employee.
Thank you. Thank you, Mr. Chair.
Thank you, Representative. I don't see any other hands there. Thank you for your testimony.
Thank you.
Up next, we have Taylor Beniers. Pardon if I did not pronounce that correctly. Okay.
Co-chairs Senator Kushner, Representative Sanchez, and the rest of the Labor and Public Employees Committee. My name is Taylor Biniars, and I am in Ellington. I stand in support of SB 831, an act concerning advance notice of an employee's work schedule to certain employees. This bill will help stabilize working families and those without by limiting on-call scheduling. I actually work in this field, politics, but without a degree, it is tough to find full-time employment, so I often search for jobs that happen to be on call during the off times. I once worked a job in the making and selling products in the manufacturing beverage service industry. When I worked there, I was given 2 types of schedules. I was either told my schedule at the beginning of the week, or I was told about the next day on the present day. Both of those schedules consistently changed. I was often either told I wasn't needed on said day or cut early into one day, but then was also called in on days that I wasn't scheduled. I felt like I couldn't say no because early on when I was asked to, and I stated in the group chat that I had plans, they were questioned harshly by a coworker, the owner's son. When I was told I didn't have to come in on the next day, I felt like I could not make plans or even just sleep in just in case I was called in, especially due to my close proximity. I drove to work and found out I wasn't needed many times. I was scared every time I had to leave early or come in late due to my therapy, which I always let them know about in advance. My mental health suffered greatly, and I had to call out sometimes because of it getting worse, causing my lack of sleep, even affecting my physical health as well. I received several overdraft fees due to automatic bills being taken out of my account due to some of my hours being shorter than expected, which coupled with the fact that I wasn't making a living wage made it worse. If I had to cancel a therapy appointment, I would have had a $75 fee. To put that in perspective, when I learned about this same hearing 6 years ago, I had a therapy appointment that day. And when I canceled it to go testify, I was within 1 hour of the fee. Honestly, I would have taken it 6 years ago because this bill is important to me and to the working people across this state. This bill would have helped me by being more financially consistent, but it also would have helped my mental health more by making me not suffer significantly. I do not have, nor do I want children, but I cannot imagine working an on-call job if I did. I strongly support SB 831. I hope this committee and Connecticut lawmakers will finally vote favorably this year to empower Connecticut's hourly workers by limiting abusive scheduling practices. I know I'm almost out of time, but I have my closing left. And for 6 years now, I have ended my testimony with the same statement. And I want all of those in opposition to hear me state this. To say that this will hurt businesses is not a just statement, because it will not hurt good businesses, because a business that cannot treat their employees with the respect and dignity they deserve is not a very good business anyway. Thank you for your time, and I welcome any questions.
Thank you, Taylor. See, Senator Kushner.
I really appreciate your testimony today. We did not get a lot of testimony today about the impact it has on workers in terms of the losses that you suffer when there's changes in your schedule. And you approached it, I think, a little differently than even some. We've heard a lot about workers who have arranged for childcare and then only to have their schedule change in workers who've had to pay for gas to get to work to only have their schedule change. And you added something new to that picture. We probably heard it before, but it's good to hear it again. And it was always good to see you. So thank you for testifying.
Thank you, Taylor, for your testimony. And up next, we have Dr. Christine Candler.
Hello, can everyone hear me?
We can, Dr. Candler.
So I wanted to thank Senator Kushner and Representative Sanchez and the members of the committee for allowing me to speak. I am a dermatologist who has been practicing in the New England area, primarily Massachusetts and New Hampshire, since 2008 when I finished my fellowship. I am board certified in dermatology, Mohs micrographic surgery, and I also at one point was board certified in internal medicine, and I have a master's in public health. I am here today to speak in support of Bill 1426, and one of the reasons why I'm here to speak about that bill is not only my medical background, but also the fact that my brother was a firefighter in Chelsea, Massachusetts, and he passed away of stage 4 esophageal cancer at age 37. This was a devastating loss for my family, and so since the year that he passed, I have been screening Massachusetts in the state of Massachusetts, but also across the country for skin cancers. I want to make it clear that one person every hour in our country, and this has nothing to do with firefighters, dies of a melanoma. Melanoma is a serious disease, and we lose people every day from it. The interesting thing about melanoma is for men, which the majority of firefighters are men, in America, the diagnosis of melanoma starts to increase at age 50, but it peaks at its highest rate at age 65. Some of the people that have come before me have mentioned that the NIOSH study has found that that firefighters have a 9% increased risk of cancer in general and a 14% higher likelihood that they're going to die of their cancer compared to non-firefighters. Our study in our country did not look at melanoma. The Nordic study did, and it was published also in 2014. The Nordic study with the firefighters found that firefighters were getting melanoma at an increased rate compared to non-firefighters ages 30 to 50, so that is decades earlier. The problem is that our U.S. preventative screening is made for the average American, and this is not our firefighters. Our firefighters go to work to keep our community safe. And while they're at work, they are exposed to occupational exposures such as carcinogens in no matter what is burning. The World Health Organization has documented that the occupation of firefighting is a group 1 carcinogen, which is the highest you can have. It basically states that all 5 mechanisms of making cancer are involved. You can't get any more than that. And they also state that lung cancer, bladder cancer are absolutely associated with firefighting, and that melanoma, non-Hodgkin's lymphoma, testicular cancer, prostate cancer, and colon cancer are associated. When we go further and we look at the World Trade Center data, the World Trade Center was a horrible disaster, but from a public health point of view, it allowed us to look at a lot of firefighters with a similar exposure and follow them longitudinally. That disaster, the 14-year follow-up data showed us that the firefighters that arrived on 9/11 and survived had a higher rate of melanoma than other firefighters. So that shows that melanoma is associated to a fire scene. But more than that, that study also showed that the firefighters that were located on the rubble on 9/11 had higher rates of melanoma compared to firefighters that were stationed streets away from the rubble pile. The interesting thing is that with melanoma, if we catch it early, the cure rate is 95 to 99% at 5 and 10 years. So there's no reason anyone should die of melanoma, whether they're a firefighter or not. If we screen these individuals early and frequently, we'll be able to capture melanomas and save lives. So I am here today to answer any questions about expanding this bill to include skin cancer, because firefighters are getting melanoma as they are getting other types of skin cancers as well, but melanoma is the one that kills.
Thank you. Representative Hughes.
Thank you, Doctor, for your testimony. I hadn't heard the just being at the scene of the firefighting makes sense of all the carcinogens burning, being exposed to that, not just the equipment that firefighters wear every day. Is there other ongoing research that we can also look to about the increased risk of melanoma, specific to firefighters' exposure?
Yeah, absolutely. And so I think that just to take a step back about the exposure itself. So the exposure is, yes, there is some exposure to the gear. We've all heard about PFAS being in the gear. But I think the other thing is that soot has documented carcinogens in it. The air quality has carcinogens in it. And when you're talking about the air, right now, while I'm talking with you, I'm eating air. I know it sounds disgusting, but air is going down into my vocal cords and then it distributes wherever it least path of least resistance, right? So it's the occupational exposures are being ingested, inhaled, and it's getting on the skin. So what the data has showed us is that if you take a firefighter and you put him in a firefighter-like setting and you study the absorption of the skin at the jaw and the angle of the neck here, the absorption rate goes up 50 to 100 times. And then in other parts of the body, in the groin area, the absorption of through the skin goes up 300 times. And so that's kind of bizarre, maybe because the skin is thinner in the groin area. But when you look at firefighters, scientists have looked at firefighters both before and after a fire, and they've looked at the blood and urine. And so what's been documented is that after a fire, the blood levels of PFAS, benzene, dioxin, all these carcinogens go from being low to elevated. The other thing that's happening is that the urine is going, the polyaromatic hydrocarbons, another documented carcinogen that's found in fires, is going from low to 3 to 5 times normal. And so when you think about that, that might be why firefighters are having an increased rate of bladder cancer, because these polyaromatic hydrocarbons are sitting in their bladder exposure after exposure after exposure. And reversely, or another thought is like with the testicular cancer and the prostate cancer, maybe the absorption of the groin area with the PFAS and the gear is what's causing those cancers. For the linking the melanoma to the scene, it's hard, right? Even with these, to prove the compound and then the outcome of the cancer, the exact break in the DNA, we don't even have that for some of the lymphomas that we know dioxin causes. But what we do know is that firefighters at the scene of 9/11 are documented with melanoma at a higher rate. And interestingly, there was a study that was done in Rhode Island of AARP retirees, and those folks were eating more fish and they had higher rates of melanoma. And so then there was this thought that, PFAS is in our food chain, and as we all know, it's in our water sources depending on where you live. So maybe there is this link between PFAS and the melanoma. We're just not sure yet, so I can't comment about that, but it's possible.
Thank you. And through you, Mr. Chair, one of the things that occurs with your testimony is in addition to looking at whether we can incorporate a cancer navigator, would you suggest more aggressive screenings for firefighters more than the annual basis and more, more aggressive in terms of melanoma and these other cancers that are unusual in younger people?
Absolutely. So I think the issue here is from a public health point of view, we don't want to screen everybody all the time because we're going to find incidental findings that aren't cancer and where that those procedures that you don't need cause harm and they cost money. So that's not a good idea. But clearly what we have here is a population that has cancer that's developing cancer at an earlier rate and it's more aggressive. So it's a public health nightmare in a way because we're not catching them soon enough. So firefighters should be considered a high-risk population, and we should take the data that we already have. If we know from the Nordic data that firefighters are getting melanoma and prostate cancer ages 30 to 50, we should start screening firefighters at age 30 or perhaps even 25 if we wanted to be a little bit aggressive for prostate cancer and melanoma. And to be quite frank, a blood test for PSA is very cheap. I mean, even if you were to pay full price for it, it's like $100, right? And a skin exam, what we've done in Massachusetts is we've provided free skin exams. And so we're trying to do that in Connecticut, but there's not enough doctors. But yes. And then colon cancer, as everybody knows, is a problem in our country. So that should probably start screening at maybe 40 or maybe even 35. Bladder cancer, that's an easy one too, quite frankly. All we need to do is collect a urine sample and look for blood in it. So that's not a high test option either. Lymphoma, non-Hodgkin's lymphoma usually happens about 3 years after an exposure. So that we're really going to need to rely on a CBC, which is a complete blood count, or the firefighters reports of being really fatigued or feeling like they have the flu that's just not ending. I think the bigger problem too is that medical doctors are not taught about occupational exposure. So we're trying, at least in Massachusetts, to teach doctors to ask. Doctors ask a lot of questions, but we don't ask about what you do. And it seems odd that at this point in time, when we can come up with personalized targeted cancer treatments, that we're not coming up with personalized targeted screening at an appropriate age, whether it be for a firefighter or a policeman or a construction worker or a petrochemical worker.
Thank you. That probably gave us more than we wanted, but we needed to hear all that, right?
Well,
Go ahead, doctor.
The other thing too is that the amount of money you're going to spend on screening, whether it be a health insurance or a municipality, is going to be much less than what these cancer diagnoses cost in the last year of life in an individual with stage 4 cancer, which, I mean, I knew my brother wasn't going to make it. I mean, it's just a better use of resources.
I think we have another job to do, don't we? Yeah. Representative Shake.
Thank you, Mr. Chairman. I guess almost good evening, Doctor. Thank you for being here with us and just going in depth with the research and the background that you have access to. What sparked my interest and concern were the rates significantly increased depending on where in the body the exposure is. So the groin area versus, you said, like adjacent to the ear and part of the neck. Have you found any research where if there is a link of any kind of exposure in the armpit area and an increased risk?
So there's not been anything documented regarding the armpits. In terms of absorption, I haven't seen anything on absorption data of chemicals. I haven't seen anything on melanoma in firefighters. Melanoma, ironically, in the ones that I've found tend to be on the back. I have found some on the neck and on the head as well. The interesting thing about the back is that there's a gap in the gear from where the pants are and the jacket is. So those vapors, the carcinogenic vapors, may be gaining access into that area, and then having the pack traps them in that area for maybe possible increased concentration and increased absorption. Specifically with the armpit, did you have did I answer your question?
You did. The reason I'm asking is because of endocrine related cancers. And if you had found in your research that there was increased exposure, whether it's the armpits you referred to earlier, the groin, the lymphatic, area that is right there internally, that is then also processing and then distributing whatever the chemical exposure is systemically throughout the body, just increases risk. And you quoted the 300% of an increase of exposure just to the groin area. So in men in particularly, whether it's the testicular cancer or the bladder cancer and in that region of the body, that was just a jarring statistic that you threw. So I just wanted to ask. And where I'm going with this is if there was something of exposure in your research, but you said that you hadn't seen anything in the armpit area, was breast cancer rates for women, which is a different topic, but you're just making me think about, in the level of exposure that the firefighters are exposed to, because we know that men also get breast cancer. It's not just women.
Absolutely. Absolutely. So all good points. So I'm going to take them sequentially, if that's okay. So number one, in general, it's been documented that firefighters, both male and female firefighters, have infertility problems. It's much harder for firefighters to conceive children, and they have a higher rate of birth defects compared to non-firefighters. A lot of that work was done by Sarah Jenke. And that probably has to do with a bunch of things. Number one, some of these carcinogens are what we call endocrine mimickers. And so they confuse our endocrine system, whether it be our reproductive system or even our thyroid. The other interesting thing that I didn't tell you earlier, because it wasn't relevant at the time, but that 9/11 14-year follow-up study, the firefighters that were on at the 9/11 scene at 9/11 that survived had a higher rate of thyroid cancer compared to firefighters that were not there. So whether it's a chemical in the or carcinogen in the blood that then is an endocrine mimicker and messes with either cancer in an endocrine organ, or the hormonal hormones that help with conception, or even this, being a firefighter is a stressful job. And you're getting woken up all night long. And so that can play with hormones and the restorative time that our bodies, when we sleep, are fixing things and getting rid of our abnormal cells or viruses and doing its normal job. I don't know as though it's necessarily linked to the armpit, but these chemicals are getting into the blood, and they do have effects on endocrine organs. The other comment that you brought up about breast cancer, definitely, one of the issues is that the majority of our firefighters are male, and so female firefighters are a minority. And so we don't, as you all know, in medicine, we need statistical power, which means we need a number of firefighters to follow before we can say, yes, this is right, and this is linked to that. And so when it comes to females and data in the firefighting area, we don't have as much data. The data that we do have is also through Sarah Jenke, but also through the National Academy of Science. And so the National Academy of Science wrote like a 300-page document. And in that document, it states that our firefighters should be getting PFAS levels. And I was shocked at this because I didn't know anything about this until I read that document. It also states in the state of New Hampshire that PFAS levels are mandatory. But I worked in New Hampshire as a physician, and I didn't know about that. So the reason why this is important is the firefighters are exposed to PFAS. PFAS blood levels, depending on what they are, there's recommendations from the National Academy of Science for certain screenings. So if your PFAS blood level is between 2 and 20, they recommend that you get breast cancer screenings. And that doesn't matter whether you're a man or a woman, because there have been firefighter male firefighters that have developed breast cancer. And it could be linked to that PFAS exposure. But more importantly, if you have a PFAS level, just to continue that, if you have a PFAS level that's greater than 22, then you're higher risk for testicular cancer, ulcerative colitis, and also infertility too. So if we could legislate that these levels could be tested by physicians using the data that our government has put out there, then we could ensure coverage through the insurance companies or mandate coverage because it was, recommended by our government that we screen firefighters, petrochemical workers, people that live near a infected known site with PFAS are all the people that have been listed in that document, which physicians don't know about.
Thank you so much. I feel like we just had like a full, course. And if we don't have a law like that in Connecticut, can't wait to work on that bill. Yep, let's start to do that and work with you in the Public Safety Committee where there's like multiple meetings happening today. One of the bills was regarding firefighters having a second set of gear, and it was around the issue of the PFAS exposure. And it's not, there's no absolute conclusion yet. And, I'm here, so I didn't hear the rest of the other testimony, but, the issue is public safety and it's also occupational safety, right? So, thank you for sharing that and for all the work that you are doing and your advocacy in trying to help educate and keep our workers safe. It's appreciated.
I don't see any other hands, but Dr. Candler, thank you so much. I feel like some of us will be in touch with you relatively soon.
Perfect.
Thank you again for that very necessary education.
My pleasure.
Take care.
You too.
Mr. Clerk, have we exhausted the list of participants for this meeting?
Correct.
Okay, well, I just want to thank everyone for coming. Motion to adjourn. Moved and seconded. Our next Labor and Public Employees Committee meeting will take place on Thursday, March 26th in room 2B at 10. March 6th. That's a long time from now. So March 6th in room 2B at 10 a.m. And our next meeting is on Tuesday, our next hearing is on Tuesday, March 11th in room 1.